yes होता है. Yes, properly. Yes, yes. So see, this is a marathon. I'm assuming that you have studied. So you are supposed to do the marathon with me. I'm not supposed to speak only. Okay? Obviously, it's a contract. Indian Contract Act deals with the contract. So can you tell me what exactly is a contract? Can you tell me what exactly is a contract? A contract is an agreement enforceable by law. What do I mean by enforceable by law? What do I mean by enforceable by law? Another thing, obviously it's a marathon, it will go at a particular pace. But let's say you don't understand, you're not very clear about some topic. You can ask me, I'll explain it in details. Okay? But otherwise, it's going to go at a particular pace. So tell me, what is enforceable by law? The aggrieved party has a right to go to the court against the other party. What is agreement? What is agreement? If in layman term, mutual understanding. But if I talk in law term, what is agreement? What is agreement? Every promise and every set of promises. So there's a set of promise or there's a single promise where my promise is your consideration and your promise is my consideration. So promise and set of promises which form consideration for each other. What is a promise? All of you can keep your books open. It should be open wherever it is, wherever you have written that. Keep it open. Keep saying with me. This is a marathon. Keep saying with me. You're not supposed to just sit there and listen. After 2 hours, we are done. After 3 hours, you don't want to sit anymore. Right? So tell me, what is a promise? A proposal when accepted becomes a promise. Just giving you a second. Take out the page where you have written all this because usi's order we will be going. Wherever you've written, is it there? Can you see it? Yes. Is it there for you? Yes. So what is a promise? A proposal when accepted becomes a promise. So tell me, can I say agreement is nothing but offer plus acceptance? Yes. And can I say offer plus acceptance plus enforceable by law is equal to contract? Yes. And agreement plus enforceable by law is equal to contract. But do you think only these 3 things are enough to make a contract? No. So what are the essentials? Tell me, what are the essentials given under section 10? No, that's not given in section 10. I said, what are the essentials given in section 10? When give me the essentials. I asked, what are the essentials given in section 10? Offer and acceptance, consideration, then capacity to contract, then free consent, then lawful object, then agreement not expressly declared void. Then tell me, what are the essentials, other essentials, not given under the Act, but are essentials? 2 parties, intention to create a legal relationship, then certainty and possibility of performance, and last concept, what? Legal formalities. Now, what are the different types of contract on the basis of validity? On the basis of validity, we have 5 types of contract. What? Void, voidable, valid, illegal, unenforceable. Please try to remember the heads under which the types of contracts fall. Okay? What is void? What is void? Not enforceable by law. If I put it in simple terms, you cannot sue me, I cannot sue you. Here we have a classification: void, agreement, and void contract. Can you tell me what is void agreement? It is void from the time it was made. What is void contract? It becomes void at a later stage. Under the Indian Contract Act, there are only 2 cases where the contract is what? Void. One is what? Supervening impossibility. Second is what? Contingent contract. Rest all is what? Void ab initio. So tell me, can you actually tell me all the cases where it is void ab initio? It's very important to know which is what. Because that is how you will actually come to your answers, your conclusions, right? Can you tell me what are the cases where it's void ab initio? First, minor, okay. What else? Sorry? Mistake, okay. But mistake to unilateral, bilateral, both are not void. What else? Illegal, okay. और बताओ, everyone can speak, please. Huh? What? Insolvency. Who said that? Insolvency. किसने बोला insolvency? ठीक है. That is disqualified by law. What else? That is voidable. It's not void. Undue influence, coercion, that is all voidable, not void. Okay. First of all, can I say when consideration is not present? Yes or no? Yes. When there is no consideration, the contract is what? Void ab initio. What is the second one? Can I say when there is no capacity to contract? That is minor. What else? What else? Minor, then unsound mind, and then disqualified by law. What is the next one? Bilateral mistake of fact. Bilateral mistake of fact. Then what is the next one? Mistake of foreign law. Mistake of kya? Foreign law. Then what is the next one? Unlawful object. Right? We have done that. Whenever we come to the respective topic, I'll tell you also. But at one place, we need all the heads so that I know which is void ab initio, which is void. Because each of the legal validity is different for each of the cases. Then what is the next one? Agreement, the meaning of which is uncertain. Right? Agreement, the meaning of which is uncertain. What is the next one? Agreement which is lawful in part and unlawful in part. And the last one, wager. I mean, in all the essentials I'm talking, wager. These are all the 8 cases where the contract is what? Void ab initio. In these 2 cases, only it is void. Rest all, whenever I use the word void, it is always void ab initio, right? Done? Can we move forward? Yes, now tell me what is voidable. What is voidable? Enforceable at the so anyway, what is voidable? Enforceable at the option of one of the parties, but not at the option of the other. Or that means one party can sue, but the other party cannot sue. Shravan, you had missed a lot of classes, right? Did you cover up all of them? All you have done? Okay. So it is basically the aggrieved party, if he wants, he can sue, but the other party cannot sue. Can you tell me the 3 cases where the contract is voidable? Under the Indian Contract Act, there are only 3 cases where the contract is voidable. Can you tell me what are the 3 cases? What is the first one? What is the first one? And ये तो बहुत important है to know where the contract is voidable, because they ask a lot of questions from this, and you should be aware that whether I can cancel or accept or I cannot do anything. That because otherwise, how will you be able to identify the legal validity of the contract then? So tell me, what are the 3 cases where the contract is voidable? First is what? Coercion, undue influence, fraud, and kya? Misrepresentation. These are the 4 cases where the contract is what? Voidable. What is the next one? What is the second one? No, illegal is never voidable. I mean, I want you to die. I hired Tarun to kill you. He wants you to die. Can we say, "Arey bhai, mar jao na? We want you to die." No, it's not voidable. Right? It's not even valid. Please don't say it's valid. So tell me, what will happen? What is the second case where the contract is voidable? Come on. Where? Effect of refusal to perform. Can I also call it as attempted performance? Yes. Don't worry. अगर किसी को ऐसा लग रहा, oh my God, I've never done this. Don't worry, you have done it. When I come to this topic, I'll explain again. Contract is voidable. And what is the second case? Where the or it is by breach, right? We can call it as the contract is what? Contract is voidable. The third one, ma'am, it is void, no? When I come to that, I'll explain how voidable and all, and then you can make a reference. The third one is what? When the time is of essence, right? When the time is of essence and you fail to perform within the time. Time of essence and fails to perform in time. In all of these cases, the contract is what? Contract is what? Voidable, right? Now, next tell me, what is, if you, वैसे अपने class में we had written this, if I'm not mistaken, but still whatever. If you have not, please do make a note of this. Now tell me, what is illegal? What is illegal? Void तो it is, but it is also punishable by law. अगर पकड़े गए तो चक्की pieces and pieces. What is the next one? What is the next one? Unenforceable. What is unenforceable? Substance is good, but there are some technical defects. Okay, can I make void valid? No. But can I make unenforceable valid? Yes, by removing the technical defects. It should be registered. I made an oral contract. Can I on a future date convert it into registered document and make it valid? Yes. I can on a future date convert it into a registered document and make it valid. Then what is the next one? Valid. What is valid? Enforceable at the option of both the, that means both the parties can sue each other. Then what was the next one? On the basis of formation, we have three types of contract. What is it? Express, implied, and e-contracts. What is express? By words. And when I say by words, can it be oral? Yes. Can it be written? Yes. What is implied? Implied means other than by words. And when I say other than by words, it can be what? By law or by actions. When it is by law, we call it as what? Quasi-contract. When it is by actions, we call it as what? Tacit contract. What is e-contracts? What is e-contracts? Contracts entered over the internet, right? Then what is the next one? On the basis of performance. What is unilateral, bilateral, executed, executory? What is executed? Already done. Can I say, if I say executed, can I say it is also discharge of contract? Correct or not? A has performed, B has performed. What happens? The contract comes to an end. It is what? Discharge. And how is it discharged? By actual performance. See, when two topics are connected and they look the same, if you don't make the connection, you will not know what to write in the exam. You will be like, ये topic ये है, and this is the, it looks similar, but how will I identify what's the difference? They are connected topics. They are the same. Is it clear to everyone? Yes? Now, if they give you A has performed his part, B has performed his part, what type of contract is it? Will you then write discharge of the contract? No. What will you write? Executed contract. But if they say A has performed his part, B has performed his part, what happens to the contract? Then what will you write? Discharge. So whether you're supposed to write what depends on what they are asking you in the question. Okay? What is unilateral? One-sided, as in before the contract is made, one has performed and the other will perform only after the contract is. That means when the contract is made, only one is left to perform. Can I say you taking admission, right, in the college? Unless you pay the fees, you're not allowed to enter the college. Yes. Can I say it's unilateral? Yes. Can I say sale on approval is unilateral? Soch ke bolo. Can I say sale on approval is unilateral? Can I say sale on approval is unilateral? No. So, let's say I want to sell this pen to you on approval. I give this pen to you. My performance is what? Give it the pen. I have given it to you. When is the contract made? When you accept it. So before acceptance, I have done my work or not? Yes. And after you accept it, only you are left to what? Pay. Can I call it as unilateral? Yes. Let's take another case. You are booking a ticket. Can I say this is unilateral? Yes, because unless you pay, your tickets will not be booked. Or let's see. Cash on order. Can I call it as unilateral contract? Yes. Because unless you pay the money, the order is not placed, right? Now tell me, what is bilateral? Both are yet to perform, right? वैसे ना, let me tell you, executory में ही they say executory can be classified as unilateral and bilateral. But you know the difference between the three, right? And executed we have already done. What is executed? Already performed, right? What is the difference? Void and voidable. What is the difference? Void and voidable. Void is not enforceable. Voidable is enforceable at the option of the aggrieved party. Correct? Or bolo? Can I say void may be void ab initio? Yes. But can I say voidable is never void ab initio, right? Void agreement is void ab initio, but is voidable ever void ab initio? No. Or bolo? Can you ratify a void agreement? No, void. How can you ratify? But can you ratify a voidable agreement? Yes. Void me, can you claim damages? No, but you are cheated. Can you claim damages? Yes. Is it clear to all of you? Yes. So now moving on, void and illegal. What is the difference between void and illegal? Void is not punishable. Illegal is punishable. Yes. Or below? Can I say every void is not illegal? But every illegal is what? Void. Every void is not illegal, but every illegal is what? Void. What else? Is illegal punishable बोल दिया. Can I say void may not be void ab initio? But can I say illegal is always void ab initio? Yes. And what is the effect on collateral transaction? What is the effect on collateral transaction? When the main contract is valid, the collateral is zero. When the main contract is void. Abhi, एक minute. Is void something against the law? No. Is void something against the law? No. So when the main contract is just void, it's not even punishable. Surrounding will be clean or not clean? Clean. So क्या होगा collateral? Collateral is what? Valid. But imagine the focal point itself is illegal. The main point is illegal. Do you think surrounding will be clean? No. They will also be tainted with illegality, and hence it is what? Void. Right? इसका एक question हम लोगों ने किया भी था, if you remember. अच्छा, I will be, obviously, as I told you, will be writing answers. So are you carrying your notebooks? Are you carrying your notebooks? Yes. So let's do this one first question. Can you see the question? Yes, I want you to write the answer to this. What will you write here? Social agreement. Chalo, okay. What we will do now, we'll not write the 3 paragraphs because second paragraph is just a copy of the question and it's just a waste of time. Whenever we are writing, we will mainly emphasize on the first and the conclusion. Okay? So I want you to write first paragraph and the conclusion. Okay? And be a little quick because we cannot waste too much of time. First question I want you to write. Uske baad I'll also start writing with you. I'll just walk around also. Have we done this question in the class? We had written this? Nahi na. If we have written some answer, pehle hi bol dena we have done it. We won't do that. Okay? Thinking what to write for the provision, because एक line के आगे कुछ नहीं है. Huh? Thinking what to write. Done with your provisions? Guys, done with your provisions? Yes? Done with your provisions or still doing? This kind of provision is actually very simple. And half of us would be thinking, ki, Are, kya likhu? Right? Radha invited her. Answer to you must have got, I'm pretty sure, right? Radha invited her 10 close friends to celebrate her 25th birthday on the 1st of Jan at 7:30 p.m. at a well-known hi-fi restaurant at Tonk Road, Jaipur. All invited friends accepted. Achha, I had put up a video of RTP discussion. Did you watch that? No. Okay. At Tonk Road, Jaipur, all invited friends accepted the invitation and promised to attend the said party. On request of the hotel manager, Radha deposited 5,000 as non-refundable security for the said party. On the scheduled date and time, 3 among 10 friends invited did not turn up for her birthday party and did not even convey any prior communication to her. Radha, enraged with the behavior of the 3 friends, wanted to sue them for loss incurred in the said party. Advice as per the provision. Can she sue them? How many of you got the answer as yes, she can sue them? No? How many of you got the answer as she cannot sue? थोड़ा सा hands थोड़ा ऊपर नीचे कर लेना, ठीक है? What would be the answer had it been a contributory? Then it's a legal relation, right? Then is she liable? Can she sue them? Yes. So what exactly will you write? We just in this case have to write about the whole social agreement thing, right? We just have to write about the social agreement thing. So what will you write here? What did you write, guys? Anyone will read their answer a little quickly? Anyone? First, only the first paragraph. Anyone? Come on. Come on. No one. Okay. As per, I hope by the end of the day you will not be like this and you will actually say, ma'am, I want to read the answer. As per the provisions, please, mat karna, huh? Please, examiner, fill in the blanks. Right, I am giving you some job to do other than marking. 1872, an agreement to become a contract or an agreement to be a contract must intend to क्या? Create a legal relationship. A social or a domestic agreement does not create any क्या? Any legal relationship. Hence, such agreements are क्या? Devoid of any legal remedies. Correct? Or are devoid of any legal enforceability or any legal obligation. खत्म, इतना ही लिखना है. You can one or two line if you want to add an agreement is a contract is an agreement enforceable by law. So to be enforceable, to become a contract, every agreement must be enforceable by law. You can write it. I'm giving you another way of writing. Right? What is the other way? How you can put it? A contract is an agreement enforceable by law. To become a contract, every agreement has to be enforceable by law. If it is not enforceable by law, it does not create any legal relationship. Social or domestic agreements are devoid of any legal relationship, and so they do not create any legal obligations. You can write it like this. This looks even better, but it's the same thing, right? So what was the other thing? As I said, a contract is an agreement enforceable by law. Why am I showing you two different answers? You cannot write, no one's answer can be word to word same. Content same hona chahiye. You should be talking about the same content, but it can never be the same. A contract is an agreement, what? Enforceable by law. So, an agreement to become a contract must create क्या? A legal relationship. If the agreement is not enforceable by law, it is devoid of any legal relationship. A social or a domestic agreement do not intend to create a legal relationship and hence are not enforceable by law. Chalo, done. So these are the two ways in which you can write the answer. Both are correct. Both are almost the same. Just the way of writing is different. Can I go to the next paragraph, guys? The last conclusion. Yes, please make sure you're writing with me so that at least you know दो चार answers लिखोगे then you'll realize कि कैसे लिखना है. Can I go forward? Can I just yes? So what was the question exactly? Let's look at the question. So the question says Radha, enraged with the behavior of the three friends, wanted to sue them for loss incurred in the said party. Advise as per. So can Radha sue them? No. So what will be your conclusion? Therefore, Radha cannot sue her friends. अच्छा, एक चीज और. Even though I always tell you conclusion can be one or two lines only. But in the conclusion also, write one line ka reason. Why? If any reason the examiner missed out upper mein what you have written, but he looks at the reason in your conclusion, he knows that you have not copied it, you have not written the answer on a whim, rather you actually know the justification. So it gives weightage to your answer. So don't just write, yes, therefore Radha cannot sue her friends. Other than that, what you should also write as invitation to her birthday party. As invitation to her kya? Birthday party was just a social agreement and did not create any legal relationship. Still, I would say answer conclusion will be one two lines only, but at least एक थोड़ा सा reason दे देना so that examiner नहीं पढ़ा ऊपर, he at least sees नीचे and he knows you have written it correctly. ठीक है? What would be your answer if it was a contributory party? In case it was a contributory party, it would be क्या? Enforceable. Hey, is it enforceable by law or not if it is a contributory party? Yes. It would be enforceable by law. And Radha can sue her friends. Chalo, samajh mein aaya sabko? Is it clear to everyone? Yes. So we are done with this answer. Can I move forward, guys? Can we move forward? Yes. अरे 2 marks का question आए, are you supposed to write in the same way? Yes, preferably. 2 marks है तो provision, you don't have to write too much provision. You can just write the provision in 2 lines, 3 lines, whatever. But still the format will be the same. Try to stick to this format even for the 2 marks because institute has given this format. Okay? So please try to stick to that. If due to shortage of time you're not able to do second paragraph, skip it. And in conclusion, give a little explanation. But please stick to this. There, the provisions will be a little lesser. Can I move forward? Yes. So now tell me, what is offer? Keep turning to the page where you have written the notes or where you have the, if you have written the notes, please keep them in front. If you are following the charts that is there at the end of our book, please follow the charts. If you are following them, keep them open. The keywords, everything is given there. It will be a little easier. Whatever is convenient, use that while you are studying. So what is offer? What is offer? Willingness to do or not to do something with a view of obtaining the other person's consent to such act or abstinence. So tell me, the person who makes the offer, what do I call that person? Offerer. The person to whom the offer is made, what do I call that person? Offeree. Now, what are the different types of offer? What are the different types of offer? General, special, cross, counter, standing. But what is special offer? Made to a definite person or group. Who can accept it? Only the person or group to whom it is made. What is general offer? To the public at large. Who can accept it? Anyone. And tell me, sometimes no, my act is an acceptance. So should I first call and say I'm going to accept, or my act itself results in acceptance? Act itself results in, like, for example, I put an ad, anyone who finds my lost puppy, and you go and search. So are you going to call me and say I'm going to search, or the act you have searched is an acceptance? The act of searching is an acceptance. What is cross offer? What is cross offer? Now, identical offers in ignorance. What is the result of cross offer? Both the offers will lapse, right? That means, can a contract come out of a cross offer? No. What is counter offer? Modification of the original offer. Can a contract come out of a counter offer? Yes. What is standing or open offer? What is standing or open offer? Which is open for acceptance over a period of time. Can a contract come out of this? I'm so sorry. What happens if you don't accept within the time? What happens if you don't accept within the time? Offer will lapse. Now, what are the rules of offer? Now, can you get a question on what are the rules of offer? Or explain the rules of offer? Yes, 7 marks. Will you just give the heading or explanation also? Explanation also. Tell me, do you need to learn the headings? Yes. Do you need to learn the explanation? Are you mad? Right? Are you mad? You really want to use that entire book and mug it up? Not possible. So are you going to learn the headings that? So you have to, otherwise कैसे लिखोगे? Are you supposed to learn the explanation? Huh? Gone. End of story. I will definitely write May 25 नहीं तो May 26 सही. Right? So can you ever, humanly possible for you to learn the explanation? No. तो कैसे याद करोगे? You will read it multiple times. You will write it in your own words. But ये याद करना है कि नहीं करना है? Yes. So what are the rules? Tell me. Must be definite, clear, and not vague. Must be made with a must and may. Be careful. Must be made with an intention to create a legal relationship. Then maybe what? Maybe expressed or implied. Maybe expressed or implied. Next. Sorry. Must be communicated. Then must be communicated. Then sorry. Must be communicated. Is related. There was a case, Lalman Shukla versus Gauridhar. Cannot be accepted in ignorance of the offer. Can it be conditional? Yes. But can it contain a condition that if you don't do this, it will be your acceptance? No. Must not contain. So if you don't reply within 10 days, I will deem you have accepted my offer. Is it a valid offer? No. Must be, cannot be accepted, must not contain any term, the non-compliance of which would amount to acceptance. Statement of price, statement of intention, invitation to offer is not an offer. Can you give me a few examples of invitation to offer? Price tags, what else? IPO, newspaper ads. But newspaper ads, there is one case where it's a, rather than only IPO, can I put it like issue of prospectus rather than IPO? Because even for the subsequent offers also, it is still what? You can, is it that only one time you make a public offer? No, it can be multiple times. So every time you issue a prospectus, it is what? Invitation to offer. Newspaper ads. There is one case where a newspaper ad is not an invitation to offer, it's an offer. What is that case? What is that case? When there is a prize money, lost and found. Achha, lost and found pay. Reduction. Prices reduced from 2,000 to 1,000 for men's shirt. Is it an offer? Reduction. Prices reduced from 2,000 to 1,000. Oh my God, I'm like, advertisement acha ho raha, seriously. Prices reduced from 2,000 to 1,000 on men's shirt. Come, buy. Is this also? Is this also? No. Why not? Sorry? So that means you are saying that this is an invitation to offer. That means, please, prize money. Just because I've stated the money is not prize money. Discount sale. This is what? Discount sale. And a discount sale is also what? Invitation to offer. Right? That is also invitation to offer. Next batao. Auction sale or kya hai? Self service shops, right? Price list. These are all considered as what? Invitation. So if you get a question on any of this, please understand, please remember, this is not an offer. What is it? Invitation to offer. Can I go forward? Yes. ये आंसर लिखेंगे नहीं. अच्छा, but ना invitation to offer का question में ना, what are we supposed to write? What? Let's say you get a question like this. Did we write invitation to offer का question in the class? नहीं लिखा ना हमने. चलो, you get a question like this. What exactly? How will you write it? Frame the first paragraph. चलो. Frame the first paragraph. Please utilize this marathons to the fullest. Go home and revise whatever you have done in the class that day. How will you write? Obviously, finished, guys. Done. हो गया सबका? You've written. Okay. Can I start? Yes. So basically, in this question, can I say I have to write about what? I have to write about what? Invitation to offer. Am I right? Okay. So, what will we write? As per the provisions of Indian Contract Act 1872, comma, an invitation to offer is not an offer. When a person makes an offer, the reply to it shall result in a kya? Contract. I did not even read the question. I'm so sorry. So basically the question is, Shambhu, they asked that self-service. Self-service is what? Invitation to offer. The cashier refuses to accept the price. Is the cashier right? Is the cashier right in refusing? Yes. So can Shambhu Dayal be compelled to sell the articles to Prakash? No. No. So why? Because it's just an invitation to offer. So it shall result into a contract. However, when a person makes an invitation to offer, however, when a person makes an kya? Please don't use however any place you like. However means it is a little away from the general rule, or it is opposite of the general rule. So it is used when we use locha. When we write locha, then we use it. Or when we write a rule and we are trying to say something opposite to the generally accepted principle, then we use however. However, when a person makes an invitation to offer, the reply to it shall not result in a contract, rather it is an offer. So, invitation to offer, can I say it precedes the offer? Yes, it precedes the offer. Correct? This is my provision. I will also make a reference to the case. It was held in the case. Actually, I would say I would send these files to you. Don't write. But the problem is no. My writing, so you won't be able to follow also. It was held in the case of, what was the name of the case? Anyone remembers? No. Pharmaceutical Society of Great Britain versus Cash Booths Chemist. What was held? That all self-service shops are. Okay, wait. How many of you thinking, oh my God, this is cheating, pure cheating. First day of the class, she told us, don't remember the case laws. And here she is, throwing away the cases on our face. How many of you thinking like that? No. If you don't remember the case, instead of writing like this, can we write price tags, price list, self-service shops, and few more examples are all invitation to offer. Can I write like that also? Yes. If you don't remember the case, after this explanation, what you can do is auction sale, issue of prospectus, the blah 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 blah. You can just write. Don't forget to write what the question is about. Self-service shops are all invitation to offer. समझ में आया सबको? Yes. Now, going back to the question, this so can Sambhu Dayal be compelled to sell the said articles to Srimati? So there, can I write like this? Therefore, I'm not writing the full answer. Can I say Shambhu Dayal cannot be compelled to sell the articles to whom? To Srimati Prakash as self-service is just an what? Invitation to offer. Clear all of you? Yes? Done? Can we move forward, guys? Yes? Can we move forward? Yes? हो गया? आपको पिक्चर भी लेने बोलूंगी बट माय राइटिंग माशाल्लाह सुभान अल्लाह you can say whatever. चलो, can we go forward, guys? Yes? अच्छा, anyone who wants to just make a note of this quickly? हाँ. Yeah. You can, even if you want, I can send these files across. But the only problem is, as I told you, first one to gaya. Should I save this file? I can save it actually. Huh? Should I save? I'm saving it. फिर भी I'll share it in the group. अगर किसी को help होगा तो you can just use it. ठीक है? Can I go forward? चलो, moving on to the next part now. बोलो जल्दी से. What is acceptance? What is acceptance? What is acceptance? When the person to whom the offer is made signifies his consent thereto. That means when the offeree signifies his consent thereto. Just like offer, we have rules for acceptance. Can you tell me what are the rules of acceptance? Must be unconditional. Must be, yeah. Must be communicated. Communicated to whom? To the. अच्छा, एक बात बताओ. When I say must be unconditional, can I say if it is conditional, it is a counter offer, right? If it is conditional, what is it? It is a counter offer. Is silence acceptance? How can we forget the hasi to fasi? Right? Is silence acceptance? No, mere silence is not acceptance. But can I give you acceptance by my conduct? Yes. By my acts. What type of contract is it? Tacit contract. When my act suggests the acceptance of the offer, what type of a contract is it? Tacit. इधर तक सबको समझ में आया? Yes. Now tell me, if I have not told you any mode for acceptance, can you accept it in any reasonable mode? Yes. But if I have given you a mode for acceptance, can you accept it in any reasonable mode, or it should be in my mode only? It should be as per my mode. So it must be in the prescribed mode. Achha, if it is not in the prescribed mode, is it a valid acceptance? No. But if it is not in the prescribed mode, but the other party accepts it, then is it a valid contract? Yes. If the other party accepts, it's valid. If within what time should we have the acceptance? Within the time given. And if there is no time given, it should be within a reason. What is reasonable? Depends. It is a question of fact. देखो, अगर question of law होता ना, अगर question of law होता, law would have defined. Law does not define. It's a question of fact. That means it's circumstantial. That means in every situation, we will individually identify what is considered as reasonable. Is it clear to everyone? Yes? Communication and revocation. So, when does, I don't know why communication of offer is not there. When does communication of offer take place? Only offer. When it comes to the knowledge of the person to whom it is made. But if I say for the offerer, when is it? When he posts it. When is it for the offeree? When he receives it, right? When he receives it, correct? Now tell me, if I just say communication of acceptance, when does communication of acceptance take place? When does communication of acceptance take place? When it comes to the knowledge of the person to whom it is made, right? When it comes to the knowledge of the person to whom it is made. Tell me, when I talk about communication of acceptance for the proposer, for the acceptor, when is it for the proposer? Always remember opposite. For the proposer, when the acceptor posts the letter. For the acceptor, when the letter reaches the proposer, right? So it is just the opposite. For the proposer, when the acceptor posts the letter. For the acceptor, when the letter reaches the proposer. Is it clear to all of you? Yes. Then next, can I revoke my offer? Yes. This is known as what? Revocation, rescission, whatever, however you put it. Okay? When does the communication of revocation take place? For me, if I'm revoking against you, for me, when I post it, for you, when you receive it. If you are revoking against me, for you, when you post it, for me, when I receive it. Simple, I post, done for me, you receive, done for you. So basically, when I say for the person who makes it, when is it for that person? When he posts it. And when it is for the person against whom it is made, when he receives it. Is there a time of revocation? Yes. So we'll just put it on a timeline here, guys. Let us say offer was posted here, offer was received here. Okay? Offer was posted here, offer was received here. Acceptance was posted here. Acceptance was received here. Can you tell me till what time can I revoke my offer? Till what time can I revoke my offer? Can I say once the acceptance letter is posted, offer cannot be revoked? Correct or not? Yes. But before the acceptance letter is posted, can I revoke my offer? Yes. See what's given. If the revocation letter reaches before the acceptance letter is posted. So can I say between this period offer can be revoked. But once the acceptance letter is posted, offer cannot be revoked. Am I right or not? Yes. Your timeline yaad rakhna. You will never get it wrong. On the other hand, till what time can the acceptance be revoked? They say if the revocation letter reaches before the acceptance letter reaches. That means, can I say I can revoke my acceptance between this period, but never afterwards? Yes. Once the acceptance letter reaches, acceptance is valid. What happens if we receive both the letters together? Revocation is absolute. Revocation is absolute. Is it clear to all of you? Yes. So, isme now there was this one question, quite interesting. This is clear to all of you? Yes. A made an offer to B to sell 250 chairs to B, offer to be open till, let's say, what is the date today, by the way? 1st April. Okay. Offer to be open till 10th April 2025. Okay. But on the 6th of April 2025, A made the offer to C. Now B wants to claim damages from A. Can B claim damages from A? Can B claim damages from A? Tell me. The offer is made for a time period, and within that time period, before the acceptance of the offer, if the offer is made to someone else, it is an automatic revocation of the previous offer. Right? It is an automatic revocation of the previous offer. We have done the same case in the class. It's an automatic revocation of the same offer. Can you claim the damages? No. Is it clear to all of you? Yes. We are done with this unit. Just a second, a moment. Anything you want to ask? Otherwise, we'll move to the next unit. So let's start with the next unit. What is the next unit about? Consideration. What is consideration? Technically known as what? Quid pro quo. What is quid pro quo? Not anything or everything in return, something in return. If consideration is missing, the contract is void ab. Remember, I had given you the list of what is void ab initio at the beginning. Yes, when consideration is missing, the contract is what? Void ab initio. Now, what exactly is consideration? When at the desire of the promiser, the promisee or any other person had done or abstained from doing, does or abstains from doing, or will do or abstain from doing, then each act or abstinence form consideration for each other. Acha, ek question hai idhar. Just going back to communication and revocation part once more. I make an offer to you by the telephone. You could not hear it. Or you make an acceptance over the telephone, I could not hear it. Is it still a valid communication? No. So even if it is made over the call, it should be heard by the other person. Can I also make an acceptance by actions? Yes. So whenever I talk about acceptance can be by act or it can also be by acceptance. Now coming back again to consideration, tell me what are the rules for consideration? First of all, it must move at the desire of the prompt. That means what? If I'm doing the work for you, but you never asked me to do the work, can I sue you to recover the consideration? I repeat again, I do the work for you, but you never asked me to do the work. Can I sue you for consideration? No. Why? Because you never asked me to do the work. On the other hand, you never asked me to do the work. I don't do the work. Can you sue me? No, because you never asked me to do the work. So the right to claim remuneration or consideration and the right to enforce the contract comes only when there is a what? Desire of the promiser. However, instead of the promisee, can someone else also perform the contract? Yes. And even if someone else performs the contract, it is valid or not? Yes. So consideration may move from the promisee or any other. And the whole idea is, well, let me tell you, consideration may, the whole idea is, let's say we both have made a contract. From my point, I am the promiser, you are the promisee. My desire should be there. And either you give me consideration or someone else will give me consideration. Vice versa, from your point of view, you are the promiser, I am the promisee. Your desire should be there. And instead of you, someone else will give me the consideration. Right? I mean, instead of me, someone else can give the consideration. What is executed? Executed. Act already done. Executory is what? An act yet to be done. Right? You have paid the fees to Yeshas. Already done. We are yet to complete your classes. Yet to be done. Maybe past, present, or future. What is present? Consideration. Something which is going on. What is future? Something which will be done. What is past? What? Already done. Oh, yeah. It is previous request and what? Subsequent promise. I ask you to do the work. And after the work is done, you promise to pay. I first ask you to do the work, and after the work is done, you promise to pay. This is what? Past consideration. Okay. Every contract must be supported by give and take, correct or not? Yes. But is it mandatory that give should be equal to take? No. So let's say you just got a 1,50,000 ka phone. After 2 months, you sell it off for only 50,000. Is it valid? Yes. There is no question of reasonability. It should be, there is no question of adequacy. Should be present. That is what we need. Okay? In every contract, in any contract, let's say I'm already, guys, I am teaching you law. That's enough. Marathon chahiye, paise do. Do you think it's justified to ask money for the marathons? No. Why? Because I'm already receiving a legal fee. It's my obligation. If I claim something extra, that extra is what? Void. Right? You promise, yeah, ma'am, don't worry. After the marathon is over, we will all pay you. Marathon over. No one is visible now. Can I sue you? No. Right? No. On the other hand, you pay the money. After you pay the money, I only disappear. Can you sue me to recover? No. No. Because it is void. But the mere liye no. Khud ke liye yes. Wow. Very nice. And the last one, consideration must not be what? Unlawful, illegal, or against public policy. समझ में आया सबको? Yes. What is privity of contract? Only the parties to the contract can sue and be sued. Third party cannot sue. लेकिन law में क्या होता है? लोचा. So there are cases where a third party can sue. Do you want me to explain these points in details? For example के साथ या just the basic चलेगा? हाँ? Basic चलेगा. Okay. Anyone wants me to explain any point? You'll tell me. I'll explain it. ठीक है? If you are appointed as a beneficiary of a trust, let's say a trust was created in your favor. That means you are going to get benefits out of the trust. So there is a contract between the person who has created the trust and the trustee. But you are the beneficiary. If you don't get the benefits, can you enforce the contract? Can you enforce the contract? Yes. Family or marriage settlements, a contract is made between two parties where a third party is a beneficiary of this. Like two brothers make a contract where they name their mother as a beneficiary. The contract is between who? The two brothers, Karan and Arjun, yaad hai? But who is the beneficiary of the contract? Ma, right? If she does not get the benefits, can she enforce? किसी को कुछ याद नहीं है, पढ़ा ही नहीं है, मैराथन में ना, मतलब मैं बताऊं क्या? So now tell me, can you enforce the contract? Yes. लेकिन ना इस केस में there is one point, the agreements have to be written to be enforceable by law. Assignment का मतलब क्या होता है? Transfer the rights. If the rights of a contract are transferred to a third party, can the third party enforce the contract? If the rights of the contract are transferred to the third party, can the third party enforce the contract? Yes. The next one is topple or acknowledgement of liability. If a third party acknowledges this, I'll put it in very simple terms. Abhi, you have ordered goods on Amazon. Contract is between who? You and Amazon, right? Blue Dart is going to deliver your goods. Can you go and sue Blue Dart, or you can only sue Amazon? Amazon. But Blue Dart sends you a message today morning. Our delivery partner is out for delivery. Please give this OTP. He's out for delivery since pata nahi when. Delivery is not coming. Now who will you sue? Blue Dart. Can you sue Blue Dart? Yes. Why? Because they acknowledge. Can you sue Amazon? Yes. But can you also sue Blue Dart? Yes. Because they acknowledge the liability. The last one, covenants running with the land. Let us say I purchase a land and the terms are subject to some conditions. Am I bound by those conditions? Yes. If I don't follow the conditions, whoever is benefited by these conditions, can he enforce the contract? Yes. Is it clear to all of you? Pakka? Yes. Can I move to the next one? Yes. So no consideration, no contract. Agreed or not? Yes. Because a contract without consideration is what? Void. A contract without consideration is what? Void. लेकिन लॉ में क्या होता है? लोचा. How many are there? पता है मैं तो ना when I have to learn something, no, apart from learning the topics, I also learn कितने points है so that I don't miss. How many points are there here? 7. पक्का. So what is the first one? Natural love and affection. Contract. Why is the contract made? Why is the contract made? Out of love and affection. It is made between whom? Parties who stand in a near relation. And it is what? Written and registered. It is a valid contract. But you know, isme if you remember the case of Rajlakhi versus Bhutna, the husband and wife were fighting. And so the husband says to his wife in writing that you stay away from me, I stay away from you, I will give you money. Is this enforceable by law? He got it written and registered also. Is this I repeat again, referring to quarrels between a Hindu husband and a wife. The husband gave in writing to his wife that he would pay her maintenance expenses and got it written and registered if they lived separately. Is it enforceable by law? Is it enforceable by law? How many of you yes? Yes? How many of you no? Why? Why? The first point was what? Love and affection. How did I start my question? Referring to quarrels. Do you see any love and affection? No. Is it enforceable by law? No. You're walking on the road, someone is, I was about to say someone is drowning. How can someone drown on the road? You are walking at the beach, someone is drowning. You save them. They promise you to pay. Can you recover that money? Yes. यो दूसरा पॉइंट पे आ चुके हैं. What love and affection? What love and affection? So the point is gone. So you are walking on the road. You अरे फिर से road. You are walking on the beach and you see a person drowning. You save him. Sir, you saved my life. You're like, रहने दे भाई. No, I want to give you 100 rupees. And I told you, don't think of throwing him back into the water. You are doing charity, guys. Can you recover that 100 rupees if he doesn't pay you? Can you sue him? Yes. Ma'am, seriously, 100 rupees ke liye, that's not the case. Can you sue him is the case. Can you sue him? Yes. When a person renders services voluntarily, services have already been rendered and the promiser promises to compensate. If these three conditions are fulfilled, it's a valid contract. What is the difference between this and past consideration? What is the difference between this and past consideration? That is voluntary. Here, the person is asking me to do the work. Whereas that is what? Voluntarily. Is it clear to all of you? Yes. Moving on to the next one, time barred debt. A time barred debt means what? It is legally unenforceable by law. But if a person gives a written promise to pay a time barred debt, it is a valid contract. Who can give the written promise? Either the debtor or his agent authorized by him. Clear all of you? Yes. Agency. Agency and bailment we will do in the last part also. Agency can or may not have consideration is valid. Bailment may be gratuitous or bailment can be for or without consideration. When we come to these topics, we will discuss it. Okay? Completed gifts. What is completed gifts? What is completed gifts? You are not just making a promise, you've already gifted. You're not just making a promise, you have given the gift. The gift is already made. Can you now recover the gift back? No, it's a valid contract. Charities and donations. Is it enforceable by law? Charities and donations, is it enforceable by law? No. But on the basis of the promise, if the other person has incurred any liability, can he recover it? Can he recover it? Yes. How much? To the extent of liabilities incurred. Clear all of you? Yes. So like jaldi se question that you tell me first, you tell me what answer you will write and then we will start writing it together. Okay? So how many of you say she will succeed? She'll succeed. How many of you say she'll not succeed? Huh? अब बाकी जो कुछ नहीं बोल रहा वो क्या बोल रहे हो? What will you write? What provision will you write here? Huh? Natural love and affection. So how will you start your answer? Tell me guys, how will you start your answer for this? As per sorry, पता ही नहीं था as per the provision. How will you start the answer? As per आगे बोलो. हाँ, Indian Contract Act 1872. आगे बोलो. How will you write it? Huh? Exactly. This is what I wanted to hear. Please understand, whenever the question is based on some locha, don't directly start with the locha. Preferably write. हाँ, ये 2 marks का है, then don't do all that. Then you just write the point. But if it is 3-4 marks, whenever the question is about a locha, start the question with the what? General rule. Then you write about the locha. So how will you write this answer? As per the provisions of whatever 1872. Okay? Every contract must be supported by consideration. Every contract must be supported by consideration. A contract without consideration is what? A contract without consideration is void ab initio. However, there are certain, okay, now if I say the word no, people will jump over me and say fine, fine, fine. However, there are certain, please exam में लोचास मत लिखना. In exam, what will you write? Okay, don't write locha. However, there are certain to this rule. In case of, you can, acha, tell me, can I start this from the next line? Yes. In fact, you know what? If there are multiple provisions, always start the second provision from the next paragraph. Gives a clarity to your answer. Examiner ko bhi pata chalta hai you have written the next provision here. Otherwise, handwriting, the one word goes into another word. That's like, very. In case of natural love and affection, the parties, in case of natural love and affection, first point, parties who stand in a near relation enter into a contract out of what? Love and affection, and the contract is written and registered. What will happen? The contract is valid. What will happen? The contract is valid. So, answer de dete, I don't even read the question after that. Let's get back to the question. Mr. Ramesh promised to pay 50,000 to his wife, Mrs. Lali, so that she can spend the sum on her 30th birthday. Mrs. Lali insisted her husband to make a written agreement, and the agreement was registered. Okay, this agreement was written, it was registered. Can we say it was made out of love and affection? Yes. Can I say it was made between parties who stand in a near relation? Yes. Sab kuch hai. Is the contract valid? Yes. Mrs. Ramesh, sorry, this will be Mr. Ramesh failed to pay the amount. Mrs. Lali wants to file a suit and recover. Referring, will she succeed? Will she succeed? Yes. Therefore, Mrs. Lali will succeed in recovering the amount from Mr. Ramesh as the contract is kya? Valid. Clear all of you? So this is done. So moving forward, after consideration, we have what? Capacity to contract. So when I talk about capacity to contract, can you tell me who is a person disqualified by law? Who is a person disqualified by law? Who is disqualified by law? No. Uh, no who has capacity to who does not have capacity to contract? Minor, unsound mind, and disqualified by law. And if capacity is missing, what happens to the contract? It is void. Void bole to void or void ab initio? Void ab initio. Now, what do I mean? So let's talk about who are persons disqualified by law. Who are persons disqualified by law? Someone said insolvent. Chalo, insolvent. Alien enemy. Or kaun hai? Now, convicted criminals. I cannot just say criminals. Must be a convicted criminal. Or kaun hai? Corporations. That is against their MOA and all. Companies against their MOA. Or foreign sovereigns or ambassadors. And company against its MOA. Acha, tell me, if company against its MOA, what do I call it? Ultra wires. What was the name of the case? This case everyone has to remember. What was the name of the case? अल्ट्रा वायर्स वाला केस का नाम बताओ. Ashbury Railway Company versus Ritchie. Have to remember the case. Now tell me, and if they make a contract, what will be the legal position of the contract? Can I say the contract is void? Yes. Now tell me, who is unsound mind? Who is unsound mind? A lunatic? Under the influence of drugs or alcohol? Huh? RCB fan? No, what we will say in contingent contract. No, wager. If RCB wins the match, I will give you 1 lakh, which is never happening. If RCB loses the match, you give me 1 lakh, which is definitely happening, right? But this is, can I call it as a wager also? No, because outcome is known. Outcome is known. It is very evident and obvious. इसमें doubt ही नहीं है. Now tell me, if a person has periods of sanity and insanity, if a person has periods of sanity and insanity, contracts during the periods of sanity is what? Contracts during the periods of sanity is what? Valid. Contracts during the periods of insanity is what? Void. That you have to prove. You are doubting my sanity. You have to prove I was insane. Okay? So minors. Now next one, minors agreement. Super number of points we have here. Right? Super number of points we have here. So let's discuss this. First of all, can I say an agreement with the minor is void? Yes. That means what? I cannot sue the minor. But a minor can be a beneficiary. That means, can the minor sue me? Yes. That means if I put both the points together, I cannot sue a minor, but a minor can sue me. Then what is the next one? What is the next one? A minor can always plead minor. So if a minor fraudulently enters into a contract and on a future date the contract is cancelled, can the minor prove that he is a minor? Yes. And if he proves his minority, what happens to the contract? The contract is discharged. Why? Because a contract with a minor is void. Right? Because a contract with a minor is what? Void. Then tell me, can the Minors Act be ratified? No. Minor ka matlab it is void ab initio. When something is, you remember when we were discussing difference of void, can it ever be ratified? No. So can he make fresh contracts? Yes. But can he ratify the contracts of minority? No. Then tell me, if the guardian contracts, what will be the legal position of the contract? If the guardian enters into a contract, what will be the legal position of the contract? Is it valid? No. Yes. If it is beneficial to the minor, it is valid. If it is not beneficial, is it valid? No. For example, when I talk about guardians, if the guardian makes a contract for movable property, is it valid? Yes. If the guardian makes a contract for immovable property ka purchase or sale, sale is valid? Yes. Purchase is valid? No. Law very clearly says any contract for the purchase of immovable property by the guardian on behalf of the minor is not valid. If the guardian is appointed by the court and he makes a contract with the sanction of the court, is it valid? Yes, because court ka sanction hai na, so obviously it is valid. Then tell me, if a person supplies necessaries to a minor, is the minor personally liable or only against his property? Only against. But for that, we have to prove that it was necessaries. Necessaries means what? The bare necessities of life. And we also have to prove that he was not in possession of them. That means he really needed the goods. Like for example, a minor already has 4 school bags. You still get him another one. Ma'am, school bag to necessaries hai na. I did not get a Louis Vuitton bag. Normal I got it. But still he already has 4 bags. Does he need another one? No. Is it necessaries? No. Clear to all of you? That means he must not be in possession of those goods. Right? Now tell me. So, can a minor be a partner of a firm? We'll look at the points so that we don't miss out and we go yahan pe jaise diya hua hai waise. So, my next question, can a minor be a partner of the firm? No. जो partnership पढ़ के बोल रहा है yes, चुल्लू भर पानी में डूब जाओ. Right? No. However, under section 30, he can be what? Beneficiary. Can he be a partner? No. He can be a can he be a member of a company? No, because when company offers shares, it's a contract. So can he be a beneficiary? No. But tell me, can he? I say he cannot be a sorry, he cannot be a member of a company. I'm so sorry. Can he be a member of a company? No. But can the shares be given to him by way of transfer or transmission? Yes, only if the shares are fully paid up. Correct? Only if the shares are fully paid up. Then tell me, can a minor be an agent? Yes. Why? Because for the act of the agent, principal is liable. He can hold others liable. Can he be the principal? No. Because how can he be liable? If the minor is a principal, what will happen? If the minor is a principal, what will happen? The agent is personally liable. What will happen? The agent is personally liable. Then tell me next one. Can a minor, contract of a minor, can it be specifically performed? That means a minor does not perform. Antique goods he had. He agrees to sell you. Later refuses. Normal case. I have some antique goods. I agree to sell you. Later I refuse. Can you sue me to sell that goods? Yes. What do we call it? Specific performance. Minor agrees to sell you some antique goods. Later refuses to sell. Can you sue the minor for specific performance? No. So no specific performance of a minor's agreement. Can a minor be declared insolvent? अरे भाई, insolvency कब होता है? When your liability is more than your asset. Is a minor ever liable? No. So can a minor be declared insolvent? No. सबको ही बोलोगे. Minor can be declared insolvent? No. अच्छा, now does the rule of estoppel apply on a minor? Estoppel का मतलब क्या? You cannot deny what you say. But when a minor says I'm a major, can he later go and say no, I am a minor? Yes, that means he can deny. That means what? He can deny. So tell me, does the rule of estoppel apply on a minor? No. Is a minor liable for tort? Tort is a civil wrong. If he's doing some cheating, is the minor liable? Yes. Just a word of caution. The way you people are giving me those expressions towards the end of the points, you're not clear. Go home, revise. Because इस पे से क्वेश्चन आया तब क्या करोगे? Go home and revise. समझ में आया? Yes. So tell me, can a minor be held liable for the torts? Is he liable for torts? Yes. Because see, here it is given. If the intention was of the minor was to cheat, he will have to compensate. But if the minor does not perform the contract, can I sue him? No. So a minor is liable for tort except for breach of contract. Can the minor be a joint promiser with others? Yes. But if a minor is a joint promiser, except him, all others are liable, right? That means if tomorrow there has to be made, some payment has to be made, he is not liable. Then tell me, if a person gives a surety on behalf of a minor, can I say the liability of the surety is what? Personal. Personal, right? That means what is personally. Otherwise, surety ka liability is what? Secondary and conditional. But here he is what? Personally. The last one. You remember parent Parker pen? Huh? Is your parent liable for what you do? Only if they have given you authority and you act as an agent for the parent. Is it clear to all of you? Yes? Minor का agreement done? ये question का सिर्फ answer दे दो. Will not write this, but इसका answer दे दो. And just tell me what you will write in this. You waste time. So is he liable or not liable? Liable or not liable? करने के बाद भी you're not able to answer, huh? Ayush was a minor, purchased 10 fancy coats for the wedding ceremony of his sister on credit from Messrs. कि भावा इसका शादी है या मतलब 10 किसका शादी है? It's his wedding or his sister's wedding. The cost of all the coats was 80,000. Not even a single coat was a necessity. Liable, not liable? No. When a person supplies necessaries to a minor, can you write his parents will be liable? No, they are not even talking about parents. And parents are liable only when they have given an authority. मेरे जैसा parent हो तो एक का भी authority नहीं देगा ऐसे, ठीक है? So not even a single court was a necessity. Liable or not liable? Liable or not liable? Not liable. So what will you write for provisions here? What will you write for provisions here? Can I start with a contract with a minor is void ab initio? Yes. And then can I talk about if a person supplies necessaries to a minor? The minor is not personally liable, but the liability is against his property. Necessaries means the bare necessities of life and things of which the minor is not already in possession. Right? हो गया provision. So, the question following the provisions of whether Ayush is liable to pay 80,000. Is Ayush liable to pay 80,000? No. Therefore, Ayush is not liable to pay 80,000 as none of it was a necessary. Clear? We are done with this capacity to contract. Can I move forward to the next topic? Yes? So, what is the next topic? Free consent. So when we talk about consent, what are the 5 things that are covered? Consent का मतलब क्या? Agree. This consent should not be free. This consent should be what? Free. When is the consent said to be not free? If the consent is, so that means not free matlab when there is a flaw in consent. Flaw matlab kya? Defect. When? Coercion, undue influence, fraud, misrepresentation, and mistake. See, coercion, undue influence, fraud, misrepresentation. This all is what? Voidable, right? Starting में लिखा था cases where contract is voidable. These are all voidable. Mistake का अलग अलग case है. Mistake का whatever it is we will do when we come to mistake. What is coercion? What is coercion? हाँ, गन पॉइंट. मुन्ना भाई को याद कर लेना. ठीक है, मुन्ना भाई को याद कर लेना. दैट इज इट. एंड हिज गन वाज टपका दूंगा. रिमेंबर, 5,000 पे दे, नहीं तो टपका दूंगा. करेक्ट, नहीं तो टपका दूंगा. दिस इज व्हाट कोएर्शन. Coercion is basically one party is threatening the other party to enter into a contract by an act which is a crime, or the unlawful detaining of the property of another. Tell me, the force is what? Physical force. And can it be by or on a third party? Yes. It can be by or on a third party. Undue influence. What is undue influence? Parties are in a relationship. When I talk about relationship can be what? Real or apparent or fiduciary. What is fiduciary? Relationship of trust. And can I say that whenever there is a relationship, there is a dominating position, correct or not? And just because there exists a dominating position, I can say undue influence. No. I am using it to make contract on terms which are what? Unreasonable. Now, when is it considered that the relationship is dominating? If in the contract there is a real or an apparent relation, or if in a contract there is a fiduciary relation, or if in a contract mental distress is there, or if in a contract the terms are in all of these cases I can say there is a dominating position. And I am using this position to force you to make a contract on terms which are unreasonable. The force is a mental or a moral force, and it can be only on the parties. Is it clear to everyone? Yes, it can be only on the parties. समझ में आया सबको? हाँ. I was 49%. And I want to do something good. I want to do something good. That is why, if you remember, I told you that in a company, no, because there would be a wrong on the minority, all the decisions cannot be taken by simple majority. And that is why they have special resolution. If you remember, I had taught you in 75% favor. Entrenchment clause when I was teaching you. So I had taught you this concept. Because what happens is, if one has 51, other has 49, or a group of people have 51 and they always dominate the minority. Now, usse kya hoga? The minority will never be able to take any decisions. So to avoid that, they have this special resolution where minimum 75% vote has to be in favor. Only then we can say the resolution is passed. No, parliament is 2/3 majority. That's different altogether. ये तो कंपनी की बात कर रहे हैं, सबके rules अपने अपने. ठीक है? Can I go forward, guys? Yes. What is fraud? वैसे fraud has been defined. ये fraud का question of fraud is actually very easy, interesting also. But जब इसके question आते हैं ना, we get a little confused about them. So please be careful about the questions of fraud. What are the 5 categories of fraud? What are the 5 categories under which fraud has been divided? First, the assertion of the fact which one believes what is false but makes the other person believe it is true. I know what is the fact, but I make you believe something else is the fact. Is it only making a wrong statement is fraud, or not saying something that you should say is also fraud? Not saying. So active concealment of fact, that is where you don't disclose the facts of the contract. Third bolo. Third kya hai? Where the contract is made without an intention to perform. Fourth bolo. Any act? Sorry? Any act fitted to deceive. Any act which is done with a motive to deceive. Ye open-ended point hai. See, I make a wrong statement. I don't say when I should say. I make a contract without an intention to perform. Fourth is when law says this is fraudulent. Abhi, what happened? No. Human mind, they will always find loopholes. So I will not look into the law. I will look into the loophole. So to avoid that, they added one more point. It can happen a situation looks like fraud but does not fall under any of the above head. In that case, lawmakers say if your motive is to cheat, then it will be considered as fraud. So any act done with a motive to cheat. So remember, it's very simple. Wrong statement, not saying something, contract made without an intention to perform. Law says fraud. And last, any act done with a motive to deceive. Not simple. These 5 things are what? Fraud. Now tell me, is silence fraud? Is silence fraud? No. Silence is not fraud. इसका नाम लिखो. लेकिन law में क्या होता है? Locha. So there are 2 cases where silence is what? Fraud. What are the 2 cases? Where it is my duty to speak. When it is the duty of the person keeping silent to speak. That means I normally don't have to speak, but there is a special situation which demands I should speak. In that special situation, if I'm silent, silence is what? Fraud. Or when my silence equals to speech. In these 2 cases, silence is what? Fraud. Is it clear to everyone? Yes. What is it when it is the duty of the person silent to speak? There are 5 specific cases to this. What are the cases? Immovable property. What was the second one? Insurance. What was the third one? Marriage. What is the fourth one? Family. And what is the fifth one? Issue of prospectus. You remember love at first sight? No? Abba, Dabba, Jabba. Ikram. Acha, Ikram ka tha na? Abba, Dabba, Jabba. So these are the 5 cases where silence is what? Silence is fraud. Is it clear to everyone? Yes? Moving on to the next one. What is misrepresentation? Always remember, what is the difference between fraud and misrepresentation? Fraud is intentional, whereas misrepresentation is unintentional. I know this is red. I tell you this is black. This is what? Fraud. I believe this is black. I tell you it is black. This is what? Misrepresentation. So see what's given. Assertion of the fact which is not true, though the person believes it to be true. That means I'm making a statement. I'm making a false statement. But because I believe that is the kya truth. Why am I making a false statement? Because I believe that is the truth. Next, देखो breach of duty without any intention to deceive gains an advantage. I am gaining advantage over you because of the wrong statement. But is it done intentionally? No. So it is done without any intention to cheat. Causing, however, innocently a party to make a mistake. Now, when I say this is black and you accept it because you also believe it's black because I told you, can we say you've made a mistake of the fact? Yes. But was it done knowingly or unintentionally? Unintentionally. What is the difference between fraud and misrepresentation? Intention and can I claim that? Can I cancel the contract in fraud? Can I cancel the contract in misrepresentation? Can I cancel the contract in fraud? Yes. Can I cancel the contract in misrepresentation? Yes. Because in all the four, coercion, undue influence, fraud, misrepresentation, in all the gone. In all the four, the contract is what? Voidable. In all the four, the contract is what? Voidable. Is it clear to all of you? Yes. In all the four, the contract is what? In all the four, the contract is voidable. Let me just open it again. In all the four, the contract is voidable. Can I cancel? Yes. Can I claim damages? Can I claim damages? In fraud, I can. In misrepresentation? Sure. Because it was not done with a motive to cheat. So in fraud, can I claim damages? Yes. But in misrepresentation, can I claim damages? No. So now tell me, what is the consequences of all the four? The contract is what? Voidable. Now, if one party uses fraud, but the other had means to discover the fraud by using his diligence, what will happen? Acha, tell me. Like this, so you will say, ma'am, in every contract, I can say you can use your diligence. No. If my question does not talk about diligence, it is fraud, it is voidable. But if the question suggests something which tells me I could have used my diligence, then it is what? Then it is voidable. Are you getting my point? So just because, so whenever you talk about this effect, always remember you will say it is voidable. I mean, normally it is fraud, it is voidable. But when my question says I had diligence, I could have used my diligence, then it is what? Valid. I think what is the motive of fraud? To make you induce you to contract, or just I say wrong statement, it is fraud. Induce you. I am using fraud over you, but you are not induced by my fraud. Will it be considered as fraud? Let's say I say a wrong statement. Okay. I gave you a wrong statement. And based on that statement, you contract. Is it fraud? Yes. Because you contracted based on that statement. I gave a wrong statement, but you never bothered because it was not important to you. Is it fraud? No. Fraud must induce you. I am just making a, I say, hey, you know what? This is black. It doesn't matter to you. It is black, it is red, it is white. You have to buy this pen. Right? You want to buy this pen irrespective of the color. Can I say this is fraud? No. Because that statement never induced. But I say this is black. You're like, oh, this is black, then I want black. Then is it fraud? Yes, because fraud must induce you to contract. Then only it is fraud. I am giving wrong statement. How is it fraud if it is not inducing you? Is it clear to everyone? Yes? Hello. Answer to this question. I know, wanted to write. I want you to write this answer. I want you to write this Mr. Samanpal answer. I will give you 5 minutes, read the question, figure out the provision, and then tell me, and then we will both write together. Tell me, what provisions will you write? Misrepresentation, ठीक है? but can be. If it is valid, how can it be voidable? If it is voidable, how can it be valid? Yeah, we did this in class, but still it's not correct. आपका आंसर अगर एक बात बताओ भावेश, if it is voidable, can it be void? If it is voidable, can it be valid? What did you say? It is. What did you say? It is valid, but it can be voidable. Or you said it can be voidable. If it is valid, how can it be voidable? You can say it is voidable and it can be accepted. तो समझ में आता है. आप बोल रहे हैं it is voidable. Wrong answer. Wrong answer. He can't? Why? Because he had to check what? He had to check what? There are few. Exactly. Okay, let's discuss this question. I want everyone's attention here. Mr. Samant owned a motor car. He approached Mr. Chotu and offered to sell his motor car. Ye sell hoga, by the way, for 3 lakh. Mr. Samant told Chotu that the car, so he had made a statement. What? That the car is running at kya? 30 kilometers per liter of petrol. Both the fuel, acha, if this line, let's forget this line for the time being. Let's leave this line. Because this line changes the answer in given situations. If this line was not given, he claimed, what did he claim? That the car was running at kya? 30 kilometers per liter of petrol, right? Mr. Chotu agreed with the proposal of Mr. Samant and took delivery of the car by paying 3 lakh to Mr. Samant. After 10 days, Chotu came back with the car and stated that the claim made by Samant regarding fuel was not correct. Okay, he made a statement which was not correct. Can this be fraud? Can this be misrepresentation? Nothing is very specifically given. It could be a fraud also. It could be correct or not. It could be fraud also. It could, because they have not said he made it on purpose or not. But if you look at the next line here, and therefore there was a, देखो छोटू खुद ही बोल रहा है, it is what? So we will not write about what? Fraud. We will only write about misrepresent. Or you can just write the consequences referring to the provision. So if in this case he is saying it's misrepresentation. See, the point is the car is running at 30 kilometers per liter and actually it was not a correct statement. Can I say the contract is voidable? Ignoring this line, can I say the contract is voidable? Yes, because it is what? Misrepresentation. But if I read this line, both the fuel meter and the speed meter of the car were working. That means, can I say Samant could have, Chotu could have seen the fuel meter, speed meter and realized what was the efficiency of the car, correct? Samant has done misrepresentation, but can I say even Chotu was negligent here? Yes. If you are negligent, the contract will be voidable or it will be valid. The contract will be valid. Is it clear to all of you? Yes. What will we write in the answer here? What will we write in the answer here? Sif misrepresentation we will write. Okay, what else? So obviously we'll start with as per the provisions of 1872. Okay? Dot dot mat likhna exam mein. Ma'am, actually people do. Ma'am, you wrote not dot dot. I also wrote dot. You forget the fact that I told you don't write dot dot. वो याद नहीं रहता है. Ma'am, you wrote dot dot. I wrote dot dot. Very good. Where a person makes a wrong representation. Where a person makes a wrong representation, believing it to be, thoda mere ko na, somehow I'm surprised about what I'm writing here. Can you see how beautiful my writing is coming? Hai na? I'm like shocked. What happened exactly? Yeah. So, believing it to be true The contract is, I'll not be happy because who knows the next line goes. The contract is kya? Induced by misrepresentation. When the contract is affected by misrepresentation, one thing you will see, every provision I go to the next slide, it's clean. Examiner can very well see my important provisions. When the contract is affected by misrepresentation, guys, 1 minute before we continue writing, did you understand why the answer is whatever the answer is? Are you sure? हाँ बोलो ना please. Exactly, and Chotu will also know, no? Oh, acha, you're saying it should be fraud. No, because यहाँ पे if this was not mentioned, no, then you could have said it's fraud. But because this is mentioned, no, that is why. Okay? Is it clear to everyone? Yes. Yes. I give you a, I give you some, maybe some movie or something. It can be played only 3 times, and it is showing it's already played once, and you can now only play it twice, like your classes, right? It is showing whenever you visit, you check, you will know it is already played once. Now only you can play twice. I say, don't worry, I have not watched. You can watch it 3 times. Is it fraud? To hey, what will happen to the contract? Let's say I give you a CD of a movie, it can be watched only 3 times. Once the 3 times you have watched, the movie gets corrupted, the CD gets corrupted. Okay? Just giving an example, samjho. You can never understand how many times the movie has been watched. I have already watched it once. I tell you, I have not watched it. You can watch it 3 times. Please take it. Fraud enough? Can you cancel the contract if you come to know? Yes or no? Yes. Abhi dekho, you will come to know only after you watch it twice. So can you cancel the contract? No. But can you claim damages for that one time? Yes. On the other hand, I give you a CD with a movie where you can actually see how many times it has been viewed. Okay? I tell you, 3 times you can view. Maximum once its 3 time use is done, it's corrupted. I tell you, I've not watched it. Take it. I have done fraud or not? Yes. But can I say you could have found out the truth? Yes. So I have done fraud, but isn't it your negligence also? Yes. Contract is what? Contract is what? Valid. Huh? Yes. Yes. यहाँ पे if this line was not given, was it ever possible for Chotu to identify what was the coverage or the efficiency of the card? No. If this line was not given, then I'm relying on you. Whatever efficiency you say, I believe that. But the moment they put this line, that means they are telling Chotu could have found out. Whose fault is it? Whose fault is it? Chotu. Can Chotu cancel the contract? No. नहीं अभी भी समझ में नहीं आया? हाँ? How many of you this question is next level बकवास एकदम कुछ समझ में नहीं आ रहा है? Is it clear? Nihar and Bhavesh, is it clear? Both of you got your like heads. Acha, everything is okay na? Haan. When the contract is affected by misrepresentation, the contract is what? Voidable at the option of the kya? Aggrieved party. However, if one party uses fraud or misrepresentation, but the other party, if he would have used his kya? Diligence would have come to know the facts, the contract is क्या होगा? Valid. The contract is what? Valid. Did you understand this provision, guys? The laptop on charge. हाँ. Did you understand this? यहाँ तक समझ में आया सबको? Yes. So let's just go to the question and see what the question is asking you. Referring to the provisions of the Indian Code, decide and write whether Chotu can rescind the contract. Rescind means what? Cancel. What do you think? He can cancel the contract? Can he cancel the contract? No. Therefore, Chotu cannot rescind the contract as the contract is valid. Since he had means to discover the contract is not affected. If you don't write this line also, even if you just write Chotu cannot rescind the contract as the contract is valid, it is still a valid answer. समझ में आया? Yes. हाँ.
Subject to a very unreasonable wages.
As in?
Let's say the mileage is they make a claim at 30, but that's only if you're on a highway.
नहीं, generally वही claim होता है. Even if you see, so and if you don't want, you feel you don't want a break, say 5 minutes break works, we can do that also instead of taking a 30 minutes break. And it's totally on you guys. जैसे आप लोग को ठीक लगे, we'll do that. ठीक है? Now mistake. Mistake can be mistake of fact or it can be mistake of a law. What is fact? Fact is basically what? Subject matter. What is mistake of fact? Fact is basically subject matter. Right? What is? So tell me, what is bilateral mistake? Can I say bi means both? Yes or no? Yes. What can I say? Bi means what? Both. Both the parties are mistaken. अच्छा एक बात बताओ. What type of mistake can I make about the subject matter? What type of mistakes can I make about the subject matter? Can it be about the identity, quantity, quality? कुछ भी हो सकता है. Quantity, quality, identity, could be anything, right? But so in case, let's say so I don't want you to write the answer because it's very chiller a question. But what will be the answer? Just tell me the answer, okay? I want everyone's attention here again. What is the answer, Bolo? What will happen is whether it is void, voidable, or valid. Void. Void ab initio or void contract. See, it is given what? Unaware. Both were unaware. Both matlab kya? Bilateral. That the elephant was dead a day before the agreement. मतलब contract बनने के पहले the elephant was dead. So is it void ab initio or is it void contract? Void ab initio. So what will you write here? What will be the provision in this case? What will you write about? Can I say you'll write about bilateral mistake? Correct or not? When both the parties to the contract are mistaken about the what? Subject matter. अच्छा एक बात बताओ. Mistake of subject matter could be identity, quantity, quality. Do you have to say which head or can you just write about mistake of fact? Just write about mistake of fact. You don't have to tell whether it is quantity, quality, identity. No. When you get a question for consensus ad idem, instead of writing consensus ad idem, what should you write? Bilateral mistake. I am talking about this camera. You are talking about this camera. Can I say there is no consensus ad idem? Yes. Can I say it's a bilateral mistake about the identity of the subject matter? Yes. So whenever you get a question like that, usme bhi provision should be what? Bilateral mistake. Is it clear to all of you? Yes. Now moving forward, if the mistake is unilateral, what happens? Please understand, silence is not fraud. This big case I want to tell you. You go to the shop, you see a necklace, you believe it's made of real diamonds. You purchase it. The shopkeeper knows you are mistaken. The shopkeeper knows you are mistaken. बताओ क्या होगा? Sure. Unless you ask. I am not liable to disclose. Silence is not fraud. So unilateral mistake, the contract is what? Valid. Unilateral mistake, the contract is what? Valid. Mistake of law. For everything we do, there is a law. For Indian law, it is said what? Ignorantia juris non excusat. That is, ignorance of the law of land is no excuse. What does it mean? Ignorance of the law of land is no excuse. So, being a part of the country, it is your duty to know the laws. You don't know the laws, no remedy, contract is valid. Ignorantia, ignorance, juris law of land, non-excusate, not an excuse. But tell me one thing, Indian law is a law. On the Indian soil, is foreign law considered as a law? No. On Indian soil, only Indian law is a law. Foreign law is not a law here. So that is considered as what? If you are mistaken about the foreign law, it is what? Mistake of fact. It's not law, it's mistake of fact. And the contract is what? Void. With this, we are done with mistake. Is it clear to all of you? Yes. Before I go to the next point, I'm just giving you 2 minutes. The next one is what? Lawful object. Now, when I say lawful object, what is lawful? For that, we understand what is unlawful. Everything other than that is what? Lawful. If it defeats the law. Now, when I say defeats the law, it is what? Defeats the law or the provisions of law. What is defeats the law? You directly go against the law. What is defeats the provisions of the law? You indirectly go against the law. What is fraudulent? When the agent acts outside his authority and the other party is aware of it. When the agent acts outside his authority and the other party is aware of it. What is injury to a person or his property? You make a contract which which leads to an injury. For 100 rupees, I'll work for you for 3 years, and if I don't, I will give you 100% rate of interest. That is what? Injury to a person or his property. There are laws which are society laws. If I make any contract which is against these laws, this is also what? Void. And the last one, agreement against public policy. And under this, we have how many heads? 10. We have 10 heads. The first one, trading with enemy. My country is at war with another country, and I make a contract with that person. Isn't it? I'm indirectly funding my enemy. Correct or not? It is what? Void. Can I also call it as illegal? Yes. Yes. Stifling prosecution. Stifle means to suppress. Prosecution means what? To punish. When you have committed an offense where imprisonment is mandatory, but instead of imprisoning you, they settle with a fine. You murder someone, no problem. Give fine, go enjoy money. Tomorrow come and kill money. Me only. Right? Can I say this is stifling prosecution? Yes. A person is caught smoking in a non-smoking zone and is fined for that. Is it stifling prosecution? No. Because the punishment there is fine or imprisonment. But when someone commits a murder, can I say imprisonment is mandatory? Yes. There, if you settle with a fine, is it valid? No. Then next, champerty or maintenance. In champerty, I am helping the other party to sue a third party. And whatever is the result of that case, we are sharing. In maintenance, just let me finish this 5 minutes. Then if you have any question, you can ask me. Okay? In maintenance, one party is helping the other party to sue a third party. But we are not sharing the result of the case. Right? Then the next one. What is the next one? Interference with the course. Achha, these are all valid or void. All of them are void. But let us say I have actually given a loan and the borrower is not, the debtor is not repaying, and you are helping me to recover that money. Then it is valid or void. Then it is valid. Why? Because I've actually given a loan. Then the next one is what? Interference with the course of justice. How does the court come to a decision? Can I say it is on the basis of the evidences or witnesses? Yes. When you tamper with these evidences or witnesses, it is what? Against public policy. The next one, sale of public offices. You are bribing to get a public post, to get a public title. It is what? Sale of public offices. Interest against obligation. Can I say this is kind of interrelated? Both are what? Bribing. But when you bribe for a public post or title, it is what? Sale of public offices. When you bribe for any other reason, I want a favor from you. No favors come free of cost, and I pay you money for that. This is not what? This is what? This is interest against obligation. The next one, marriage brokerage contract. I tell you, find a husband for me. I mean, I don't need, sorry. I will pay you money for that. Can I say it is against public policy and hence void? Yes. Is it also illegal? No. This is only void. But you know what? I go to a marriage bureau and I just ask for an information about a guy. Is this considered as void? No. I'm just asking for information. But when you are getting two people married, finding people for each other, that is my job. I'll find a husband for you, wife for you. Right? So I'm not doing all that. Don't come, please, ma'am, please. I'm looking for one. Huh? So that is what? That is void. The next one, agreement in restraint of marriage. Can I say every person has a right to get married? Yes. Any agreement which stops a person from getting married, can I say it is void? Yes. The next one, this is void. It is also illegal. Only void. The next one, where is it? Agreement in restraint of trade or for the creation of monopoly. Can I say every person has a right to carry a lawful trade? Hello. Now I can see that, okay, we are dead. Okay. Tell me, sit straight, all of you. Take a deep breath and tell me, can I say any agreement which stops a person from carrying a lawful trade is void? Yes or no? Hello. Huh? Oh, we are. Take a deep breath and please breathe it out also. Now, can I say every person has a right to carry a lawful trade? Yes. Any agreement which stops them from carrying a lawful trade is void. However, there are lochas under the Indian Contract Act and under the Partnership Act. And how will I decide is it valid or not? If it is reasonable, it is what? Valid. Acha, I sell the goodwill of artificial business to you. You tell me you cannot do artificial or real business, real jewelry business. Is it valid? I sell the goodwill of my artificial jewelry business to you. You tell me you cannot do artificial jewelry ka business. Valid or not valid? Valid. Because you have purchased the goodwill. And you say you cannot carry the business of real or artificial jewelry. Valid or not valid? Not valid. Because artificial you can stop me. How can you stop me from real? If I start that, can I do that? Yeah. Is it clear to all of you? Yes. The last one, agreement in restraint of legal proceeding. Can I stop a person from going to the court? No. Every person has a right to go to the court. Any agreement which stops a person from going to the court is what? Against public policy. Ajay, एक minute. This is void or is it or illegal? Void. If I stop a person from going to the court, is it valid? No, because I have a right. And if the agreement says you cannot go to the court, such an agreement is void. But tell me, in the agreement we say we will go only to this court and not to any other court. Valid or not valid? Yes, that is valid because here we are prohibiting, there we are only restricting. Is it clear to everyone? Yes. Last theme, so because that is agreement expressly declared void, and we'll be done with the essentials part. So tell me, when I say agreement expressly declared void, the first one is what? Agreement, the meaning of which is uncertain. Is it valid? No. Agreement, the meaning of which is uncertain is what? Void. But if there are means to ascertain the vague term, what will happen? The contract is valid. अच्छा, if a contract has two parts, one legal and other illegal, बोलो क्या होगा? If I can separate them, legal is valid, illegal is void. But if I cannot separate them, completely void. The next one, wager. What is a wager? Game of chance. I am set to win or lose. I will give you 100 if it rains, you give me 100 if it does not rain. It is what? Wager. Right? Wagers are valid or void. Wagers are valid or void? Void. But in the state law of Gujarat and Maharashtra also makes it what? Illegal. So with this, we are done. Tell me examples of those cases which looks like wager but is not a wager. Examples of contracts which looks like wager but is not a wager. Insurance. Lottery is a wager. It's punishable, yeah. Huh? Share market, chit fund company, mutual funds, huh? Game of skill, crosswords, puzzles, horse racing. These all look speculation. These all look like wager, but they are not wagers, right? They are not wagers. Is it clear? So, coming back again here, guys. Let's start with the next topic, next unit, performance of the contract. And this unit can actually be divided into two parts. The first part is all about performance of the contract, and the second part is, अच्छा, tell me, okay, let's do this question, okay? Tell me, which question will you do, this or this? Second one, कौन सा लिखोगे बोलो? First or the second one? First one, chalo, write the first one. Read the question. Can I say this question basically relates to, what does it relate to? Restraint of trade, right? We have to write about restraint of trade. What will you write? Should I just write or will you also write? Or you will write and then I will write? You will write, chalo, good. Can we go forward? Can we move forward? So what provision have you written here? Tell me. What did you write? Restraint of trade, so far correct. You basically have to talk about what? Huh. So how will I start? As per the provisions of, or can I also write according to the provisions of? Yes. Indian, don't write dot 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 dot. Okay, 1872. No, 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 no. Any agreement which stops a person from carrying any lawful trade is to that extent क्या void. यहाँ पे what has happened? Kashish had sold the what? Goodwill of his business. Kashish was running a business of artificial jewelry since long. He sold his business, man. You are saying he sold the goodwill. He never sold the goodwill. Are selling your business means what, guys? Selling the goodwill of your business, right? To Naman and promises not to carry on the business of artificial jewelry and real diamond jewelry in that area for a period of next 1 year. After 2 months, Kashish, okay, he sold his what? Artificial jewelry ka business. He is saying you cannot carry artificial or real diamonds ka jewelry. Can you stop him from carrying artificial jewelry ka business? Yes. Can you stop him from carrying real? No. Can you stop him from carrying the business of real jewelry? No. How can you stop him from carrying real jewelry ka business? So can you stop him from carrying the business of artificial jewelry? Yes. But can you stop him from carrying the business of real jewelry? No. So in that for a period of next 1 year, after 2 months, Kashish opened a showroom for real diamond jewelry. Naman filed a suit against Kashish for closing the business of real diamond jewelry business as it was against the agreement. Can you stop him? Now see, can I say this is valid? Yes. But can I say when you stop him from real jewelry ka business, this is void. It's not justified. See, understand if I have an artificial jewelry ka business and if I have real jewelry ka business, I am catering to two different class or section of people. And this class or section of people are not connected to each other. Those who buy real will not buy, and they don't have a connection. ऐसा नहीं है ये real भी ले लो ये artificial. So it's totally different. I have sold the goodwill of the real business. Can I sell the sorry artificial business? Can you stop me from carrying the business of real jewelry? No. This is what void. What Kashish did was he started real diamond ka business. Can you stop him? No. So whether Kashish is liable to close, is Kashish liable to close his business? No. So any lawful trade is to that extent void. However, the Indian Contract Act 1872 and the Partnership Act 1932. अच्छा यहाँ पे नहीं भी लिखा अगर Partnership Act, that's fine. But retirement of partner. अच्छा, tell me if they tell you about retirement of partner and they say can he carry a competing business? The agreement says he cannot carry a competing business. Is this valid? Is it valid? Now, you will write as per which act? If they tell you, write as per Partnership Act, can he carry the competing business? Then you will write as per retirement rules. If they say as per Indian Contract Act, can he write? Can he carry? You will write what? Indian Contract. Then you will write what? Restraint of trade. Okay? However, this lays down certain lochas. If the buyer of a goodwill restricts the seller from carrying a lawful business, if it is from carrying the similar business, sorry, from carrying a similar business, if it is reasonable, it is what? Valid. Correct? This is my provision. This is my provision. Therefore, Kashish need not close his business. कौन सा business? Of real jewelry as it was क्या? Void. Is it clear to everyone? Yes. This is my answer. I hope it's clear to all of you. Yes. Can I move forward, guys? Yes. So why don't you do one thing? Why don't you just try to write this answer at home? Just take a picture of this. You can try when you come tomorrow, you can try writing it and then get it. Acha, had we written this answer in the class? Ek second, huh? Just 1 second, 1 second. Had we written this Shrishti wala answer in the class? We nahi, solved nahi, written. एक बार देखो ना minors agreement, just go and check. I don't even remember. Had we written this? Had we written this? We had written this, क्या? We had written this. तब ठीक है, रहने दो तब फिर. I want you to write this Ayush wala example. ठीक है? Take a picture of this, please. I want you to write this answer at home. See, when I talk about performance of the contract note, I can actually divide the chapter, this unit, into two parts. First part is just the first part is all about the different concepts relating to performance. So you'll see we'll keep there are small topics. We'll keep moving around them, and the last part is discharge of the contract, which we already know is a huge topic in itself. Okay. So moving on to the first topic, performance of the contract. अच्छा इसमें दिया हुआ नहीं है. Just one second. I'll just check what all is there. Acha, it's not given. First of all, tell me, when I say performance of the contract, can I say performance may be actual or attempted? Correct or not? Yes. A has to deliver goods to B, B has to pay. He has to deliver, B has to pay. A has delivered, B has paid. Can I say this is actual performance? Yes or no? Yes. And when I say actual performance, can I also say this is what? Discharge of the contract. Once we have fulfilled both our obligations, the contract is what? Discharge. Can I also call it as executed contract? Yes, this is also known as what? Executed contract. What is attempted performance? A has to deliver goods to B, B has to pay. A is ready to deliver, but B refuses to accept. Correct? Can I call it as attempted performance? Yes, yes, this is what? Attempted performance. Now tell me, when I talk about performance, who can perform the contract? Who can perform the contract? When we talk about performance, who can perform the contract? Can I say parties can perform? Yes or no? Can I say promiser can perform? Yes. Who can perform? Promiser. Ma'am, why only promiser? Why not promisee? Because from my point of view, I'm the promiser, I should perform. From your point of view, you are the promiser, you should perform. So can I say promiser can perform? Yes. Let us say A has to deliver the goods to B, but the goods are with A's agent. Can he tell his agent that you please go and deliver the goods? Yes. That means, can I say who can perform? Agent can perform. Who can perform? Agent can perform. So who is the second one who can perform? Agent. So the first one is who can perform? Promiser. The second one is what? Agent. But tell me, contract is about singing. And I agree to sing. Then later I say, I cannot come, my agent will come and sing. Will you accept my agent? I say, I cannot teach, I cannot take marathon, my agent will come and take the marathon. Will you accept it? No. Right? So can I say when the contract is about personal skill, only promiser can perform? At different situations. A makes an offer to B. Before B accepts, A is dead. What happens to the contract? A makes an offer to B. Before B accepts, A is dead. What happens to the offer? Offer will lapse. Right? Offer will lapse. A makes an offer to B. B accepts it. Before the contract could be performed, A is swaha. What happens to the contract? Is the contract discharged or the legal heirs have to perform? Legal heirs have to perform. That means who can perform the contract? Legal heirs. But I have a question here. Tell me, you hire a painter to paint a picture for you. Before the painting is complete, paralysis ho gaya. Before the painting is complete, he is swaha. What happens to the contract? Can I ask the legal heirs to perform? No. Why? Personal skill. What happens to the contract? Void. That means, can I say generally agent and legal heirs can perform? But when the contract is about personal skills and confidence, who can perform? Only problem. Personal skill to samajh mein aaya. What is this confidence? The contract very clearly says only the parties will perform, third party will not perform. The contract very clearly says what? Only the parties will perform, third party will not. Now, can the third party perform? No. Right? Then it is what? Personal skill, and it's not personal skill, it is what? Confidence. Is it clear to all of you? Yes? Acha, on this, tell me the answer to this question. I think we have done this question if I'm not wrong. Well, no, doesn't matter. Okay. Can A receive certain goods from promising to pay 1 lakh? Later, A expressed his inability to make the payment. So, C, who is known to A, pays 60,000 to B on behalf of A. However, A was not aware of the payment. Now, B is intending to sue A for the amount. Can he sue him for 1 lakh rupees? Can he sue him for 1 lakh? No. Can I say payment by C is a valid payment? Yes. See, A does not know. Still, is it a valid payment? Yes. That means, can I say contract can be performed by a third party, right? One last case. Can I have a situation like this? A, B, C jointly promise to pay D 6,000. Can I have a case like this? A, B, C jointly promise to pay D 6,000. Can I have such a contract? Yes. That means, can I say joint promisers can perform, right? Who can perform? Joint promisers can perform. Now, let's talk about joint promisers. What is the liability of each of them? What is the liability of each of them? Equally. Are you sure? Because nothing is given. So how much is each of them liable? Equally. So how much is each of them liable? 2,000 each. How much is each of them liable? 2,000 each. Let us say, so I'm going to discuss the different situations. So now let's say after making the promise, B and C run away. Can A be held or compelled to pay the whole amount to D?
Yes.
Yes. That means, can I say they have a kya? The liability is what? Joint and severe. Correct? The liability is joint and severe. Achha, even if B and C are there, can D still compel A to pay the whole amount? Let's say B and C are there. Still, can D compel A to pay the whole amount? Yes. Yes. Anyone can be compelled. Now tell me, let's take another situation. A pays off the whole money to D. What will happen? Can he recover it from B and C? Yes. I was not supposed to pay. I had to pay only my share. I paid on your behalf. Can I recover? Yes. So if one of them pays on behalf of the others, can they also recover? Yes. They can recover the share from them. Now tell me, let's say if this person is unable to pay, why would a person be unable to pay? Insolvent. What will happen? Who will bear the loss? Others will bear the loss. That means now instead of 2,000, each of them is liable to pay how much? 3,000. He pays 500. Now what? Calculate. Oh my God, seriously. 2,750 each of them will pay. Hey Bhagwan. Now tell me, if let us say one of them is Swaha, what will happen then? The legal heirs of Swaha will perform with whom? With others. The legal heirs of all the Swahas will perform with whom? With the others. Is it clear to all of you? Yes? Last. If the promisee releases one of them, he releases one of the joint promiser from liability. Will he be liable to others? Will he be liable to others? Let's say B says, A, you don't have to pay me. I mean, you are released from your liability. Is it that the amount is reduced from 6,000 to 4,000? No. It's like the A does not have to pay. Now, who will pay? BC. Can BC recover from A the respective share of A? Yes. So, is he liable to the others? Yes. And are the others liable to the promisee? That is, are B and C liable to D? Yes, because he did not release ABC, he released only A. Is it clear to everyone? Did you understand each of the case? Yes. We are done with this. Can I move forward, guys? Yes. Can we move forward? Yes. Now, moving on to the next one. What is the difference between succession and assignment? What is the difference between succession and assignment? What is succession? Transfer of rights. What is assignment? Oh, sorry. I'm so sorry. What is succession? Inheritance. What is succession? Inheritance. What is assignment? Assignment is transfer of rights. So what I'll do is I'm saving this document with whatever I have written. So I'll upload the recent document again. So you'll get it with the marked things. Okay. So what is succession? Inheritance. What is assignment? Transfer of rights. Succession takes place how? Operation of law. Assignment takes place how? Either operation of law or express agreement. Acha, tell me, when the legal heirs get the property of the disease, the Swaha guy, do they only get the assets or also the liabilities? Both. Like, do we ask, hey, you are taking asset, you want liability? Do we ask or it's automatic? Automatic. They get both the assets and the liability. But tell me, in case the assets is, let's say, the assets is 10 lakh, liability is 15 lakh. The asset is only going to pay 10 lakh, 5 lakh is what? Extra. So should the legal heir personally pay that 5 lakh or not? No. So both assets and liabilities are inherited, but liability to the value of the assets. समझ में आया? So in this case also, if let us say A is Swaha, his legal heirs are liable to pay. But are they personally liable or to the assets? To the assets. Let us say his share was 2,000, but the legal heir only inherited up to the value of 1,000. How much will the legal heir pay? 1,000. Rest 1,000 who will bear? B and C. Is it clear to everyone? All ABC are Swaha. All ABC are Swaha. Can I compel A's legal heir to pay the whole amount? Can I compel A's legal heir to pay the whole amount? No. Legal, can I compel A to pay the whole amount? Yes. Can I compel the legal heirs? No. Legal heirs are only liable for their share. These are questions here. Whatever we are discussing, each of this is a question. Is it clear to all of you? Yes? Succession assignment, did you understand? Yes? Now, what is effect of refusal to perform? A is ready and willing to perform. अच्छा, ये जो ready and willing to perform है ना, when he is ready and willing to perform, first, his performance must be what? His performance must be what? This is known as offer to perform. Okay. Offer to perform is valid if it is what? Unconditional. Okay. I'll explain it. Proper time and क्या? Place. Okay. A delivers at the goods at night 2 o'clock. He said, what the hell? Does not accept. Is he wrong here? No. Has he committed a default? No. But if he makes the delivery in the afternoon at 2 o'clock, he said, what the hell? I sleep in the day, wake up at night. Can he do that? No. Then is it B is wrong? Yes. Is it clear to everyone? Yes. Now tell me, it was proper time and place. It was the performance of the whole obligation. What does this mean? You had to deliver me 1,000 kgs of goods. You only deliver 600 kgs. I'm like, I don't want to keep it. You give me whole. Can I reject it? Yes. So in that case, am I wrong? No. So when I say B refuses to accept, it should be the fault of B. If these conditions are fulfilled and B refuses, then it's fault of B. If these conditions are not fulfilled and B refuses, is it B's fault? No. समझ में आ रहा है? Should I explain it again? पक्का? Okay. Now the fourth case where the buyer has not examined the goods. Buyer has not examined the goods, must be given an opportunity to examine. So basically what they are saying is, what they are trying to say is, if all these conditions are fulfilled and still B refuses to accept, who is at fault? B. Can I say, no, if all these things are done and still B refuses to accept, whose fault? B. But if these cases are not present and B refuses, is he right in refusing? Yes. Now tell me, A delivers proper time, proper place as B wanted everything. Still B refuses to accept. Can I call B as the breaching party? Yes or no? Yes. And if B is the breaching party, can I call A the what? Aggrieved party. Is A under any obligation to deliver the goods again? No. But does he have any rights? Yes. He spent money for the carrier, he packed the goods, all these can I claim as damages? Yes. He has a right to claim what? Damages. Is it clear to all of you? Hello. समझ में आया? Can I also call this as attempted performance? Yes. That means, can I say attempted performance is also what? Effect of refusal to perform. समझ में आया सबको? In the notes, had we written this 4 conditions? नहीं? अगर कोई, I think 1 or 2 is missing. We have written. Now, time and place of performance. Tell me, if in a contract no time is given for performance, when should you perform the contract? Can I say reasonable time? Yes. If in a contract day is given but no time is given, can you perform again? Night 2 o'clock knocking. The person opens. Good morning, sir. Are you sleeping? Nah, I'm a nocturnal being. I wake up in the night, sleep in the day. I was waiting for you only. Arey, good, sir. I've come to deliver. Is it a valid delivery? No. No place is fixed. Duty of the promiser to ask the promisee to fix a reasonable place. If I have to perform on a particular day, but I will perform only when you ask me to perform, can I say it is your duty to ask me to perform the contract? Yes. Now, time for performance can be, this is another favorite type of question of the ICI. कितने बार उन्होंने पूछा इसको, ठीक है? Time for performance can be of essence or not of essence. If in the contract time is not of essence and you fail to perform within the time, the contract is what? Valid, but you can claim the damages. On the other hand, if the time is of essence and you fail to perform within the time, the contract is what? Voidable. Voidable का मतलब क्या? Can you cancel? Yes. Ma'am, time of essence, time of essence means if you don't perform within the time, it puts the other party at a loss. Not of essence means if you don't perform within time, the other party is not at a loss. If I ask a lady to sing live, time is of essence or not of essence? Of essence, because live show hai, right? But if I ask a lady to record a song, of essence or not of essence? Not of essence, because if not today, I can record it tomorrow also. If the time is of essence and I fail to perform, the contract is voidable. That means, can I cancel the contract? Yes. If I cancel the contract, can I also claim the damages? Yes, because it is said If a person rightfully cancels the contract, he can also claim the damages. On the other hand, can I accept the contract? Yes. And if I accept the contract, can I claim the damages? Yes, only if mentioned. Clear to all of you? Yes? Huh? Huh? Yeah. Is it clear to everyone? Hello. Is it clear to all of you? Yes. So if it is of essence and you fail to perform, the contract is voidable. ठीक है एक सेकेंड जस्ट वन सेकेंड क्वेश्चन नहीं है इसमें did we do that villain wala case a question अच्छा that I have given in the 30 days wala series I will not do that ठीक है I don't have that question in this marathon wala thing I'll just search for it and give it to you later ठीक है so tell me is it clear to all of you can I move forward yes can we move forward yes can I move forward yes appropriation of payment. What basically is appropriation of payment? The debtor has taken multiple debts from the same creditor and he just makes a part payment. Let us say the total debts was 20 lakh taken on different dates. One was let's say 5 lakh, one was let's say 2 lakh. Next bolo 5, 6, 7, 9 lakh. Kitna bacha?
64.
Thank God realization. So only you said actually. So now when he makes a payment of 20 lakh, can debtor specify which debt? So 20 lakh is the loan amount, sorry. Let's say he makes a payment of 3 lakh. Can he specify which debt to set off? Yes. Yes. Now when he specifies, this specification can be what? Express or implied. It can be what? Express or implied. When he specifies, can he specify yes? And if the creditor accepts the payment, the creditor must set off that debt only. So if the debtor says set off this, creditor is taking the payment, he has to set off this. If the debtor does not say anything, makes the payment on account generally means what? Against my account, take this money. Can the creditor decide and set off any debt? Yes. Can he even set off a time barred debt? Yes. But can he set off a disputed debt? Dispute means we both are arguing about something, amount, payment date, rate of interest, anything. Unless I settle the dispute, how can I set it off? If both the parties do not specify, then it will be what? First in order of time. And when I say first in order of time, can this also include, when I say first in order of time, can this also include a time barred debt? Yes. And let's say, so that means this 3 lakh will be set off against this 5 lakh, correct or not? Yes. Now tell me if there are more than one debt on the same day, 5 lakh, 2 lakh, same day. Is 3 lakh enough to pay the whole amount? No. What will be set off? In their proportion, in the ratio of 5:2. Is it clear to everyone? Same day, no? So in their proportion. Is it clear? Yes. I know we had, I'm pretty sure this question was done in the class. Look, don't look into the material, look the question from here. This is one of the, is topic say related one, like real nice question. The question says that T owes G the following debts as per the table. And these are the debts, right? And T makes a payment on the 1st of April, but he does not specify how to appropriate. So tell me, how will the check of 12,500 be appropriated? Mm-hmm. 12,500. How many of you say 12,500? How many of you say it will be adjusted against 5,000, 3,000? 5,000, 3,000. Okay. Why 12,500? Exactly. What did I tell you? It can be an express or an implied intimation. Here, He did not say anything expressly. But when the check amount represents a similar loan, it is equivalent to a loan. It is an implied intimation. I want you to set off this debt. समझ में आया? In this case, this 12,500 wala check will be used for what? For this. Now the remaining 4,000 will be set off in what proportion? 5:3. That means, can I say 2,500 and 1,500, right? It is how it will be set off. Is it clear to all of you? Yes, can we move forward, guys? Yes. Now moving on, can I move forward, all of you? Yes. So I want you to write this answer. Start writing, then I'll also write. I want you to write it first. So, Mr. S promises to Mr. M to paint a family picture for 20,000 and assures to complete his assignment by 15th March 23. Unfortunately, Mr. S died in a... Okay, so this is what he's going to paint. Unfortunately, Mr. S died in a road accident and his assignment remains undone. Can Mr. M bind the legal representative of S for the promise? No. Why? Personal skill. Suppose Mr. S had promised to deliver some photographs to Mr. M on 15th March against the payment of 10,000, but he dies before that day. Will his representatives be bound to deliver the photograph? Yes. So what do you exactly have to write here? What exactly you have to write? You have to write about the performance of the contract, correct or not? And you have to write about personal skill. And you have to write about, first write about death and incapacity, and then write about what? Personal skill. So, what will we write? As per the provisions of the Indian Contract Act 1872, the parties to the contract must perform the contract unless dispensed with. That means what? If a contract is made, the parties have to perform the contract unless I tell you, you don't have to perform. Right? Unless I tell you, you don't have to perform. If no If there is no contract to the contrary, or you can also write if no different intention appears. Okay, that means if the let's say if the contract says no, even if there is, in case of death the contract will be discharged, then will the legal heirs perform? No. So if there is no contract to the contrary, or if no different intention appears, no different intention appears, you can... Why am I writing so many things? If you write this also, it's correct. If you write this also, it's correct. I'm telling you different ways you can write it. Okay? In the contract must be performed by the promisor, or in case of his death or incapacity, by his representative or any other person appointed by the rep. Achha, if I don't write any other person appointed by the representative, is it okay? Yes. performed by the representative or any other person appointed by the representative to क्या perform the contract. However, if the contract is based on personal skill and confidence, only the promiser can perform. In case of death, the legal heirs have no obligation to perform, or the legal heirs cannot perform. Correct or not? Yes. Same here. I've just little added a little. Actually, whenever you're writing your answers, make sure full stops are there. You write complete sentences. Incomplete sentences से क्या होता है ना? Your answer does not look good then. And then it finishes off in this. तो कुछ तो content आप अच्छे से दोगे ना? Then only you will score marks. Otherwise, how will you score marks? So now, can Mr. M bind the legal representative of S? What will be the answer? Therefore, what will be the answer? Acha, instead of therefore, can I write thus? Can I write hence? Yes. It can be anything. Therefore, Mr. What is the question? Mr. M cannot bind the legal representatives of Mr. S as the contract is based on क्या? Personal skill. Correct? What would be your answer if in case the contract was to deliver photographs? It is not a see. अच्छा एक बात in this question in the second paragraph, okay, here I want to discuss a little bit about the second paragraph, guys. In this question, in the second paragraph, okay, will you be writing, I repeat again, in the second paragraph, will you be writing both the situations or you will only write the first situation? No, only the first situation. So how will you write? In the above case, Mr. S promises Mr. M to paint a family picture. However, before the painting could be complete, he is dead. Since the contract is based on personal skill, the contract cannot be performed by the legal heirs. This is it. Therefore, third paragraph, therefore, Mr. M cannot bind the legal representatives of S to perform. This is how you write if there are multiple questions. Now, suppose, now the second part you will write only in the conclusion. So it should be a little extra or not. Yes. In case the contract was to deliver photographs, it is not a contract of personal skill. In such a case, if the promiser is dead, his legal heirs must क्या perform. So, Mr. M can bind the, this is the question, can he bind? Is it that? Will that be bound? Okay. So the legal representatives of, please always answer. वैसे मैंने वो भी लिखा होता, it was correct. But they are asking, are the legal representatives bound? So please answer as per the question. So the legal representatives of Mr. S are bound to deliver the photographs. Did you understand this? Are you clear with it? Hello. Is everyone clear? Yes. Huh? I have a question. This, yes. So, reciprocal promises. So tell me, what exactly is reciprocal promises? Dependent. What do you mean by dependent promises? Hello. What do you mean by dependent promises? What do you mean by dependent promises? Performance of one kya depends upon the performance of the other. Now tell me, how do you fix the reciprocal promises? Can I say it can be fixed by the parties? Yes. What do you mean by the parties? The parties fix the order of performance. That means what? A says, you first perform, then I will perform. B accepts. Or B says, you first perform, then I will perform, and A accepts. This is what? Performance fixed by the parties. We have fixed the order of performance. Is it clear to all of you? Yes. On the other hand, Acha, tell me, when the order is fixed, can we perform in any other order or it should be in the order fixed only? In the order fixed. So performance has to be what? In the fixed order and not any other order. अच्छा अभी बताओ, can it also be fixed by implication? Yes. What is implication? I don't tell you who will perform first, who will perform later, but from the contract we imply who will perform first, who will perform later. If one party prevents the other from performing, I will build your house, but you say I will supply the timber and then only you build the house. You don't supply the timber. Am I liable to build the house? No. So can I say I have no obligation to perform? Yes. But can I claim damages from the other person? Yes, I can claim the damages. Is it clear to everyone? Yes, yes. Can I go forward? Restitution. What is restitution? If a contract is voidable and you cancel it, can you demand back whatever you have paid under the contract? I repeat again, if the contract is voidable and you have cancelled it, can you demand back whatever you have paid? Yes. This is what? Restitution. If the contract becomes void, can you claim whatever you have paid? Yes. Restitution. So let us say I took a theater on rent. Obviously, I have to pay some advance money. Before the show, the theater is burned down. Can I get the advance money back? Yes. Can I get the advance money back? Yes. Is it clear to all of you? Can I move forward to the next one? Hello. Yes. What is discharge of the contract? Discharge of the contract means what? Contract comes to an end. Parties are no further obligated to perform. There are 6 ways by which contract comes to an end. By performance can be actual or attempted. What is actual? We have performed the contract. What is attempted? One is ready but the other refuses to perform. We had done something like this in the beginning, attempted performance. Can I also call it as discharge of the contract by attempted performance? Am I right or not? Yes. Can I also call it as discharge of the contract by attempted performance? Tell me. Huh. The next one is what? By lapse of time. I don't even have to tell you. What is lapse of time? Best example. Time bar death. By lapse of time, the contract has become unenforceable. What is the next one? Huh? Operation of law. है ना? Yeah, the teacher bunking the class. So the next one is by what? Operation of law. Could be death, insolvency, merger. One contract merges into other. Death का मतलब क्या? Personal skill. Otherwise the legal heirs will perform. But अगर personal skill है, what happens? The contract is discharged. These provisions are overlapping. So one head may actually fall under what? Other head also. Is it clear to all of you? Good morning. Good morning. Nana, she's good night only. Taking her up, good night. Now, please understand, this is mutual consent. This is what? Mutual consent. Don't forget that. What is novation? Old contract is cancelled, new contract is made. What is rescission? Achha, when I say old contract is cancelled, new contract is made, does it happen between the same parties or is it with a third party? It can be between the same parties or it can be with the third party, right? Then next tell me rescission. What is rescission? Cancellation of the contract. What is alteration? Change in the terms of the contract. What is remission? I pay less in full settlement or I pay in kind. So I had to pay you 10,000, I pay you 9,000 in full settlement. Or instead of 10,000 cash, I give you 10,000 kind. Okay, in kind, but in goods. This is what? Remission. Can I say in alteration, the contract is actually not cancelled? Yes, just the terms are changed. What is the next one? Impossibility existing at the time of contract. Can I call it as void ab initio? Yes or no? Yes. Can I call it as pre-contractual impossibility? Yes. Can I call it as subsisting impossibility? Why subsisting impossibility? When the contract was made, it was impossible to perform. We have three cases known to both. Remember, star from the sky. Ah, Tare Zameen Par. Star from sky. What? Star from sky. If it was Harry Potter movie, he would have got for me. But it is not Harry Potter movie. Can he get it for me? No. Impossible to perform. And can I say we both know it's impossible to perform? Yes. Unknown to both. Horse Z. A wants to sell his horse to B. B agrees to purchase. Both A and B do not know that the horse is already dead. Where did we do this? Bilateral mistake. Okay. A knows his horse is dead. Still he tells B, I will sell you my horse. A knows his horse is dead. Still he tells B, I will sell you my horse. Voidable. Why? Because it is fraud. But along with fraud, can I say it is also impossible to perform? Yes. And because it is impossible to perform, it is what? Void. But because it is fraud, I have to give the damages. The next one, supervening. What is supervening impossibility? When the contract was made, it was valid. But before the contract could be performed, it becomes what? Void. Before the contract could be performed, it becomes what? Void. Can I call it as a void contract? Yes. Can I call it as a post contractual impossibility? Yes. Can I call it as subsequent impossibility? Why subsequent? After the contract is made, it is impossible to perform. Under the English law, it is known as what? Doctrine of frustration. Okay? Why? The contract is frustrated. Already covered all of these cases almost. Destruction of subject matter. You remember the theater which was given to the singer? Yes. I rent your theater. But before the show, the theater is burned down. Can I now perform the contract? No. Acha, ek cheez. Ye horse dead, do you remember bilateral mistake? Yes. I'm giving you another example. A says to B, I will sell you my horse, the ownership of which would pass to you after 10 days. Is it a valid contract? Yes. After 3 days, the horse is dead. What is the difference between this horse dead and that horse dead? There it was already dead. It was what? Void ab initio. Here it is dead later. It is what? Void contract. The next one, death of the promiser. Remember, painter. Yes. Extra वाला जो example था. Can I also call it as subsequent impossibility? Yes. Yes. Non-existence of a state of thing. Everyone remembers the fiance which turned lunatic at the scary house. Yes. You got engaged. Okay. Is it a valid contract? Yes. One day you took her to the scary house. Everything was good, but when she comes out, she is a gone case. Right? Now, are you required to marry her? No. Are you required to marry her? No. The state of thing for which the contract was made does not exist. The next, outbreak of war. An Indian makes a contract with, okay, some other country. Okay? I won't mention any country online. So the contract is made. Is it a valid contract? Yes. But before the contract could be performed, there is a war. Can you now perform the contract? No. No. Acha, what is the difference between this and trading with enemy?
This one is after the contract.
This, after the contract is made, there is a war. There, war was already existing when the contract was made. Is it clear to all of you? Change in law. I tell you, I want to sell this pen to you, you agree to purchase. Before I could sell you, there is a new law saying selling of this pen is illegal. Can I now sell this pen to you? No. Change in law. Subsequent impossibility. Acha, tell me, in these cases, can I claim damages from the other person? No, because it is not in our control. अरे भाई वो स्वाहा हो गया. All these 5 cases. None of the cases are in our hands. But can I claim a refund of the money that I have paid? Yes, restitution will apply. Again, let's say let's say you hire a painter to paint a picture for you. You paid him advance. He is Swaha. Can you ask his legal heirs to pay back the advance? Yes. No, advance to paisa. You paid me advance for this pen. I couldn't sell you. Now, can you ask for the refund of the advance money? Yeah, because it's not my fault, but it's not even your fault. No. But can you claim damages from me? No. Refund means, let's say I say I'll sell you this pen for 10,000. You gave me an advance of 3,000. I couldn't sell the pen. I mean, it becomes illegal. Can you claim the 3,000 back? Yes. But can you claim damages over that? No, because damages किस basis पे claim करोगे? It was not my fault I did not sell you, right? It was because beyond our control. So can you ask for the refund of the 3,000? Yes. But can you claim damages? No. Can I move forward, guys? Yes. Breach. What is breach? Non-fulfillment of the terms of the contract. Where one party refuses to perform, we call it as a breach. Okay, so on this, tell me, can I say attempted performance? Can I say attempted performance is also breach of contract? Yes or no? Yes. Every time we do a topic, you should be able to connect. Make a note of it. You should be able to connect. These topics are interrelated. नहीं तो एग्जाम के पहले लगेगा अरे ये तो उधर ऐसा था ना. It looks like the same. Why is it not the same? You should be very clear about it. Is it clear to all of you? Yes. So now moving forward. So let's talk about breach. What is breach? Non-fulfillment of the terms of the contract. Let us say the contract has to be performed on the 15th. On the 10th, I come to know the other party will not perform. Can I call it as anticipatory breach? Yes. So what is anticipatory breach? When before the due date, I come to know the other party will not perform. I have 2 options. I can cancel the contract on that very day, or I can wait till the due date. If I cancel the contract on that very day, fine. If I wait till the due date, now if on the due date the other party performs, am I bound to accept? Yes. Other party does not perform, it's actual breach. What is actual breach? on the date of performance or on the due date. That means if on the 15th I tell you I will not perform, it is what? Actual breach. अच्छा एक बात बताओ. If one day performance is there, it's on the due date. But like for example, you take classes at Yeshas. Can I say it's over a period of time? Yes. So if in between we stop the classes, you don't pay, whatever. Is it on the due date or during the course of performance? So actual can be on the due date or during the course of performance. On this day, will you wait for some other day? No. Due date aa gaya. Now what date will you wait? You will cancel the contract or not? Yes. And when you cancel the contract, will you claim the damages? Yes. Is it clear to everyone? Yes. Before I move forward, I'm just giving you 2 minutes. आप लोग एक बार देख लो इसको, and then we will move forward. ठीक है? Now, moving on to the next part. If there is a breach, will I have some remedies or not? Yes. Remedies can be classified under two heads basically. First is the kya? Monetary rights, and the second is the other rights. When I say monetary rights, that is damages. We have obviously got different types of damages. Before that, what are the rules of damages? First, any damage which arose naturally can be claimed as a matter of right. What is the second one? Special damage can be claimed only if there is a notice of the special loss. Third, remote damages can never be claimed. Fourth, any damage under a quasi contract can be claimed. What is ordinary damage? The fact that I made a contract with you and the fact the contract was cancelled gives me a right to claim the damages. Right? Can I claim it even if it is not mentioned in the contract? Yes. Generally, damages are calculated how? Market price less contract price. Generally, how is damages calculated? Market price less contract price. What is special damage? Can you claim it as a right? No. It is not your right to claim special damage. So when can you claim the special damage? In case if there is a notice. What is nominal damage? When you have not suffered any damage, a damage as less as 1 rupee is awarded. This is known as what? Nominal damage. What is the next one? Vindictive or exemplary damages. These damages are basically punitive in nature and hence they are awarded only under special situation. Right? Which two cases? Wrongful dishonor of a customer's check and breach of contract of marriage. Can I say lower the amount of check, higher the compensation claim? Can I say lower the amount of the check, higher the compensation claimed? Yes. Now tell me, what is penalty or liquidated damage? Damage is already mentioned in the contract. When I say liquidate penalty, can I say penalty is something which is very high, a very high amount mentioned as damage? Yes. What is liquidated damage? We try to calculate what could be the damage that we will suffer. Whatever is mentioned, what will you get? You will only get what you have suffered, or whatever is mentioned, whichever is less. What is rescission? Now, please, we have done rescission before. That was mutual consent. This rescission is what? This rescission is not mutual consent. This is breach. So I am ready to perform. You refuse to accept. Should I sit and cry or should I sue you to cancel the contract? Sue you to cancel the contract. This is what? Sue for rescission. Can I also claim damages? Yes. So please remember, other rights are available apart from monetary rights. मतलब other rights तो मिलेगा. I can also sue for damages. What is quantum merit? As much as is earned or as much as is merited. As much as is earned or as much as is merited. अभी एक बात बताओ. In case of quantum merit, if the contract is separable and I have performed a part, will I be paid for the part performed? Yes. If the contract is not separable and I have performed a part, will I get money for the part? No. But if the other person accepts it, will he pay me for the part accepted? Yes. If I perform the contract, which is not separable, I perform, but not up to the mark. Should I be paid a reasonable amount or not? Yes. Like you repair the room. I say I don't like the room. I'll not give you anything. Can I do that, or I have to pay the reasonable amount? Reasonable amount. Contract later becomes void. Right? Later becomes void. So whatever part has been performed, should I pay for that part or not? Yes. Is it clear to everyone? Yes. What is specific performance? Basically, specific performance is suing the other party that you have to perform. This is generally in two cases. This is generally in what? Two cases. What are the two cases? First, goods have no substitute. This generally happens in case of what? Antique goods, right? Antique goods or some goods which are not easily you don't get them. Or the damages are not an adequate relief. What is damages are not an adequate relief? Damages cannot be compensated for non-performance. Damages cannot be compensated for non-performance. There. Will I just take the damages or will I sue the party to perform the contract? I'll sue the party to perform the contract. Is it clear to all of you? Yes. The next one. What is injunction? There is a negative term and one of the party breaches the negative term. Can the other party sue to perform the contract? Yes. Now we are done with this unit also. Last में हमने कोई भी after this we have not written any answer also. नहीं हो गया I want you to take a picture of this. I want you to write the answer to this and come. Okay? Tomorrow, before we go forward, we'll be discussing these two questions and then we'll move forward. And I'll ask you to read the questions. Okay? Oh yeah. So can I go forward? Yes. Now, special contracts. We have 7 types of special contracts, starting with contingent contract. What is contingent contract? Dependent on a future uncertain event. What is contingent contract? Dependent on a future uncertain event. It's a contract to do or not to do something on the happening or non-happening of a future uncertain event. I will sell you my house if I inherit it from my father. The contract is what? I will sell you my house. But it depends on what? If I inherit it from my father. The contract is what? I will sell you my house. It depends on what? If I inherit it from my father. Now, can I say the event must be a collateral event? Yes. Simple, sir. If the event is coming from the other party, it is not collateral. But if it is not coming from the other party, it is what? Collateral. For example, A says to B, I will give you 1 lakh if you marry C. And A says to B, I will give you rupees 1 lakh if I am able to marry C. बोलो कौन सा contingent है कौन सा नहीं है? Second one is contingent. In the first case, the contract is dependent on the marriage. But this marriage is coming from the other party, correct or not? When the event is coming from the other party, it is what? It is reciprocal. But in the second case, I will give you money when I marry. Here is the event coming from the other party? No. So when the event is not coming from the other party, it is what? It is collateral. And if it is collateral, then it is what? Contingent. Samajh mein aaya sabko? Yes. And it is never, let's say A says to B, deliver me the goods. I will pay you if I wish to. Is it contingent? No. Can it depend on a third party? Yes. But can it depend on the desires of the parties? No. So, when I say contingent contract can depend on the happening of an event. It can depend on the non-happening of an event. Let's say A says to B, I will sell you my house if I inherit it from my father. The contract is what? Contract is what? A will sell his house to B. But it depends on what? If he inherits it from his father, right? Correct? Tell me one thing. If A inherits the land, is he liable to sell? Yes. If A does not inherit the land, is he liable to sell? No. No. Is B liable to? Yeah. If he inherits, he has to buy because there is a contract. So is valid when the event happens, becomes void when the event does not happen. Becomes void. Is it void ab initio or it is a void contract? Void contract. In Indian contract act, contract is void only in two cases. What are the two cases? A supervening impossibility and contingent contract. Clear to all of you? Yes. Then dependent on the non-happening of an event is valid. Let's say A says to B, I will give you rupees 100 if the ship does not come to the port. Giving the same examples because you can connect to the examples because we have done it in the notes. If the ship does not come to the port, now tell me, if the ship sinks, the contract is what? Valid. Because the contract says if the ship does not come to the port, ship sinks means it will not come to the port. Contract is what? Valid. So it is valid when the event does not happen and becomes void when the event happens. If the ship comes to the port, will I give you the money? No. Can it depend on a third party? Yes. A says to B, I'll give you 1 lakh if I am able to marry C. C marries D, what will happen? Void. But if C marries A, valid. So it's valid if the third party acts as per the contract. Can it depend on impossible event? No. A says to B, I will give you 1 crore if I get a star from the sky. Not possible. It is what? Void ab initio. Clear to all of you? Yes? Quasi contract. What exactly is a quasi contract? Tell me. What exactly is a quasi contract? There is no contract between the parties, but a contract is created by the imposition of law. Why is it created? To prevent the unjust enrichment of one at the expense of other. If I supply goods delivered by mistake or under coercion, I have to deliver the goods to you. By mistake, I deliver it to them. Are they obliged to return the goods back to me? Yes. Are they obliged to return the goods back to me? Yes. Necessaries supplied to a minor. If a person supplies necessaries to a minor or to a lunatic's family, is there any contract between them? No, because we cannot make a contract with a minor or a lunatic. But there is what? Quasi contract, where the person who has supplied the necessaries will get his money back. From where? From where? From their property. Now, for this, two things is important. He has to prove that what he supplied was necessaries and the person did not have the possession of them and the family was a dependent family. Right? Payment made for a third party. You are supposed to pay, I pay. Why I pay? Just random I pay or to protect my interest I pay? Why do I pay? Do I just pay it randomly or do I pay to protect my interest? To protect my interest. Can I recover it back from you? Yes. Yes. Work done non-gratuitously. Work done what? Non-gratuitously. Your car is parked outside, a kid starts cleaning your car, you see him, you don't stop him. Are you liable to pay him? Yes, because he's not doing it free of cost. And finder of the goods we will do when we come to kya? Bailment. Okay? With this we are done with this part also. बताओ इसका आंसर क्या होगा? You'll write it. जल्दी से लिख लो इसको. This is the last one for the day. PQR Hospital in Delhi recruits Dr. A on contract basis for a period of 3 months. The hospital management promises to pay Dr. A a lump sum amount of 1 lakh if D tests positive. So is it happening or non-happening? Happening. Identify the type of contract and highlight the rule of enforcement. Correct? So what should I write here, guys? Should I also explain about contingent contract here? Because they have said identify the type of contract, right? So थोड़ा लिखना चाहिए कि नहीं? अब see, you have to understand how to answer. if a question is a locha to a general rule, the right way to answer is how? First, I will write the rule, then I will write the locha. Correct or not? But if the same question comes for 2 marks, can I actually write the rule and then the locha? No. There, what will I write? Only the locha. But otherwise, if it is a rule, if it is 3-4 marks ka, I will first write the rule and then I will write the locha. Are you getting my point? So you have to understand, depending on the marks, how much you should write. Depending on the marks, you have to decide the content of your answer. So anyway, coming back here. So here, do I need to write about contingent contract? Yes, because they've told us, identify the type of contract. So first you have to write what? As per, you remember the section number, you can write as per section this. You don't remember the section, there is no hard and fast rule that you have to write the section number. But guys, let me tell you, if you don't remember the section number, please don't write a wrong section number. That gives a worse impression than your no section. And as an examiner, if you write a wrong section, I do have a right to give you an absolute 0. I actually can put a cross across the question and give you 0. That is my right, because you've quoted wrong. So you don't remember the section, don't write. But if you remember, go ahead. If you don't write wrong sections, please. As per this of Indian Contract Act 1872, can I start with the definition? So actually, no, after this comma, no, people get confused. How should I start? Should I write this case refers to? अच्छा एक बात बताओ, Indian Contract Act is like 120 pages, 130 pages. Out of that 130 pages, why did you choose to write about contingent contract? Because this case relates to contingent. So do I have to write this case relates to? No. I am writing about contingent contract because this case relates to. So do I have to start this case relates to? No. Bangalore Road ke jaisa answer hai ye. Right? It is an answer like Bangalore Road, nothing else. So you directly, it's a contingent contract, directly start with it. Don't write a contingent contract means, some people what they will do, 1872 contingent contract, then start definition. Are ye kya hai? No hyphen, nothing. What is this? A contingent contract means, or a contract to do or not to do something on the happening or non-happening of a future uncertain event is a contingent contract. ऐसे लिखना है, ठीक है? A contingent contract is a contract. A contingent contract is a क्या? Contract to do or not to do something on the happening or, I know you, it's, I told you I'll leave you, 8:30 से ऊपर हो चुका, I understand, but please just we'll finish this answer and I'll leave you, ठीक है? Dependent on the happening or non-happening. So on the happening or non-happening of a क्या? Future uncertain event. Now, do I have to write about happening, non-happening, all, or only the one which it relates to? A contingent contract dependent on the happening of an event. Dependent on the happening of an event is valid when the क्या? Event happens and becomes void कब? When the event does not happen. This is my provision. Clear to all of you? This is my provision. Now, also what will happen if Dr. A does not contract COVID? So therefore, can I say this is a contingent contract dependent on the happening of an event? Yes? Hello? This is, do I have to really write this line or can I just avoid also? I can avoid also, right? This is a contingent contract dependent on the क्या? dependent on the happening of an event, right? In case Dr. A does not contact kya COVID, he will not be entitled to receive what? One, right? हो गया. This is our answer. वैसे if you will see in all the answers we have not written anything great or out of the box. Simple. But we have written complete, proper, with the proper words, sentences, full stops. That is what you need to do. आप लोग का problem क्या होता है? You write 3 lines in 1 line. And the answer is not complete, it's not good, it's not standardized. So I'll see you all with this. We'll end it here. So let's start with the next one. The next one, contract of indemnity. Thank you. Contract, what is indemnity? What does the word indemnity mean? What does the word indemnity mean? To make good the loss. The word indemnity means to make good the loss. So party 1 is making a promise to party, this is party 2. What promise is he making to party 2? That I will make good the loss that you may suffer. That is, party 1 is saying to party 2 that if you suffer any loss, which loss? Due to me, that is due to party 1 or due to any other person. So he says, if you suffer any loss, I will compensate you for the loss. The person who makes the promise is the indemnifier, and the person to whom the promise is made is the indemnified. Right? Is the indemnified or indemnity holder. So what are the rights of the indemnity holder or the indemnified? Let's say someone actually files a case against him. Can he recover all the cost of the case that he has filed? Yes. If in that suit he loses that case, if he loses means he has to pay something, can he also claim the damages that he suffers? Yes. Apart from that, let's say they don't go to the court. Rather, they settle outside the court. So any sum which is paid in the compromise, can he recover that also? So let us say you found a mobile phone, you picked it up, your friend says it's mine. You say, don't worry. So you are like, okay, take it. Then you are like worried. If it is not his, what then? If someone else comes and says it is mine, why did you give it? What then? So he's like, what should I do? What should I do? So his friend tells him, don't worry. I promise you, if tomorrow someone comes and says it is their phone and you suffer any damage, I will give it to you. So this is what? Contract of indemnity. You are the indemnified or the indemnifier? Who is making the promise? Your friend. He is the indemnifier. To whom the promise is made? To you. So you are the indemnified. Now let us say someone else comes and claims the phone. They're like, why did you give it to him? It is my phone. So now he files a case against you. So when he files a case against you, can you actually recover that money of so you will also have to hire a lawyer. Whatever expenses, can you recover those expenses from the other person? Yes. You lost the case. If the phone actually belonged to that guy only, not your friend. So you had to pay him some compensation. Can you claim that also from your friend? Yes. The person comes and says, it's my phone. Why did you give it to him? I'll file a case against you. You're like, please go ahead. The court is all yours. Definitely my grandson will give your grandson the money. Right? Because you don't know how cases go on. Right? You know how cases go on. Right? I know. Huh? Tariq. So he's like, yo. So he says, look, you want damages? I'll give you damages. Let's not go to the court. This is what? Compromise. So you pay him the sum. So can you recover this sum of money from your friend? Yes. Is it clear to everyone? Yes. The next one, contract of guarantee. Indemnity. Tell me one thing on this. Is contract of insurance a contract of indemnity? A contract of insurance, is it a contract of indemnity? Yes. As per the definition, no. Because they are saying loss suffered due to the fault of this party or fault of this other party. So we are only talking about man-made causes. So when I'm talking about man-made causes, does it cover? I repeat again, does it cover? What do you say? Yeah. Does it cover this insurance? No. But in the case of Gajanan versus Madan, the court held that, what did the court say? The court held that this definition is incomplete and it shall include contracts of insurance. So contract of insurance is also contract of indemnity. Contract of guarantee. What is a contract of guarantee? One party promises to another to perform on behalf of a third person or to discharge the liability of the third person in case he fails to do so. So let's say surety is promising to the creditor that if the debtor does not perform or if the debtor does not discharge his pay, I will pay on his behalf. This is what contract of guarantee. The person who gives the promise is what? Surety. The person to whom the promise is given is what? Creditor. The person who gives the promise is the principal. Sorry. Oh my God. I'm so sorry. The person who gives the promise is the surety. The person on whose behalf the promise is given is the principal debt, and the person to whom the promise is given is the creditor. Is it clear to everyone? Now tell me, how much is the surety? Yesterday I told you we'll go at a particular pace because it's a marathon. So cannot go slow. But if you have doubt on anything, you can please ask me again. Okay? Now tell me, what is the liability of the guarantor or the surety? I am liable for whom? Principal debtor. Can my liability ever be more than him? Can my liability ever be more than him? No. Let us say D took a loan from C, S gave a guarantee. What is this guarantee? If D does not pay, I will pay. The loan amount including the interest was 2 lakh. The loan amount including the interest was 2 lakh. So what is this? If S does not pay, what is S saying? If D does not pay, I will pay. Who is the principal debtor here? Who is the creditor here? Who is the surety here? Tell me. What is D is what? Principal debtor. Who is C? Creditor. Who is S? Surety. Who is S? Surety. Now tell me, what is basically guarantee? That if S does not pay, oh my God, what is wrong with me? So basically, what is the promise? That if D does not pay, I will pay. What is the promise? If D does not pay, I will pay. Is it clear to everyone? Yes? If D does not pay, I will pay. Now, how much is the liability of D? How much is the liability of D? 2 lakh, right? Abhi, what happened? No, this C says to S, look, you are giving a guarantee. This guy is 2 lakh. But because you are giving a guarantee to me, you have to pay me 2,20,000. That means you have to give me a guarantee of 2,20,000. Can we do that? I repeat again, when S gave the guarantee note to C, C says, look, you are giving the guarantee on behalf of what? D. D has to pay 2 lakh. But you are giving a guarantee, I want more. So give me a guarantee of how much? 2,20,000. How many of you say he can ask for a guarantee of 2,20,000? Can he ask? No. What? Who? On whose behalf I am liable? D. What is D's liability? 2 lakh. What can be my maximum liability? 2 lakh. Can it be more? No. So please understand, it is always coextensive. What is coextensive? Equal or less, never more. Can you on the other hand say, look, out of the 2 lakh, 1,80,000 is the principal amount, 20,000 is the interest. I will not be giving guarantee for interest. I will only give guarantee for interest amount. Can we do that also? Can we do that also? Yes. Can we do that also? Yes. So it coextensive means it is equal or less, but never more. Now, when does the liability of the tell me when does the liability of the surety arise? When does the liability of the surety arise? When the principal debtor makes a default, right? And tell me, if I cannot hold the debtor liable, can I hold the surety liable? No. Because I am liable only because the debtor is liable. If the debtor is not liable, how can I be liable? Now tell me, what are the different types of guarantees that we have? Tell me, what are the different types of guarantees that we have? Specific, continuing. What is specific? For a specified transaction. Can you revoke it? No. Guarantee is given, and that is why contract is made. How can you revoke it? Right? So, no, you cannot revoke it. What is continuing guarantee? Moves over a series. Please, ये सब keywords होगा. Series of transaction has to be there in your answer. ये कीवर्ड है. Moves over a series of transaction. Can I revoke my continuing guarantee? Yes, by notice of revocation. ठीक है? Now moving forward, what are the rights of the surety? Can I say the surety has a right against the principal debtor, against the creditor, and against the surety? Am I right or not? Co-sureties, yes. What is his right against the principal debtor? सबसे पहला rights of subrogation and then rights of indemnification. What is right of subrogation? He steps into the shoes of the creditor. He steps into the shoes of the creditor. That means the moment he pays off the what? Creditor. Debtor had taken a loan from creditor 2 lakh, S has given a guarantee. On the due date, S goes and pays off C. Can I say SC is out of the picture? Yes, yes. Now, D is like, oh wow, I am discharged. Khatam. Is he discharged or is he still liable to pay? Still liable. As far as D is concerned, S has now become his creditor. He steps into the shoes of the creditor. Please, hey creditor, open your shoes. I will wear and step into your shoes. No, okay. So he steps into the shoes of the creditor. This is known as what? Subrogation. This is known as what? Subrogation. So rights of subrogation is basically he steps into the shoes of the creditor. Now tell me when he pays off. So when I say he steps into the shoes of the creditor, can we say all rights of creditor passes to him? Can I say all rights of creditors passes to him? Correct or not? Yes. All the rights of the creditor he now gets. So when I say rights of the creditor, if creditor does not get the money, can he sue the debtor? Yes. Now, if S does not get his money, can he sue the debtor? Yes. Can I say D must pay back S? Yes. This is known as what? Right of indemnification. This is known as what? Right of indemnification. So this is the right of the surety against the principal debtor. Now, what are the rights of the surety against the creditor? So let's take a case. Let's say D had taken a loan. Why did I even erase it? I don't know. Let's say D had taken a loan from C, loan of 10 lakh. And S has given a guarantee. Okay. S has given a guarantee. Now what happened is that D had taken this loan. C says, what is the security? He says, S has given the guarantee. No, S has given the guarantee. I know, but S can die. He's human. Give me more security. He's like, what more security? No, I want more. So what he does is he gives a piece of jewelry to C of rupees 8 lakh. On the due date, when S pays C, can he get the jewelry? Can he get the jewelry? Yes. This is the right against the creditor. If you remember, I told you he steps into the shoes of the creditor. That means all the rights of the creditor pass to him. Did the creditor have a right over this jewelry? Yes. So once he pays off the creditor, can he recover that jewelry from the creditor? Yes. Achha, let's say the creditor says, I return the jewelry back. What will happen? Creditor says, I return the jewelry back to D. What will happen? Bolo.
S has the right to
S has a right to claim the value. Has it? Why will he claim the value? Let's say C lost the jewelry. Let's say C gave the jewelry back to D. What will happen? Can I say S is discharged for 8 lakh rupees? Yes or no? His liability is now only how much? 2 lakh. Right? Is it clear to all of you what discharge of the surety maybe will do? Till this point, is it clear to everyone? Yes. Now, tell me one thing. Let's say I add something. D gave a piece of jewelry of 8 lakh to C. S was unaware. S was unaware of the jewelry. Does he still have a right over the jewelry? S was unaware of the jewelry. Does he still have a right over the jewelry? थोड़ा थोड़ा जल्दी जल्दी से बोलिए, please. Does he still have a right over the jewelry? Yes. Doesn't matter he knows or not. He has a right over that jewelry. Is it clear to everyone? Yes. Are you sure? Pakka? Yes. Now, what are his rights against the so rights against the creditor is what? Security. If the creditor loses the security or parts with the security, the surety is discharged to the extent of the value of the security. And if you see, he's entitled to every security whether he knows about it or not. समझ में आया सबको? Yes, we had done this example also in the class when we were doing it. Now moving forward to what are the rights against the co-sureties. अच्छा co-sureties का rights के लिए ना I'll just show you one question and I want you to tell me the answer to this. I don't know I don't think we have discussed it in the class. So this is the question, right? I want you to tell me what should be the answer. Why don't we do one thing? Take a picture of this question, write the first paragraph and the conclusion. But when you practice at home, you're supposed to write all the 3 paragraphs. मैं ज़्यादा टाइम नहीं दूंगी. I'll just give you 2 minutes to write it, at least to figure out. फिर हम साथ में लिखेंगे इसको, ठीक है? In tax papers बता रही हूँ तो इंटर का बता रही हूँ. So even tax is a law only. Tax is also law only. So tax laws बोलते हैं उसको, ठीक है? तो company law भी वही है. What you are doing is law only. So in the suggested answer, the ICAI actually made a comment. The reason the students are not scoring is because they are writing very generic answers. You have to understand, maybe you don't have to write the law language word to word, but you cannot write a very, very generic answer. So that is the reason you don't score marks. Abhi, writing an answer and you don't follow an order. तो उससे क्या होता है ना, your answer looks very haphazard. You are saying, you are not telling me what is subsequent impossibility. And then you are talking about if there is a subsequent impossibility, money should be refunded. And then you are defining what is subsequent impossibility. No, there should be an order to your answer. So when I was checking this answer of the student, no, what he had written, if the debtor gives an amount which is equal to the amount of a loan, it is implied. This is not the language. Are you? Mr. R executed a loan to D with X, Y, Z as sureties. They are known as what? Co-sureties. Co-sureties का मतलब क्या होता है? When 2 or more persons have made a joint promise. Each surety executed a bond with varying penalty amounts. X with a penalty of 1000, Y 20, Z 40. Is it a ratio or is it the maximum amount I'm liable to pay? Maximum amount. In the event of D's failure to repay the borrowed money to Mr. R, examine the liability of the sureties in accordance with the Indian Contract Act. When Mr. D makes a default to the tune of 42,000. Additionally, assess the situation if there is no contractual arrangement among the sureties. Okay, tell me how much is each of them liable to pay? 10? No, the default is 42,000. What is the liability of each of them? Agar 42,000 I divide, okay? If I divide 42,000 into 3 parts, it comes to what? 14,000 each. Correct or not? Yes? But we just saw that X is liable only for how much? 10,000. So X kitna dega? 10,000. So how much is his loss? How much is he not going to give? 4,000. Which will be borne between whom? Ma'am, how did you get 14,000? This is not the ratio. And if nothing is given, how do we share it equally? Correct? So how much is each of them liable to pay? 14,000. But X says I'm only liable to pay how much? 10,000. So uska jo less amount hai, how much is that less? 4,000 will be borne by whom? Y and Z. What ratio? Equal. That is 2,000 each. Correct or not? So how much will Y share? 16,000. Does it cover? Yes. How much will Z share? 16,000. Is it clear to all of you? Yes. Now how will you write? Should I write the answer? Guys, should I write the answer? क्या हुआ आज? Everything all right with you guys? कल के बाद में realize why it's not that easy. हाँ? कल के बाद realize why it's not that easy. किसको किसको शक हो रहा है अपने ऊपर में आपकी देना चाहिए कि नहीं देना चाहिए? हाँ? Now is not the time to have shak. Now the only time is to study. Right? The only time is to study. As per the provisions of Indian Contract Act 1872, in case or rather where two or more persons have given a joint, where two or more persons have given a guarantee, then in case there is no express agreement to the contrary, each of them is liable to contribute equally. In case of co-sureties bound by different amounts, if there is no agreement to the contrary, then each of them is liable to contribute equally up to their respective limit. Clear to everyone? Yes. Ma'am, you have written same things only, no, both paragraph. No, first I have given what happens in case of no limit and no agreement as to how we will share it. Second is different amounts. Okay? The liability of the co-surety shall remain even if there is no contract between them. Do you know why did I write this line? If you see here what's given, see in this question, assess the situation if there is no contractual arrangement among, that means what, XYZ have not made any contract between them, still they will continue to be liable or not? Yes. So this line is written for that only. So the liability of co-surety remains even if, or exists even if there is no contract between them. Is it clear to everyone? Yes. So how will you assess the situation? So therefore, what is the question? What is the first question? When examine the liabilities of the sureties. Okay. Therefore, X is liable for how much? 10,000. You will have to, do you have to show the working in the second paragraph? Yes. Do you have to show the working in the second paragraph? Yes. X is liable for 10,000. Y is liable for how much? 16,000. And Z is liable for kitna 16,000. The liability will remain the same. The liability will remain the same even if there is no contractual what was the word there? Arrangement. Even if there was no contractual arrangement between X, Y, Z. That means they are saying if they did not have a contract amongst themselves, then what will be the liability? Is it clear to everyone? Yes? Hello? Hmm? Hmm, not here actually. Office में होगा. Can I go forward? Yes. Abhi chalo, let's move on. So now going to the next part, tell me what is contract of bailment? One party is transferring what? Possession. Please, ये party two होगा. Please remember, we are not transferring the ownership. Here, is ownership transferred? No. What is transferred? Possession. Possession of goods are transferred. Please understand, goods का मतलब क्या? Movable goods, right, are transferred to a for a specific purpose. And once the purpose is attained, can I keep the goods? No, I have to return the goods back or dispose of the goods. Okay? Now, the person who gives the goods is what? Bailer. The person to whom the goods are given is the bail. Right? Now, tell me, when we talk about bailment, what are the characteristics of bailment? What are the characteristics of bailment? First, can I say there must be some goods? Yes or no? Yes? When I say goods, can I include immovable property or am I only talking about movable goods? Only movable goods. Second, can I say there must be delivery of the goods? Correct or not? Delivery should be real or it can be like constructive, symbolic, anything. Anything. But delivery has to be there. Okay? Third is what? There must be a transfer of kya? There must be transfer of possession and not just custody. Remember the old lady? Kalia Perumal versus Visa Lakshmi Achi? Yes, auntie. Huh? Yes, valet car. Valet car is custody. But if you're parking your cars on the road like this, is it custody? Now, valet car is possession. But when you are parking here, you have the keys. They only have the custody of your goods, not the possession. What is it? What is possession? What is custody? Possession means you have a right to access the goods at any given point of time. Then what is the next one? There must be a return of kya? Same goods or same goods in altered form. Or same goods in altered form. Clear all of you? Yes. Now tell me, what are the types of bailment that we have? Hey, discharge of surety we did not. I'm so sorry. Can I please go back again to discharge of the surety? Yes. ये बहुत important actually. By notice, death and revocation and novation. Notice. Can I revoke specific guarantee? Yes. No. Can I revoke specific guarantee by notice? No. Specific guarantee cannot be revoked. Can I revoke continuing guarantee by giving notice? Yes. Revocation is only for the future transactions and not for the past transactions, right? Now tell me, death. Does it result in the revocation of guarantee? Specific? No. Continuing? Yes, with respect to future. Who is liable? Legal heirs. But are the legal heirs personally liable only to the extent of assets inherited? Only to the extent of assets inherited. Then next, novation. There is a change in the contract. That means, let's say the old surety steps out and a new surety comes into the picture. The contract is not discharged, but the old surety is discharged. Variation in the terms of the contract. That means what? And please, it's any variation. So even if it is beneficial, variation is variation. So any change in the terms of the contract without in the terms of the contract, who is doing it? Principal, debtor and creditor. But they are not informing whom? Surety. Will discharge the surety. From when? From when will he be discharged? From when is he discharged? From the date of variation. Why am I liable? Because principal debtor is liable. If the creditor releases the principal debtor, is the surety also discharged? Yes. If the principal debtor releases the if the creditor releases the principal debtor, is the surety also discharged? Yes. Because I am liable because he is liable. If he is not liable, how can I be liable? Then, when the creditor makes a composition with the principal debtor, this is the first one. Or the creditor promises to give time to the principal debtor, or the creditor agrees not to sue the debtor and the surety is not informed. What is makes a composition? Instead of 10 lakh, I will pay you 8 lakh in full settlement. Composition. I was supposed to pay the loan after 1 year. You tell me it's okay. Pay after 2 years. This is what extends the time. Or let us say the creditor says to the debtor, whatever happens, I will not sue you. Agrees not to sue. Should you inform the surety or not? Yes. If you don't, it will discharge the surety. Are you getting my point? Yes. So basically, please understand point number 2 and point number 4. What is the difference? Point number 2 may you are discharged from the day of variation. Whereas in point number 4, you are completely discharged. Iska na, there is very interesting question. I want you, it is there in the RTP. This time wala RTP mein tha ye, theek hai? So, where is RTP? RTP, हाँ, foundation unlocked. So you will also tell me what provisions will you write for this answer. This one. Can you see this? Yes. Jaldi se पढ़ लो and tell me then. Also find out. Okay, chalo, let's discuss this question. I want everyone's attention here, please. So this question is, Ankit has taken a loan of 1 lakh from Kishore on the guarantee of Sudeep at the interest rate of 12%. After some time, due to the financial crisis of Ankit, and at his request, Kishore reduced the interest rate to 8%. Can we say this is variation in the terms of the contract? Yes. And also extended the time for repayment. When I say this is extended the time, see what we had discussed here. When you make any variation, this is the point. You are discharged from the date of the variation. But when you extend the time, see when the creditor makes a composition or promises to give time, the surety is not informed. The surety is discharged. Are you getting my point? ये दो provisions आएगा in this question. Now coming back here, Ankit becomes insolvent. Whether Kishore can sue Sudeep for recovery. Now see, there are two things. In this case, his liability is reduced his liability is discharged from the date of variation. But when he gives time, his liability is completely discharged. So can I recover the money from him? No. Please, dono situations are different. If this was not given, then we will say he is liable up to the date of what? Reduction. But because they added this and also extended the time, the moment extension of time happened, ab kya hua? Completely discharged. So what am I supposed to write? We are supposed to write both the provisions. Can I just read it out instead of writing it? Huh? As per the provisions of the Indian Contract Act 1872, when the principal debtor and the creditor makes any variation in the terms of the... Now, if this question was for 5 or 6 marks, if it was for 3 marks, you don't have to write all of this. But if let's say it was for 5 marks, Should I actually give the definition of guarantee? Yes. Yes. So sometimes on the basis of the weightage of the marks also you have to decide the content of your answer. Okay? When the principal debtor and the creditor makes any variation in the terms of the contract without informing the surety is discharged from the date of such variations. Next line. In case of any composition between the principal debtor and the creditor, or where the creditor extends the time or gives time to the principal debtor, or the creditor agrees not to sue the principal debtor and the surety is not informed, the surety is discharged from his liability. Is it clear? These are the two provisions. So, Prit and what is his name? Sudeep. So, your answer, did you understand what was lacking? You wrote variation, you did not write about extension of time. Okay? So, I hope it's clear. Why you have to write both? Because दोनों में answer is different. दोनों का, so and both provisions are different. So, you are supposed to write both the provisions. Okay? So, now what was the question here? Whether Kishore can sue Sudeep for recovery. Therefore, Kishore cannot sue Sudeep for recovery because the liability of Sudeep or Sudeep is discharged as a surety. Okay? So moving forward, next one. Achha, let's say D has given a D has taken a loan from C. S has given a guarantee. A goes to C and tells C, please don't sue D. And C agrees. Is C discharged? Is S discharged? I repeat again, D had taken a loan from C and S has given a guarantee. Now a third party, goes to C and tells C, please don't sue what? D. Right? Is S discharged? No. Because see, what is given here very clearly, it's given the creditor agrees not to sue the debtor. So this is a contract between whom? Creditor and principal debtor. Here is the contract between the creditor and the principal debtor. No. Is the surety discharged? No. So see what's given here. But if he agrees with the third party not to sue the debtor, the surety is not discharged. I hope it's clear to everyone. Yes. Let us say, and then one another case was what? Agrees not to sue the debtor, right? I want you to listen very carefully. Today was the repayment date of the loan. 1 year creditor did not sue the debtor. Now he goes to sue the surety. Surety says 1 year, why you did not sue him? I am discharged. Is he discharged? I repeat the case again. He did not file a case against the debtor. The creditor did not file a case against the debtor for 1 year from the date of repayment. After that, he goes to file a case against the surety. Surety says, what were you doing for 1 year? You did not sue him. I am discharged. Is it discharged? No. Please understand. Here they are saying creditor, there is a contract between the creditor and the principal debtor where the creditor agrees not to sue the principal debtor. Here, was there an agreement between them? No, he just did not sue. So see, forbearance on the part of the creditor to sue the principal debtor does not discharge the surety. Is it clear to everyone? Yes. The last one, when the creditor impairs the right of the surety. When you take away my right. For example, when you return this jewelry, he returns this jewelry to the debtor. Can I say he has taken away S's rights of 8 lakh? Yes. Can I say S is discharged to 8 lakh? Yes. And when the guarantee is obtained by concealment of material facts, then the liability is not there. Is it clear to everyone? Yes. Now, again, moving to contract of bailment. Since we have done this, I'm not going into this again. Tell me, what are the different types of bailment that we have? Gratuitous, and what is gratuitous? Not for money. What is non-gratuitous? For consideration. If it is for consideration, can I say it is always beneficial to both the parties, right or not? But if it is without consideration, can I say it is either beneficial to the bailer or it is beneficial to the bailee? Now, What are the duties of the what? What are the duties of the bailer? To disclose all the faults in the goods. अभी ना यहाँ पे थोड़ी थोड़ी चीजें समझने की है. When I say disclose the faults in the goods, okay, if my bailment is gratuitous, I am only liable for which faults? Known. But if my bailment is non-gratuitous, I am liable for both known and unknown faults, right? To repay necessary expenses. When I say expenses, expenses can be what? Ordinary and extraordinary. Like petrol is what? Ordinary, right? But repairing of the bike is what? Extraordinary, right? Now tell me, ordinary expense and extraordinary, यहाँ पे लिखने का भी नहीं है. चलो, ordinary expense, who will bear? Bailee. Extraordinary expense, who will bear? Bailer. Always remember, when I talk about this, ordinary expenses, who will bear? Who will bear? Bailee. Extraordinary expenses, who will bear? Bailer. If it is a non-gratuitous bailment for the benefit of the bailee, also same. Ordinary expenses, who will bear? Extraordinary, bailer. But now tell me, if the bailment is for the benefit of bailer, okay, let's say you have a puppy, you ask your friend to take care of your puppy. Puppy falls ill. Extraordinary or ordinary? Extraordinary. Puppy ka food? Ordinary, right? Puppy falls ill. Extraordinary. Your friend pays. Are you supposed to pay him back? Yes. Who will bear? Bailer. Ordinary. Bailee. Generally it is bailee, right? Can you tell him, bro, get one pedigree? You give him to eat. Whatever is left, you please eat it as chakna. Can you do that? Huh? Can you do that? No. So who will bear? Bailer. So please understand, generally ordinary expenses is bailee, extraordinary expenses is bailer. But if it is for the benefit of the bailer, both the expenses is borne by whom? Whom? Bailer. Now, if the title of the bailer is defective, if the title of that means he does not have the rights over the goods, and because of that, if the bailee suffers any loss, can the bailee recover the loss from the bailer? Yes. Yes. Bailment over. Bailee is saying, please take your goods. Bailer is like, yeah, I will take it. Keep no with you. Can he do that? No. Yeah, I will keep. You pay me money for that. So can he receive the goods? Should he receive the goods? Yes. And the last one, can gratuitous bailment be terminated at any given point of time? Yes. And because of that, if the bailee has suffered any loss, you have to pay back that loss to the bailee. Clear? Now, what are the duties of the bailee? Take reasonable care of the goods. What is reasonable care of the goods? That care which a prudent man would take. Tell me two cases where he has taken reasonable care, still the bailee is liable. So coming back again, tell me, if I have given you specific instructions and you don't follow the specific instructions, and if somebody you have taken reasonable care, but you don't follow my specific instructions, if anything happens to the goods, are you liable to pay? Yes. Yes. On the other hand, if I fail to return the goods within the time, and if anything, even if I take care of the goods, am I liable to pay for the loss? Yes. Then can he make unauthorized use of the goods? No, I have given you for a particular use. You can only use it for that purpose, no other purpose. Not to mix the goods with his own goods. Okay. When I talk about mixing of goods, there are different cases. We mix it with the permission of the bailer. Can I say proportionately both will share the goods? Yes. Without the permission of the bailer, we mix. If they are separable, whose duty is it to get it separated? Logic, bailee, मैंने आपको दिया. Who will separate it? You, because you mixed it. If any charges for separation, who will pay? Huh? Who will pay? Bailey, because it's Bailey's fault. समझो ना simple, किसका fault है? Bailey का. Who will pay? Bailey. If not separable, what will happen then? I gave you olive oil. You mixed with mustard oil. What? Now can you separate olive and mustard oil? Yellow color. Are light yellow, dark yellow? Can you do that? No. Who will bear the loss? So that means what? Loss nahi. Can I say Bailey is supposed to pay the price of the goods to the baler? Yes. So when he mixes the goods, if they are separable, who will have to separate? Bailey. Any cost of separation will be borne by whom? Bailey. If the goods are not separable, the Bailey must pay reasonable price of the goods. Right? Not to set up any adverse title over the goods. Adverse means negative title. I give you my phone to keep. You go and pledge it. Is it right? No, you don't have the right to do that. So not to set up any adverse title. Return any increase or profit to the goods. And obviously, finally return the goods. Can I move forward? Yes. Can we move forward, guys? Yes. Now, rights of the baler. Apart from the rights, duties of the bailee, which is the rights of the baler, what else are there? Can he sue Bailey for enforcing his rights? Yes or no? Yes. If you make unauthorized use of the goods and because of that, if I have suffered any damage, can I claim that loss from you? Like I told you, drive only on plain land. You drive on hilly area. Can I claim that damage if I have suffered any? Yes. If it is a gratuitous bailment, can I cancel it at any time? Yes. It can be cancelled. If due to third party anything happens to the goods, can I claim damages from the third party? Yes. This is a right which is available to both bailer and bailee. Can I move forward to the next one? Yes. What are the rights of the bailee? The goods co-owners, okay, 3 people own it. Bailey gave it to one of them. Is his work done? 3 people jointly own a property, group, own some goods, a car, let's say ABC own a car. They gave it to D on rent. D came and returned the car back to A. Is D's obligation over or he's still liable to deliver the car? No, over. He has delivered it to one of the joint bailers. His obligation is what? Over. The bailment is one chapter which is logical. One concept which is simple logic. इसमें कुछ है ही नहीं. Delivery of the goods to baler without title. If the baler says, my goods, okay, I gave it to you on bailment. I tell you, please hand it over to her. You hand it over to her. She's not the owner. Is your obligation over? Yes. Why? Because I told you to hand it over to her. Right to apply to the court to stop delivery. If someone is asking me for the goods and that person has no right to ask me for the goods, can I go to the court to stop him from asking for the goods? Yes. Right of action against third party. This is the same thing. I have your goods. Third party ke karan the goods are destroyed. Can I sue the third party to recover the loss? Yes. Right of lien. What is lien? If I don't get my charges for bailment, can I stop the goods? Yes. Particular lien is basically for the charges of service. I ask you to stitch 4 shirts. I pay you the price of 1 shirt. Can I take the delivery of 1 shirt? Yes. Can I take the delivery of the 4 shirt? No. I pay you the price of 1 shirt. You keep the money. You say, come bring 3 shirt ka paisa, then take all 4. Can you do that? No. What I have paid, I will get. What I have not paid, I will not get. So it is for the charges of service. What is general lien? It is over the general account of the balance. That means, let us say with my bank, I have 3 FDs. And I have taken a loan against this FD. That means this is the security if I fail to repay. I try to get this FD encashed. Can the bank stop me from getting this FD encashed? Yes. Yes. It is exercised over the general account balance. That means what? It is over, even though it was against this FD, can the bank still stop me from taking these FDs? Yes. This is not available to all banks, CAs, only they can do it. Is it clear to everyone? Yes. Finder of the goods. What are the rights of the finder of the goods? What are the rights of the finder of the goods? Huh? If he does not, अच्छा पहला सबसे पहला obligation. Can I say in case of finder of the goods, there is a quasi contract between the owner and the finder? Yes. There is a quasi contract between the owner and the finder. अच्छा मैं ना ये क्वेश्चन को डिस्कस करने से पहले एक क्वेश्चन दिखाती हूँ आपको इस पॉइंट्स को डिस्कस विल डिस्कस दैट क्वेश्चन ठीक है so let's just discuss this question 1 minute 2 minutes of your attention here please. So, Raghav found a gold and diamond studded wristwatch value approximately 1 lakh on the roadside. He picked it up and then advertised in the newspaper that the true owner thereof can take the watch after showing proper evidence. After waiting for a certain period of time, when the true owner did not turn up, he gifted that wristwatch to his son. Son. Acha, by the way, can you actually gift this watch? No, because you're not the owner of the goods. Can you sell the goods in some cases? He gifted that wristwatch to his son Mahesh. A few days later, Madhav, the true owner, somehow noticed the watch on the wrist of Mahesh. He approached him to collect the same, but Mahesh refused. In the evening, Raghav called Madhav and told him that he incurred 20,000 to find the true owner. If he fails to reimburse him the lawful expenses incurred on finding out the true owner, he will sue him for the recovery thereof. Even he can sell the watch to recover. Okay. So first he's saying for this expense I will sue you. Can he sue him? No. You have a see. This is the money you have spent on your own. It's your choice that you have spent it. You can recover it from him, but you don't have a right to sue him to recover the money. So the answer is what? No. Now he says I can also sell the watch. Can he sell the watch? Can he sell the watch? Can he sell the watch? Mm-hmm. Well, as far as selling the watch is concerned, you can sell the watch if the expenses is 2/3 or more of the value of the goods. So let's come back here. What is the obligation? Can I say take reasonable care of the goods? Yes. Can I say not to mix the goods with his own goods? Yes. Not to use the goods for personal purpose? Yes. And try to trace the owner, right? If he does not get the money, expenses, whatever, can he, let's say that 20,000 expense was not given to him. Could he keep that watch with himself? Could he keep that watch with himself? Hello? Could he keep that watch with himself? Yes. But can he sue? No right to sue. The lawmakers, but on what grounds they said, you have spent this money on your will, no? How can you sue me for that? But it is for your watch, I am not, so for that you can exercise lien. But you don't have a right to sue. Acha, let's say I found the watch. Hello, give 10,000, then I give the watch. Can I do this? Can I do this? No. But if you have announced the reward, can I tell you that pay me only, then I will give you? Yes. So right to sue for reward, if any. If there is a reward, can I sue for the reward? Yes. Right of sale. Now see, right of sale is very clear if the goods are what? Perishable. Or if the owner is not found. Or owner is found but he refuses to give kya? Lawful charges. What is lawful charges? Whatever I spend. And such charges are what? 2/3 or more of the value of the goods. So let's go back into this question and understand. Gifting the wristwatch to his son, can he do that? No, because you cannot use the goods for your personal purpose. Warning Madhav to sue for the recovery? No. Retaining the possession of the wristwatch till the recovery of lawful expenses. Yes. Selling of the wristwatch for the recovery of expenses. No. The value of the watch was estimated 1 lakh. How much did you spend? Was it 2/3 or more of the value of the goods? No. So can you sell it? No. Is it clear to everyone? Yes. Now tell me, when is bailment terminated? When is bailment terminated? Time is over, purpose is over, parties are over, subject matter is over. Gratuitous bailment can be terminated at any point. And if the person makes unauthorized use of the goods. Clear, all of you? Can I move forward? Yes. Pledge. What is pledge? Can I say pledge is, so basically I want a loan from you. Now please understand, you will not see my face and give me loan. You will not see my face and give me the loan. What will you say? Ma'am, what is the security for the loan? So I say, take my phone, give me the loan. What have I done? Pledge the goods. Can I call it as a bailment? Yes. Pledge is a bailment of the goods as a security for the payment of a debt or the performance of the contract. Can I call the pawnee, okay, as the bailee? Yes. And can I call the, baba, either, sorry. Can I call the pawner as the bailer? Yes. And can I call the pawnee as the bailee? Yes or no? Yes. Now, what are the duties? Okay, यहाँ पे ना कुछ problem हो गया है. What? इसका duties are here and इसका duties are here. ठीक है? Not doing the duties part because it is the same as what? It is the same as what? Bailment. But एक minute जल्दी से read the heads if you have any doubt, नहीं तो we'll go forward. Okay. Rights, duties are clear. Do I need to explain any? No. What are the rights? What is this right to redeem? If I have paid, right? If I have paid, can I get back the goods? Yes. I think if the due date was today, but I pay later, can I still recover the goods? Yes. If the goods are not sold, I can recover the goods. What are the rights of the pawnee? Retainer. Retainer is nothing but what? Lien. Abhi, please understand one thing. Generally, in bailment, the lien can be exercised only for the what? Charges, right? Here, lien can be exercised for the principal amount, for the interest amount, for the ordinary expenses. But can you exercise lien for the extraordinary expenses? No. No. Can you recover it? Yes. But can you exercise lien? No. If let us say I take one loan from you, give my phone. Subsequently, I take some other loan also from you. Can you use this phone as a security for the other loan also? Yes. Yes. Then right when pawner makes a default. That means when the pawner does not pay, can I say the pawnee can also sell the goods? Clear to all of you? Yes. Okay, can I move forward, guys? Yes. Can we move forward? This, no, we will do obviously when we go to the Sale of Goods Act part. I'm not doing it here. Can we move forward? Yes. What is agency? Agency means what? When one person acts on behalf of another or represents another person. The person who does the work is known as what? The person who does the work is known as what? Agent. But the person for whom the work is done is known as what? Principal. For the act of the agent, who is liable? Principal is liable. But there are cases where the agent is personally liable. Yes. When the contract expressly says that principal shall be personally liable. When the principal resides outside India, तो हम किसको sue करेंगे? The one who is in India, right? Agent. Agent is acting for an undisclosed principal. What is undisclosed principal? That means he doesn't say that is acting as an agent, that is acts in his personal name. When the principal is a person who cannot be sued in the court of law. So there are these diplomats, these, can you just go and file a case against the prime minister? No, you need the approval of the court to do that. So,
do even embassies have that?
Yeah, you just cannot go and file a case against these diplomats and all. So in that case, you need the permission of the court. So there, who will I file the case against? Agent. Agent signs the contract in his own name. Can we say this is kind of undisclosed principle only? Yes. Then acts for a principal who is not in existence. I am saying I am an agent of what? Mr. Y. Who is Mr. Y? Y is Y only. Why? Why? Fictitious person. Agent acts outside his authority. If an agent acts outside the authority, if it is accepted, is the principal liable? Yes. If not accepted, is the principal liable? No. Then the authority is coupled with interest. Principal is a minor or has no capacity to contract, or pretended agent. Pretended agent, remember ratification wala. If he accepts, then principal is liable. But if he does not accept, who is liable? Agent. Agent. How is agency created? By express authority. I give authority to the agent that you please act as my agent. Then implied. Actually, cases question to will come from implied only mostly. Mostly kya? Express mein there is nothing to ask. By estoppel. You are not my agent. I represent you as my agent. You keep quiet. I am not your principal. You represent me as your principal. I keep quiet. This is what? Estoppel. Right? On the faith of this, if the third party contracts, who will be liable? For the act of the agent, who is liable? Principal. By holding out, we had a relationship of principal agent. We had a relationship of principal agent. Today we don't have. But no public notice was given. So since public notice was not given, the world thinks what? That you are still my agent. By necessity, I have given you to do some work, but to protect my interest, you act outside your duty to protect my interest. This is what? Agency by necessity. But here, there should be first a real necessity. You must have acted as a prudent man. And third, you must not be in a position to communicate. Only then it's agency by necessity. Operation of law, best example, partnership. Is wife the agent? Yes, only for necessaries. Please, idhar necessaries is not the same as minor. यहाँ पे necessaries differs from person to person depending on their status of life. If the husband and wife are living separately, बोलो क्या होगा? If the husband and wife are living separately, बोलो क्या होगा? Can she still use the credit of her husband? Yes or no? If they are living because of the fault of wife, one day husband comes home, wife is like, you have to make a choice. What? Me or your mom? He's like, please go out. Right? No offense. So tell me, can she use the credit of her husband then? No, not at all. But they are living separately, other reason. Can she use the credit of her husband? Yes. Yes. Uh-huh. Now, if he gives maintenance expenses to the wife, 10 days, 15 days, she'll spend everything. After that, no money left. Party, sharty, sab kuch ho gaya. Now what? Can she use the credit of her husband to buy the food? No. He has given maintenance expenses. No. Sab logic hai. Right? He goes and tells everyone, look, if my wife comes to take anything on credit, you give, I'm not liable to pay. फिर भी शॉपकीपर के पास he goes, भैया भैया दे दो ना भैया, तो भैया दे दिया. Is the husband liable to भैया? No, भैया ही समझेगा. Agency by ratification, two things are here. First, when a person acts on behalf of another without his knowledge. I go and tell everyone, I'm your agent. Am I your agent? No. Estoppel में क्या हो रहा है? In your presence it is happening. Here I go and contract on your behalf as your agent without your knowledge. Two things will happen. You may what? Accept it or you may reject it. If you accept, there is an agency. If you don't accept, there is no agency. If you accept, are you liable? Yes. If you don't accept, are you liable? No. Then, next case is where agent exceeds his authority. I told you, go and get me a loan of 1 lakh. You are next level. You get me a loan of 1 lakh 20,000. I was like, you're so good. Brain you use. How much am I liable? I said, so good. Brain you used. Your brain you used, but here no brain you use because no brain. So how much are you liable to pay? 1,20,000 because you accept. I accepted. No, I said good. Your brains, right? No, no. Yeah, I was being sarcastic. No, the first was not sarcastic. I said good. You use your brain, and then I said, but no brain, right? That was sarcastic. Class में answer करने में no brain, right? But doing all these things, very much of brain. Oh, acha, you thought this was also sarcastic. Ayo, no, no. Who told you to get 1,20,000? Who asked you to use extra brains? जितना है उतना use कर लो ना. Go and return this 20,000. How much am I liable to pay? 1 lakh. Is it clear to everyone? Yes? Achha, what is the difference between substituted agent and sub-agent? What is the difference between substituted agent and sub-agent? Can I say sub-agent is appointed by the agent under the authority of the agent? Yes. Substituted agent is appointed by the agent under the authority of the principal. Is substituted agent valid? Yes. Is appointment of sub-agent valid? No. For the act of the sub-agent, who is liable? Agent. For the act of the substituted agent, who is liable? Principal. Right? When I talk about sub-agent, can the sub-agent directly go and sue the principal for his remuneration? No. Can the substituted agent go and directly sue the principal for his remuneration? Yes. Is it clear to all of you? Yes. If the sub-agent or substituted agent do a tort, okay, tort with anyway we can sue. Is it clear to all of you? Yes. Termination of agency. Termination of agency. We made an agreement for termination. Revocation of authority. Then agent is appointed for an object. Object is over. He's appointed for a time. Time is over. Death or insanity of the principal or the agent. Insolvency of the principal. If it was made for a subject matter and the subject matter is destroyed. If I'm acting as an agent for a person residing outside India and now he's become our alien enemy, or when the principal or the agent is a company and the company is dissolved. I just want to discuss a few things here and we will wind up this. सबसे पहला, what is agency coupled with interest? What is agency coupled with? Now let me tell you, agency coupled with interest cannot be terminated, right? Agency coupled with interest cannot be terminated. You have to tell me what is agency coupled with interest. What is agency coupled with interest? क्या होता है agency coupled with interest? The agent has a personal interest in the agency. The agent has a personal interest in the agency. And because of that interest, the agency is created. Because of that interest, the agency is created. Are you getting my point? For example, I had given this example also. I have given a loan to you. And to repay this loan, you tell me, ma'am, please sell off my land. Take your loan, take your commission, and remaining give me the money. Can I say here the agency was created because of that interest that I had in the business? Yes, this is what? Agency coupled with interest. समझ में आया? This is what? Agency coupled. I hope it is clear to everyone. Yes, this is agency coupled with interest. Now, can you terminate this agency? No. Because it is the reason of the loan that the agency is made. So unless the loan is paid, agency cannot be terminated. You have to tell me, is this agency coupled with interest? You tell me, ma'am, I have a land. Can you please sell it for me? I say, okay. Later you say, ma'am, anyway, you will sell the land for me. Can you give me 1 lakh loan? Adjust it against the purchase price. Is this agency coupled with interest? Think and tell me, is this agency coupled with interest? Here, why is the interest there when the agency was made? No. Agency coupled with interest ka matlab hai, the interest should exist when the agency is made. And one last point. Here, the principal sends a notice of revocation. But this notice was received here by the agent. So when is the agency terminated? The principal gave a notice of revocation at this point, but at this point, the notice was received by the agent. So when is the agency terminated? Huh? When agent gets the notice. As far as agent is concerned, termination happens when he gets the notice of termination. In between this period, if he makes a contract, agent contracts on behalf of the principal, is the principal liable? Yes. Yes or no? Yes. Yes. With this, so back again to this. So tell me, what is the date of enforcement of Partnership Act? 1st October 1932. So before that, it was a part of the Indian Contract Act, applies to the whole of India. What is partnership? So this is definition of partnership. What is partnership? Agreement between two or more persons to share the profits of the business carried by all or any one or more acting for all. So अगर हम इस definition को देखें, what are the essentials? The first one is what? Agreement. Agreement, it is agreement. So can I agree with my own self? No. I need two people at least. I need at least how many? Two. The agreement can be what? Express or imply. When it is expressed, can I say it can be oral or written? Yes. And if it is written, the deed where we mention all the clauses is called the partnership deed. Minimum how many? Maximum how many? 50. 50. If it is more than 50. If it is more than 50, it becomes illegal. Please don't write 200. 200 is for what? Private company. 200 is for what? Private company. समझ में आया? The next, what is the agreement for? To share profits. Only say share profits because we may have partners who do not share the losses, right? We may have partners who. I really want to discuss the RTPs, right? Nahi? Because I told you know that 30 days writing session. I have covered all the RTP questions in that 30 days writing session. But I want to discuss the RTP so that we should be able to, once we see how hame aata hai, we've done everything. We'll discuss the RTPs depending on how much time is available to us. So tell me, in what? So because I only say sharing of profits, not losses. Why? Because I may have partners who do not share the loss. In what ratio do I share the profits? Now, agreed. And if nothing is agreed, equally. In what ratio do I share the losses? Agreed. And if nothing is agreed, in the PSR. What is the agreement about? To carry the business. When I say business, can I say it can be any trade, profession, or occupation? Yes. But always remember, renting of any property is never considered as business. And please also remember, when I talk about partnership, the motive is always profit. So if you make a partnership without a motive to earn profit, can I call it as a partnership? No. The motive of partnership is always what? It is always to earn profit. Clear to everyone? Then moving forward, who will carry the business? Most importantly, who will carry the business? Let us say there are three partners A, B, C. Who will carry the business? Can I say all of them? Can I say all of them? Yes. Who has a right to carry the business? All. Can A, B, B, C, A, C carry the business? Yes. Can A alone carry the business? Alone. Alone. Yes. Yes. Now, when he carries the business, who is liable? Who is liable? A is liable or the whole firm is liable? The whole firm. This is known as what? That means agent does the work, principal is liable, A does the work, firm is liable. Can we say it's agency? So, partnership is it's actually a branch of agency. Operation of law. Remember agency by operation of law. Yes, that is partnership. And this is mutual agency. That is business carried by all or anyone or more acting for all. And this is the cardinal principle of what? Partnership. And can I say the partner who carries the business on behalf of the firm is both the principal and agent. Principal and agent of whom? Can I say of other partners? Yes, principal and agent of other partners. But is it principal and agent for everything or is it principal and agent for the purpose of the business of the firm? For the purpose of the business of the firm. Okay, true test of now see partnership agreement can be express or implied. Correct or not? Partnership agreement can be express or implied. It can be oral or written. If it is written, I know partnership exists. But if the agreement is oral or if the agreement is implied, how will I know whether partnership exists or not? If two or more people share profits, can I say they are partners? Only prima facie. That means first look. I have to have mutual agency. When mutual agency is also present, can I say partnership exists? Yes. Now, what are the different types of partners? Active partner. Does he bring in capital? Yes. Does he take part in the business of the firm? Yes. Does he share profits, bracket mein losses? Yes. Is he known to the outsiders? Yes. Is he liable to the outsiders? Yes. Is he liable to give notice? When I say notice, matlab kya? Public. Yes. The other name for active is also what? Ostensible partner. Sleeping, or also known as what? Dormant partner. He sleeps off, huh? No. Does he bring in capital? Yes. Does he take part in the business of the firm? No. Does he share profits and also the losses? Yes. Is he known to the outsiders? No. Is he liable to the outsiders? Yes, liabilities for every partner. Does he have to give public notice? No. I don't know you are a partner. You come, you go. How does it matter to me? So, do you have to give a notice? No. Nominal partner. Who is a nominal partner? Who lends his name to the firm. Now, does he bring in capital? No, naam leke aage agar if I'm bringing capital, if I'm bringing name, why I need you then? I will only do the business. Does he take part in the business of the? Oh, please, I'm beyond all these things. Does he share profits and losses? Generally, no, because he gets a fixed royalty. Is he known to the outsiders? Is he liable to the outsiders? Yes. Does he have to give public notice? Liable because of his name. I'm going to the firm, no. So liability to ho gayi. Who is partners in profits only? They share only the profits, not the losses. Are they liable to the outsiders for the acts of the firm? Yes. Sub partner. Partner agrees to share a part of his profits with another. अच्छा एक बात बताओ. This sub partner, if he does not get his share of profits, can he sue the other partners? No. If the sub partner, if in case there is a loss to the firm, can the other partners sue the sub partner? No. Basically, can I say a sub partner is actually not the partner of the firm? Yes, he's only the partner of the partner. Partners by estoppel or holding out, same as what? Same as agency. I am a partner of a firm. I take you with me. And to the third party, I say, this is my partner. Are you my partner? No. But I say, you are my partner. To the third party, are you a partner? Yes. Yes. If the third party contracts with the firm, are you liable? If the third party contracts with the firm, are you liable? Yes. Second case, I'm an outsider, not connected to the firm. When I say outsider, What outsider means, I'm not a partner of the firm. I could be an employee or no way connected to the firm. I go and tell the third party I'm a partner of the firm. On this faith, third party contracts with the firm. Who is liable? Firm to liable hai, because the contract is made with the firm. Am I liable? Yes. Am I liable? Yes. Yes. This is what? Partner by estoppel. Or what is my liability? Severe. Can I say partner must give notice of retirement? Yes. If a partner retires without public notice, when I say retires without public notice, does it apply to active partner? Yes. Does it apply to nominal partner? Yes. Does it apply to sleeping partner? No. Why? Sleeping partner does not have to give notice. If a partner retires without any public notice, he is liable for what? For the subsequent acts of the firm. That means if I retire without giving notice to the outsiders, I'm still a partner of the firm. So I will continue to be liable. Is it clear to everyone? Yes? Okay. So on this note, अच्छा एक बात बताना. Okay guys, can we move forward? Yes. So now tell me, can a minor become a partner of the firm? No. However, why? Because when I say partner, partner means unlimited liability, and a minor can never have unlimited liability. But can I say a minor can be admitted to the what? Benefits of the firm. Tell me, when a minor becomes a beneficiary, what are the rights of the minor? Okay, how many of you have not started studying at all for the exams right now, till now? Okay, for those who have not started studying, don't know where to start studying from, I would always suggest don't start with Indian Contract Act. एक तो it's huge, marks weightage wise just stands no chance. Like Partnership Act 20 marks, 21 marks, Sale of Goods Act 21 marks, Companies Act 21 marks. I'll finish it off in 4 days, 5 days. Indian Contract Act 50 days, marks 32. है ना? So always start, but don't leave Indian Contract Act. But start first these chapters, you get a confidence, अच्छा ये हो गया, and then go back to Indian Contract Act. So moving again, what are the rights of a minor when he becomes a beneficiary? All of you will say, I know this, everyone knows this. Will he get his share of profits? Obviously. Can he check, inspect, and copy the accounts of the firm? Yes. Can he sue the other partners for his share if he does not get his share? Yes. But he has to sever all his connections with the firm. Tell me, what is his liability? Huh? Minor will not be personally liable. Liability is against his property. Now tell me, within 6 months, from when? From the day he attains majority or the day he comes to know he was a beneficiary, whichever is later. He has to give a notice to the what? To the public and to the registrar of whether he wants to become a partner or not. What happens if he fails to give notice? He will automatically become the partner. Now, if he becomes a partner, either by failure to give notice or by choice, what will be his rights? Just as it was. What will be his liability? What will be his liability? He will be liable from the day he was admitted to the benefits of the firm. Right? We are done with this unit. Can I move forward, guys? Yes. Rights of a partner. This is the second unit. What are the rights of a partner? Can he take part in the business of the firm? Yes. But ma'am, that is done by active partner. Unless I say you are an active partner, every partner is an active partner. So every partner has a right to take part in the business of the firm unless agreement to the contrary. Can I say every partner has a right to be consulted? Yes. If it is a managerial decision, consent of all. If it is a day-to-day matter, whose consent? Majority. Can I say, huh? Oh, acha, it was not there. I'll just do it. Okay? Can he check, inspect, and copy the accounts of the firm? Yes. But it should be done what? Bona fide. Remuneration, is it payable? No. Only it is if it is stated in the agreement or if it is the custom of the firm. Only if it is stated in the agreement or it is the custom of the firm. Does he have a right to share profits? Obviously. Does every partner have a right to share exclusive profits? No. Because if everyone shares profits, who will bear the losses? But can I have some partners, they will not share the profits, they will only bear the, I mean, not share the losses, only the profits? Yes. Now, right to interest on capital. Is it your right? No. Only if it is what? Agreement or custom or statutory provision. It is paid only out of the profit. So if there is a loss, do you pay interest on capital? No. My firm closes down today. Okay? So now I pay, by the time I pay the capital, it's 2 months. Should I pay interest on capital for this 2 months? No. Please understand the concept is interest on capital is paid out of profit. If I close my business today, I stop earning profit. And if I stop earning profit, am I liable to give you interest on capital? No. Interest on advance. Advance is something over and above the capital. Payable or not? Yes. It is payable. At what rate? Agreed rate, and if nothing is agreed, at the rate of, if the contract is silent, at the rate of 6%. And it is payable even when there is a loss. Let's say today I dissolve the firm. After 1 month, I pay the advance. Should I pay interest for this 1 month? Yes, it's a loan. And interest is paid up to the day the loan is not repaid. Then tell me, if a firm has to pay money but a partner pays, can he recover it back from the firm? Yes. Right to be indemnified. What is indemnified? Paid back. This we will not do right now because in the rest part of the unit we'll anyway be doing all of this. Okay? Moving forward, what are the duties of the partner? Can we say that they should carry the business to the best of advantage of the firm? They should be just and faithful to each other. Yes. Can I say they should not make secret profits from the firm? Yes. If due to their fraud or negligence the firm has suffered any loss, can I say they should compensate for that loss? Yes. Then what else? If a partner or the legal heirs of a deceased partner ask for the accounts, can I say the partner should give them the accounts? Yes. Then can he claim remuneration for doing the business? No. Can we say that just like you share profits, equally you should share the losses? Yes. Here equally doesn't mean equal ratio. Equally means just like you share profits, you must also bear the losses. Okay? Partnership property. What is partnership property? Whatever we start our business with, that is bought into the common stock. Now tell me, during the course of business, if I acquire any property, will that also be considered as a property of the firm? Yes. If I use a partner's personal property in the firm's business, does it become the firm's property? No. Whose property is it? Partners. And for using his property, what do I have to do? For using his property, what do I have to do? I have to pay him rent or I have to pay him interest. Is it clear to all of you? Yes. Then next, can I say goodwill is also a property of the firm? Yes, subject to a contract between the partners. Depending on the contract between the partners, goodwill is a property of the firm. Personal profits. If a partner earns any profit from any what? Transaction of the firm, or by using the name or assets of the firm, or from any personal business competing with the firm, can he keep the profit or must he give it to the other partners? He must give it to the other partners. Then next, if the agreement says a partner cannot carry any personal business, but the partner carries a personal business which is not competing with the firm. The agreement is saying that he cannot carry any personal business, but he carries a personal business which is not competing. Is he liable to give profits? No. Why not? Because it's not competing. But should he compensate the firm for losses? Yes. If it was competing, profit as well as damages, right? If it was competing, both profit and damage. Is it clear to all of you? Yes. Chale aage. Yes. Now tell me, implied authority. What do I mean by implied authority? The authority of a partner to act on behalf of the firm and bind the firm by his acts. It is the authority of a partner to act on behalf of the firm and to bind the firm by his acts. But the act binds the firm only when it is done in the ordinary course. That means, please understand, the act can bind the firm only if it is done in the what? Ordinary course, and it is done on behalf of the firm. So if my firm deals in sugar and I place an order for rice, is the firm bound by this contract? No. Why? Not done in the ordinary. What is ordinary course depends on the what? Business. If it is not done in the ordinary course but the other partners ratify it, then who will be liable? Let us say tea delivered rice. Other partners kept it in the firm. Who is liable? Hello. Who is liable? The firm is liable. Is it clear to everyone? We had never written a question on implied authority, right? Had we written? Never. Let's do one thing. Let's write one question on implied authority. Okay. So let me see if it is here. And I want you to write this answer in the format. Okay. ABC are partners in a firm called ABC firm. A, with the intention of deceiving D, a supplier of office stationery, buys certain stationery on behalf of the ABC firm. The stationery is of use in the ordinary course of the firm's business. Will the firm be liable? Will the firm be liable? Yes. Why? Because they are saying he bought the stationery on behalf of the firm. And it is given, it is what? Ordinary course. A does not give the stationery to the firm, instead brings it to his own use. The supplier D, who is unaware of the private use of the stationery by A, you have to identify the key lines or words or phrases like this, which will give you the answer. A does not give the stationery to the firm, instead brings it to his own use. The supplier D, who is unaware of the private use of the stationery by A, claims the price from the firm. The firm refuses to pay the price on the ground that the stationery was never received by it. Can they refuse? Can they refuse? No, because it binds the firm, because it is done in the usual course of the business. Referring to the provisions, decide whether the firm's contention shall be tenable. No. What would be your answer if a part of the stationery purchased by A was delivered to the firm by him and the rest of the stationery was used by him for his private use? Then what would be the answer in that case? Can we say answer would still be the same? Correct or not? Yes. Why? Because as far as the third party is concerned, who is liable? The firm. Can the firm claim the damages from this partner? Yes. So what you are supposed to write in this answer? What did you guys, what did you write in this answer? What did you write in this answer, by the way? How many of you wrote as per the provisions of Indian Contract Act 1872? You wrote that, Chavi? Huh? You wrote? आंसर के साथ प्लीज एक्ट चेंज हो गया है अभी प्रोविजंस का एक्ट भी चेंज हो गया इट विल बी व्हाट एज पर द प्रोविजंस ऑफ दी क्या कैन आई राइट PA 1932 नो ये कोई शॉर्ट फॉर्म नहीं है यू हैव टू राइट द फुल एक्ट प्लीज ठीक है what do I have to write about in this question tell me personal liability no this is not personal profits implied authority so you have to write about what huh a partner of the firm is an agent of his क्या other partners for the purpose of the business of the firm. The partner has the authority to carry the business on behalf of the firm, and his acts shall क्या bind the firm if the act is okay. Here there is one thing. Hamara question had 1 2. When you are writing, please don't write 1 2 here because he'll get confused कि आपने ये answer लिखा, provision लिखा, क्या लिखा. Write A. The act is done in the what? Usual course of business, and the act is done on behalf of the firm. Right? ये हुआ मेरा provision. However, the firm can recover from the partner any loss they suffer. What? Due to his acts. This is my provision. Khatam. With this, the provision is done. Now, we'll write the conclusion. So, how will I write the conclusion? Therefore. So, in your second paragraph, you have already written about they are refusing to pay and all that, right? Therefore, the firm's contention is not tenable as the act was done in the ordinary course and on behalf of the firm. Okay, here I have a question. In the second paragraph, will you also write about this second case or will you just write about this case? See, there are multiple questions, no? The second question is saying if they use half of the pen and half of the pen was given to the firm, right? So in the second paragraph, will you write both the situations or will you only write about this situation here? Only write about this situation. You cannot write both. So you'll write the general case which is given. So that is why here the second conclusion can be a little longer in some cases. If A gives half of the stationery to the firm, even then firm shall be liable to pay for the क्या whole contract. Whenever multiple questions are given, in the second paragraph you cannot write the whole thing. So what you do in the conclusion, you make the conclusion, you write the situation given and give the answer. Is it clear to everyone? Yes? Can we move forward, guys? Yes? So moving on to the next part. Can I go forward? Done, all of you? Yes? Now, acts beyond implied. What do I mean by beyond implied authority? Partner cannot do these acts. What do I mean by beyond implied authority? Partner cannot do these acts. And what happens if he does? Firm is not liable. That means the partner cannot do these acts, and even if he does, the firm is not liable. Can the firm do these acts? Yes. But a partner cannot do these acts. What are these? But can these acts be done? Yes. If by express agreement we allow the partner to do the work, or if it is the custom of the trade, then the partner can do these acts and the firm is liable. Like for example, one point says he cannot buy or sell immovable property. But tell me, my firm deals in immovable property. Then can I buy or sell or not? Yes. So then in that case, who will be liable? If we do that, can we give the partner the authority that you can buy and sell on behalf of the firm? Yes. Then is the firm liable? Yes. So generally these acts cannot be done by the partner. However, we can give them authority to do these acts, or if it is the custom of the firm, they can do these acts and the firm is liable. He cannot submit any dispute relating to the firm to an arbitrator. He cannot compromise or relinquish the liability of any person towards the firm. He cannot withdraw any case filed on behalf of the firm. He cannot what? Compromise or नहीं ये तो हो गया ना? हाँ. He cannot admit any liability against the firm. He cannot transfer or acquire immovable property. What was the next one? He cannot open a bank account in his own name on behalf of the firm, and he cannot enter into a partnership on behalf of the firm. You want me to explain any of the points in the class we had done? Like, can I hire a lawyer? Yes. Can I go to the arbitrator? No. If the case court has filed a case, can we say let's take back the case? No. Giving a normal trade or cash discount to a debtor is okay, but we are saying, hey, you don't have to pay anything or pay half. Is that okay? No. So we cannot compromise or relinquish. Okay? The rest are easy, but understandable. These were something that we had to understand. Can I give a partner a little more or a little less authority? Can I give a partner a little more or a little less authority? Yes. How does it affect the third party? How does it affect? So this topic, no, again, we don't have to write, but I'll discuss this with this question. Okay? We'll discuss this. Can you see how many times they have given this question in the mock test? So we'll just discuss this question. Through this, we will be able to understand this provision. Okay? Extension and restriction. I think we have done this question in the class, if I'm not wrong. Chalo, koi nahi. Okay. A, B, and C are partners of a firm, ABC and Company. The firm is a dealer in office furniture. A was in charge of purchase and sale, B was in charge of maintenance of accounts, and C was in charge of handling all legal matters. Recently, through an agreement among them, it was decided that A will be in charge of maintenance and B will be... Okay, tell me one thing. When we change the authority of each other, isn't it something which is internal to us? Yes. Similar, that means when I give a partner a little more or a little less authority, or I change the authority of a partner, this is something which is between us. How does it affect the third party? Does it affect the third party? How does it affect the third party? I repeat again. Chalo. Being ignorant about such agreement, M, a supplier, supplied furniture to A, who ultimately sold them to a third party. Is the firm liable? Whether M can recover the money from the firm? Yes. Please understand, any change amongst you does not bind me unless I know about it. That means, can I say the third party is an outsider dealing with the firm shall be bound only if he has knowledge of such restrictions. Right? Knowledge of such restrictions. So, what would be your advice in case M was having knowledge about the agreement? Then what will happen? Then can I say he cannot recover? Yes, he cannot recover. Is it clear to all of you? Yes. अच्छा, एक last question before we move to the next part, which is dissolution. नहीं. ये बताओ. So, Shyam, Mohan and Keshav were partners in Messrs. Nand Lal, Gokul Wale and Company. They mutually decided that Shyam will take the responsibility to sell the goods. Mohan will do the purchase and Keshav will look after the accounts. No one will interfere in others' department. Once when Shyam and Keshav were out of town, Mohan got the information that the price of the goods is going down sharply due to some government policy which would result in heavy loss to the firm if goods are not sold immediately. He tried to contact Shyam, who has authority to sell the goods. When Mohan couldn't contact to Shyam, he sold all the goods at some reduced price to save the firm from heavy losses. Thereafter, Shyam and Keshav denied accepting the loss. Can they deny accepting the loss, or are they liable to accept the loss? They are liable. वैसे, so when you write this answer, first you should talk about what? Implied authority. First, you should say what is the implied authority of a partner. Then you should talk about acts in emergency. So to protect the interest of the firm, if the partner sells off the goods, who will be liable? The firm is liable. Okay, one thing we had not discussed earlier, what are the different types of partnerships that we have? Partnership at will, particular partnership, partnership for a fixed period. What is partnership for a fixed period? Firm for a particular period. What happens once the period is over? The firm is dissolved. Can the partners continue? Yes. And what happens? It becomes a partnership at will. What is particular partnership? Firm for a particular purpose. What happens once the purpose is over? Firm is dissolved. Can the partners continue? Yes. It becomes a partnership at will. What is partnership at will? No time is given. What is the most unique feature of partnership at will? Any partner can give a written notice and retire from the firm or dissolve the. Then tell me, when I talk about partnership at will, when a particular partnership or a partnership for a fixed period converts into a partnership at will, what will be the rights and liabilities of the partner? It will be the same, but the rules of partnership at will apply, right? Okay, notice to a partner. In the ordinary course of the business, if the partner gets any notice about any fact, is it deemed that the whole firm knows about it? Yes. But the notice must be actual and not constructive. Dissolution of partnership. Uh-huh. Can I say in dissolution of partnership, the relationship of partner changes, correct or not? The PSR changes. What are the 6 ways by which it can happen? Admission, retirement, death, insolvency, expulsion, transfer of shares. Admission, when a new partner joins the firm. How can a new partner join the firm? Consent of all or express agreement. When is the new partner liable from? The day he joins the firm. Can he decide or agree to be liable from a prior date? Yes. But even if he agrees to be liable from a prior date, the third party has no right to sue him. Then what is the next one? Retirement. What is retirement? A partner leaves the firm. A partner leaves the firm. Wow, how can a partner retire from the firm? Consent of all or express agreement or by notice in case of partnership at will. अच्छा एक बात बताओ, in case of admission, can a partner agree to be liable from a prior date? Yes, but it does not give the third party any right to sue him. Then tell me, retirement may, when a partner retires from the firm, what are the rights of the retiring? What is the liability? What is his liability? Can I say his liability is up to the date of retirement? Yes, up to the date of notice of retirement. In case I'm supposed to give public notice, up to the date of public notice. If I'm not required to give public notice, up to the date of what? Up to the date of notice to the other partners. When a partner retires from the firm, what are his rights? He'll get a share of profits. Then, if accounts are not settled, he will get subsequent share of profit, or his share will be treated as a loan and he will get interest on loan. Then, can he carry a similar business as the firm? Yes, if there is no agreement to the contrary. Can he sell his share to the existing partners? Yes. And if he sells his shares to the existing partner, can I say he will have no further rights over the firm? Yes. Insolvency, death. Can we say the moment a partner is dead, he ceases to be a partner of the firm? Yes. What are his liabilities? No, estate will be liable up to the date of his death. Should I write legal heirs will be liable, or more appropriate is estate will be liable? Estate up to the date of his death. What are the rights? Can I say the rights are same as in the case of retirement? Exam में asking, what are the rights? They are the same. as in the case of retirement. Please don't write all these things. Okay? Next one, bolo. Insolvency. The moment a partner is declared insolvent, he ceases to be a partner of the firm. Acha, death and insolvency, do I have to give notice of death or insolvency? No. No. What are the rights and liabilities of insolvency? You kya right, kya liability? Insolvent, no liability. Ma'am, we can give him his share. No, we'll keep it to pay his liability. No, in the firm. So no rights, no liability. Can I say death and insolvency are two cases where the firm is dissolved? Yes. But if the partners want, can they continue? Yes. Expulsion. What is expulsion? A partner is thrown out of the firm. How can you expel a partner? By there, no. It should be done with the consent of majority. There should be an express agreement. Express agreement means giving power to what? To expel a partner, and it should be in good faith. If the expulsion is not in good faith, the expulsion is null and void. What is good faith? It is in the interest of partnership. Second, partner is served with a notice. Third, opportunity of being heard. What is transfer of interest? Can a partner sell, pledge, or mortgage his share in partnership? Yes, that is transfer of shares. How is it done? Again, with the consent of all or express agreement. What will be the rights of the transferee? Is the transferee a partner of the firm? No. So does he have a right to share profits? Yes. Can he interfere in the business of the firm? No. Can he check, inspect, and copy the accounts of the firm? No. Can he, on dissolution, what we will get? What he will get? He will get his share of profits and property. But till now, you are not letting me see my share. How will I know what is my share? So he's given a statement of affairs as on that day. Is it clear to all of you? अब जाएं break पे? I'll see you. I'll see you. कितना? So I want you to write this answer in the format. जल्दी जल्दी लिखो. फिर I'll also just 2-3 minutes finish it and then we'll write it together. ठीक है? M, N, and P were partners in a firm which were dealing in refrigerators. On 1st October, P retired from partnership but failed to give public notice of his retirement. After his retirement, M, N, and P visited a trade fair and inquired about some refrigerators with latest techniques. X, who was exhibiting his refrigerators with the new techniques, was impressed with the interactions of P. He was impressed by the person he shouldn't have been impressed. This is called toxic relationships. Seriously. And he's not even a partner, he's impressed by that guy. So, and requested for the visiting card of the firm. The visiting card also included the name of P as a partner, even though he had already retired. Basically, what they are talking about is he retired, but he did not give public notice. Very evidently, question looks like it relates to that only. Okay? Mr. M's X supplied some refrigerators to the firm and could not recover his dues from the firm. Now X wants to recover the dues not only from the firm but also from P. Can he do that? Analyze the above provisions and whether P is liable in the is P liable in this situation. Tell me, guys, is P liable? Why? Why do you think P is liable? He hasn't given. So this is obviously the case is very clear cut. It is talking about no public notice. मेरा पहला question है, in this case, am I actually supposed to write even about how a partner can retire from the firm? No, like consent of all, we don't need to write that. Okay? So we just need to write about retirement and notice. As per the provisions of the Partnership Act 1932, when a partner retires from the firm, he must give a public notice of the retirement. बहुत ही simple सा question this was. If a partner retires without giving क्या any public notice. If a partner retires without giving any public notice, he shall be liable for the acts of the firm done after his क्या retirement. This is my provision. That's it. Acha. If instead of this, the question would have added P was a sleeping partner, then what would you write? He's not ठीक है provision में क्या लिखोगे? Now listen very carefully what all should come here. Provision में will you write all of this? Yes. Next line में you will write in case the partner is a sleeping partner, he need not give notice of his retirement. And if he retires without giving public notice, he is not liable for the subsequent debts of the firm. समझ में आया? Had the question been, so I'm just giving you situations. अगर ऐसा question आया, what will you write? So if the question says what will like P was a sleeping partner, then am I supposed to write this thing? Yes. And next line में I will add if the partner is a sleeping partner, he need not give any public notice. So in that case, what will happen? If he retires, and if he retires without public notice, he will not be liable for the subsequent debts of the firm. Is it clear to all of you? Yes. Chalo, can I move forward, guys? Yes. Moving forward, is registration of partnership mandatory? No, it is optional but desirable. Why do we say it is desirable? Because an unregistered firm faces disabilities, right? What are the disabilities of an unregistered firm? First, it cannot sue a third party. Can a third party sue? Yes. Second, it cannot claim a set off of more than rupees 100. That means, can it claim a set off of up to rupees 100? Yes. Partners cannot sue each other except for the dissolution of the firm and for the accounts of the firm. That means, can the partners sue each other for disputes? No. But if they want to dissolve the firm, can they sue? Yes. If they ask you a question like, what are not the disabilities of an unregistered firm? Be careful. What people do, they go and write what are the disabilities. Guys, I did not ask you what are the disabilities. I have seen paper mein. They got 1 mark, 0 marks. Why? Question, this is such a stupid सा question है एकदम. I wanted to say stupid slip of tongue. ठीक है? Such a stupid question it is. But people got 0. Why? They asked what are not the disabilities. And what did they write? What are the disabilities? So you cannot write. They cannot sue the third party. What will you write? Third party can sue the firm. Are you getting my point? You cannot write they cannot claim a set off of rupees 100, up more than rupees 100. What will you write? They can claim because they are asking you what are not disabilities. Please, brains को use करो. आपको answers आता है, but you have to understand how to approach the answer. And that is how you lose marks. Right? They will ask you, what was the second thing? So they cannot, instead of writing cannot claim, you should write they can claim a set off of up to rupees 100. If the partners want to dissolve the firm, the partners can sue each other. So this is how you're supposed to write. Don't write. You cannot sue each other except for dissolution. You're approaching the answer in the wrong way. You have to answer as per the question. Okay? Chalo. Now, if a partnership firm wants to sue a third party, what conditions have to be fulfilled? First, the firm must be registered. Second, partners suing should be named as partners of the firm. First, the firm should be registered. Second, partners suing should be named as partners of the firm. Now, dissolution of firm. It can take place without the order of the court or it can take place with the order of the court. Can it happen by agreement? Yes. What is by agreement? Consent of all. What is by agreement? It means all of them agree. What is happening of certain contingencies? Time is over. purpose is over. Correct? What else? Death or insolvency. Except one, all dead or in. अच्छा इसमें बताओ कंपल्सरी कौन सा है? Which is compulsory? Last one. Last में तो you have to dissolve. And what is by notice? Partnership at will. I can just give a written notice and क्या? Dissolve the firm, right? Partnership at will. Now tell me, without the order of the court, when does it happen without the order of the court? When does it happen without, with the order of the court, sorry. When does the court pass an order? When someone applies to the court. Who can apply to the court? Can a partner apply to the court? Yes. Can a third party apply to the court? Yes. What are, this is one favorite question of the institute. Kitne baar I have seen this question being asked in the exam. What are the cases where the court may order for the dissolution of the firm? Bolo. Can I say permanent incapacity of an active partner? Yes. Yes. Or bolo. Business becoming illegal. Partnership becoming an illegal association. What else? Huh? Consistent breach of contract, perpetual losses, right? Deadlock in management. Except one, all are dead. Except one, all are insolvent. In all of these cases, the court can dissolve the firm. Now, what is the, before I do this, once the firm is dissolved, till when do we consider the firm is dissolved? When the partners decide or when public notice is given? So let us say on the 10th we decided to dissolve and on the 15th we gave public notice. Officially, when is the firm dissolved? 15th. When is the firm dissolved? 15th. Now, what is the order of payment? What is the order of payment? First I pay what? Outside liability. Then I pay what? Partner's loan. Then I pay what? Partner's capital. And if any surplus is left, distributed how? PSR. It is distributed in the PSR. समझ में आ रहा है? अगर firm का assets are not sufficient to pay up to the capital, it is a what? Deficit. In deficit, who contributes? Partners. In what ratio? Profit sharing ratio. Right? Pakka no profit sharing ratio. Yes. If a partner has both personal debts and partnership debts, his personal debts are first used, his personal property is first used to pay what? Personal debts and then partnership debts. Is it clear to everyone? Sure? Chale aage? Yes? Okay, so I just want you just to give the answer. Okay? Is question ka give me the answer. Just give the answer, not writing or anything. Uh-huh. How many of you say not valid? Okay, how many of you say it's valid? Oh, no one. So basically, PN company is registered as a partnership firm in 2018 with A, B, and P as partners dealing in sale and purchase. A dies, now only B and P continue the firm and same business with the same firm name. In the month of December, the firm they thought of hiring a new partner with the mutual consent of each other. Hence, they took a new partner. Is the firm a registered firm? Huh? Is the firm a registered firm? No. Is it a registered firm? Yes. Is registered. You have to pay attention to the words. Now, the firm has supplied a large amount of material to one of the clients, Mr. X, for business purpose. In spite of regular reminders, X failed to pay the debts due to the firm. In Jan 2020, the firm filed a case against X in the name and on behalf of behalf of P and company without fresh registration. With reference to Indian Partnership Act, discuss if the suit is maintainable by the firm. Suit by the firm is maintainable. No, why not? The firm is registered. See, if I want to file a case against the firm wants to file a case, 2 points have to be fulfilled. What? Firm should be registered and the partners suing should be named as partners of a firm. Correct? Here, firm is registered or not? Yes. But they took new partner and without fresh registration, they continue. So is S named as a partner of the firm? No. So is the suit maintainable? No. हो गया सबको समझ में आ गया? Yes. Can we move forward now? Yes. We'll start with the Companies Act. Okay. So starting with Companies Act. Again, another. How many marks chapter? Huh? 21. 20 to 21. So if we complete this, we have covered 32 plus what? 20 समझ लो. How many marks? Huh? 50? पक्का? 4-3 है भाई. 73 marks we have actually covered of the paper. Chalo. So let's start with Companies Act. So can I say Companies Act 2013 obviously talks about what? It talks about a company. Am I right or not? Yes, talks about a company. So tell me what exactly is a company? Clause 20 of the Companies Act defines the term company. What is company? Means a company incorporated under this act or any other. That means if I am incorporated in the year, let's say I'm incorporated in the year to 1993, am I still considered as a company? Yes, yes. So what are the characteristics of a company? सबसे पहला separate legal entity. The concept of separate legal entity is a company and member is different. A thin wheel called the corporate wheel comes between the company and the members. That means the company is not liable for the members are not liable for the company. Is it clear to all of you? The company is not liable for the members are not liable for the company. Can we lift the wheel? Yes, in certain cases, the wheel has been lifted. The next is what? Perpetual succession. Death of a member does not result in the death of the company. His legal heirs will become the shareholders of the company, and when they register the shares in their name, they become the members of the company. Then limited liability. I am only liable for the unpaid value of the shares held by me. And once I have paid that money, my liability comes to an end. When a perpetual succession pay now, 3-4 times I've seen they've asked question in the exam. In September exam also there was this question, M and N ka. 70%, 30% share, something like that. Both of them died. Both of them died? One died. I mean, something like that was there. So liability of the member is limited to the unpaid value. The moment I pay off all the price of my shares, my liability at that given point of time comes to an end. The next is what? I want to file a case against the company. Can I file a case against the company in my own name? In the name of the company, or do I need the name of the members to file a case against the company? In the name of the company. I don't need the name of the members to file a case against the company. So company, if I want to come, I can file a case against the company in its own name. Company can file a case against me in its own name. They don't need the name of the members to file a case. Then tell me, property of the company belongs to the company or it belongs to the members of the company? Property of the company belongs to the company. Members have no rights over that property. What is the next one? Separate management. Who is the owner of the company? Shareholders. But the company is managed by whom? Board of directors. The company is managed by a separate body called the board of directors. Why? Because the board of directors have an expertise. If every member could actually run the company, then they would be entrepreneurs and they would be having their own businesses. Correct or not? They don't have that expertise or skill to run the business. So when I talk about company, the board company is managed by a separate body, singularly known as directors, together known as what? Board of directors. Okay. Now, what is the next one? Common seal. Is it mandatory? No. And as of today, if the company does not have a common seal, the document shall be signed by 2 directors or it shall be signed by 1 director and one company secretary if the company has appointed a. So, Acha, tell me, is it or anyone can sign? Or if company secretary is there, signature of company secretary is mandatory. If company secretary is there, signature of company secretary is mandatory. But if company secretary is not there, then two directors will sign. Is it clear to everyone? Yes. I'm sorry. There are some companies जिनके लिए mandatory है. For others, it's not mandatory. So if you fall under the criteria of mandatory, then you have to appoint. Otherwise, नहीं करना. Criteria नहीं बता रही हूँ because अभी आपको समझ में नहीं आएगा what I'm trying to say, ठीक है? But not mandatory for every. But for some, it is mandatory. So if let us say mandatory you have appointed, document shall be signed obviously by the company secretary. If it's not mandatory, but still you have appointed, who will sign? Director and company secretary. If you have not appointed a company secretary, who will sign? Two directors. Clear to everyone? Yes. Now moving on to types of company. Can I say broadly every company is either a private company or a public company? Yes. And every company is either, each of this private or public company is either limited by shares or limited by guarantee or unlimited liability company. Correct? Now, what is limited and unlimited liability company? Limited liability means what? My liability is limited. It is limited to what? It is limited to what? It is limited. How do I know it is limited? Because it's given in the memorandum of association. How do I know it is limited? It is limited to the, how much is it limited? Unpaid value on the shares held by them. So let's say if I hold 10 rupees ka share, I have paid 6 rupees. What is my maximum liability? 4 into number of shares. And when am I liable to pay this? Whenever the company makes a call. When can the company make a call? When can the company make a call? Either during the course of business or during winding up. During the course of business, who will make the call? Board of directors. During winding up, who will make the call? Share liquidators. Shareholders कभी call नहीं कर सकते. Official liquidator. What is company limited by guarantee? अभी क्या होता है ना, if you try to write the definitions in your own word, you will change the meaning. Preferably stick. Definition है ना, the more you stick to the definition, the better it is. So tell me, company limited by guarantee. What is it? Here the members have made a promise to pay a certain amount as they respectively undertake. Undertake का मतलब क्या? Promise. How do I know how much each of them has taken? Because it is given in the memorandum. To contribute to the assets of the company. That means it's the cash I will give to you. When? When the company goes into winding up. Is it clear to all of you? Yes. Now, when I talk about company limited by guarantee, this company may be what? With share capital or it may be without share capital. And remember in the class I taught you if it is with share capital liability kya hoga, without share capital single liability, with share capital double liability, right? Is it clear to everyone? Yes. Unlimited liability company. What is unlimited liability company? Has no limit on the liability of the members. Has no limit on the liability of the members. Is it clear to everyone? Yes. No limit on the liability of the members. Okay. इस पे I want you to give the answer to this question. I think we have done. I don't know. चलो इसका बताओ answer. Just give me the answer. Writing will not do this. We'll write part later. दूसरा question. No limited private company is incorporated as unlimited liability company, having share capital of 10 lakh. One of its creditors, Samuel, filed a suit against the shareholder, Mr. Innocent, for recovery of his debt against no limit. Mr. Innocent has given his plea in the court that he is not liable as he is just the shareholder. Explain whether Samuel will be successful in recovering his debts from Innocent. How many of you say yes? How many of you say no? And the rest of you, what? If you remember, we had done this in the class also. When I say unlimited liability is what? Towards the company, not towards the outsiders. That means what? Means Mr. Innocent is a member of an unlimited liability company. That means he is liable to the company. But is he liable to the shareholder? Sorry. Will he be liable to the shareholder? No. Shareholder can sue the company and company in can turn sue the member. But can the third party directly sue the member? No. So it is unlimited towards the what? Towards the company and not towards the shareholder. Is it clear to everyone? Yes. Okay. So OPC. What is OPC? Which has only one person as its member, right? Who can form a OPC? Only a natural person who is an Indian citizen, whether resident. Okay, here I had told you in the class also, because they had given this question. It was September paper only, and I told you we will wait for the institute to give the answer, because institute had given a different interpretation in the books, in their book, right? So here, what they had given is only a natural person who is an Indian citizen, whether resident in India or otherwise, and has stayed in India for at least 120 days in the immediately preceding financial year. So if I read this, what does it mean? It is mandatory for you to stay in India for at least 120 days to become eligible to be a member of an OPC or to be the nominee of the OPC. Is it clear to all of you? Yes. Now tell me, where will I write? Why do I mention the name of the nominee? If the member is dead or incapacitated, who will become the member? Nominee will become. So that is why I put his name. Where do I put his name? In the memorandum. Can I just random put someone's name, or do I need to get their consent also? I need to get their consent also, right? So he will give a written consent. This written consent is filed with whom? With the ROC. Can I change my nomination? Yes. Can the nominee take back his nomination? Yes. And what happens in both the cases? In both the cases, what happens? We will have to search for a new nominee. I mean, he has to name a new nominee, right? Now tell me, the nominee, how many company can I be a member and nominee at one time? Only one company, right? Only one. Acha, is there any minimum or maximum capital requirement for an OPC? No. No. How many can I be? Now, how many companies can I be a member and nominee? One. Can I be a member of one, nominee of other? Yes. I can be a member of one and at the same time a nominee of other one, but only one. Can I become a member of two OPC? It can happen only because of nomination. Let us say there are two OPCs, OPC 1, OPC 2. X is the member of OPC 1, Chota X is the member of OPC 2. OPC 1 का nominee was Chota X. Possible or not possible? Yes. Possible or not possible? It's possible. Now what happened is, I repeat again, now what happened is that this X, Mr. X is Swaha. Any problem? Yes. Chota X has now become a member of how many OPCs? Two OPC. He's become a member of how many OPC? Two OPC. How many companies can you be a nominee of? One. But he has become of two. So within 180 days, he has to fulfill the requirement of the Act. What do I mean by fulfill the requirement of the Act? Come back to one OPC. Now, what are the restrictions? Can a minor be a member of an OPC? No. Nominee of an OPC? No. Can an OPC be a Section 8 company? No. Neither original registration nor future conversion. It can never be a Section 8 company. Can it carry the business of NBFC? No. It is always, it can, because NBFC का जो requirement it will never fulfill. So it cannot do the business of NBFC. Is it clear to all of you? Yes. So now tell me what about this? This answer. Now be careful with this answer, okay? Mr. A is an Indian citizen and his stay in India during the immediately preceding financial year is for 115 days. He appoints Mr. B. Okay, he's an Indian citizen. He's a natural person? Yes. Is he an Indian citizen? Yes. Whether resident in India or otherwise, and has he stayed in India for 120 days? No. So he fulfills these two conditions. He does not fulfill this. So can A start an OPC? No. See, please understand, as per this, no, it is mandatory that you have to stay in India for 120 days. So, can Mr. A start an OPC in India? No. Why? 120 days. He appoints B as his nominee who's a foreign citizen but has stayed in India. Okay. Nominee has stayed in India for 130 days. One condition fulfilled? Yes. Nominee is a natural person? Yes. Is he an Indian citizen? No. Can he be the nominee? No. So both answers is what? No. Is it clear to all of you? Can we go forward? Yes. Now, what is a private company? What is a private company? Which has a minimum paid up capital as may be prescribed, and by its articles restricts the transferability of shares. I told you why these words are important. Restrict means I can do subject to condition. Prohibits means I cannot do it. Prohibits the invitation to the public to subscribe in the securities. This is important from exam point of view, as in from for questions. Limits the number of members to what? 200. While counting this 200, joint holders are counted as what? Single members. And employees and ex-employees. Now please, if you put it only ex-employees, your answer is wrong. Ex-employees who acquired the shares while in employment and continue to hold them when after employment ceases shall be kya? Excluded. Is it clear to everyone? Most of the time if you get a question on private company, it's based on this only, right? It is based on this only. And ispe, I know you will now kill me for telling you to write so many answers. I am ready to die, but let's write this answer, okay? I know it's damn annoying. Parasnath Infra Height Limited is a public company having 215 members. Out of 215 members, 20 members were employees in the company during the, okay, they were employees from when? From 1st June 21 to 30th June 23. They were allotted shares in the company on 1st April 2017, which are held by them till today. That is 31st October 23. Okay, how many of you got the answer as they don't have to? So, first of all, out of this 215 members, 20 members are what? Employees. In this case, will these employees be counted or they will not be counted? Bolo. How many of you say they will be counted? Raise your hands. I want to see answers from everyone. How many of you say they will be counted? Yes. How many of you say they will not be counted? Okay. See what was given. If you see here, what was written? Employees who acquire the shares while in employment. So what they are saying is that when you purchase the shares also, you should have been an employee. What they are saying is when you purchase the shares also, you should be an employee. when they were employees from this period to this period, right? Right? When they were employees from this to this period, shares were allotted to them. Were they employees on this day? No. So will they be counted or not counted? They will be counted. So is the company required to reduce the number of members? Yes. Is it clear to everyone? Answers like this, second para is very important. Because in the second paragraph you are going to explain the whole counting part. तो उसको बहुत अच्छे से लिखना है आपको. समझ में आया? You want me to show how you are supposed to write this answer? ठीक है. Second paragraph. So basically, you have two options. Should I write the whole definition of Companies Act or only the limits the number wala part? Okay, you can write only the limits the number wala part. But if you write the whole definition, then you should write the whole definition. Like you have written restricts, you have written limits, you forgot to write prohibits. No, you should write all the 3 points then. So how will I write it? How many of you wrote how as per the provisions of Companies Act? How many of you wrote Partnership Act? Oh my God, Chavi, I see telepathy or I understand what you are going to do without even looking at your answer. Be careful. Which act? Companies Act. Okay. In the question, can it happen that a question may look like sale of goods ka bhi hai? Indian Contract Act ka bhi hai. Can it happen? Yes. So if that happens, they tell you as referring to the provisions of this act. So when they tell you, you are supposed to write as per the reference to that act. Is it clear to everyone? Yes. As per the provisions of Companies Act 2013, a private company, sorry, I was writing the whole definition actually. Should I write the whole definition? See, you have two options. You can write the whole definition or you just write the limits, the number. Generally, in the institute के answers में you will see they give the whole definition वैसे. ठीक है? In case of a private company, the number of members is क्या? Limited to 200. Provided that, first point, employees, don't just write ex-employees, it is wrong. Provided that employees and ex-employees who क्या? Acquired the shares while in employment and continued to hold them even after the employment ceases shall be क्या? Excluded. On the other hand, if you're writing the entire definition, how will you write? A private company means a company which has a minimum paid up capital as may be prescribed and by its articles. You go to the next line, restricts the transferability of shares. Next line, limits the number of members to 200. Next line, provided that joint holders are counted as single members. Next line, provided also further that persons who are in the employment of the company or persons who formerly being in employment acquired shares while in such employment and continue to hold them even after the employment ceases shall be excluded. Next line, C, prohibits the invitation to the public to subscribe in the securities of the company. This is how you'll write if you're writing the entire definition. Is it clear to everyone? How will I? मैं second paragraph लिखूंगी नहीं, but क्योंकि इस question में it plays a very important part. I'll just tell you how to write it. ठीक है एक बार. In the above case, Parasnath Infra Height Limited is a company with 215 members. Of these 215 members, 20 were employees. They became employees on this date, and the shares were allotted to him on kya this date. Okay? The company wants to convert into a private company. Since the employees had acquired the shares even before the employment, they will be counted in the total number of members. So the total number of members of Parasnath Infra Limited is 215. Next line, therefore. See, I have written whatever is given here. मैंने कुछ भी extra नहीं लिखा. But I have not written this public is a public company. ये वो जहाँ पे company incorporated under Companies Act. Not required all this. No? Therefore, Parasnath Infra Height Limited must reduce its number of members to convert into a private company. Is it clear to everyone? Yes. सबको समझ में आया? Can I move forward, guys? Yes. What is a? Can I move forward? Yes. What is a public company? What is a public company? Has a not a private company, has a minimum paid up capital as may be prescribed. This one, company which is a subsidiary of a, that means if my holding company is a kya, public company and my subsidiary is a kya, private company, right? The can I say the subsidiary will be deemed public company. In its articles, is it a public company or is it still a private company? Still a private company, but Companies Act will apply as if it is a public company. समझ में आया सबको? Yes. Can we move forward? Yes. Small company. What is a small company? What is a small company which is not a public? That means, can I say a private company includes and limits the number to 200? Is this you cannot forget to write except in the case of kya OPC. That means, can I say an OPC and a small company is also a private company? Am I right or not? Yes, that is also a private company. Okay. Public, a small company which is not a public company. That means what? It has to be a private company. Correct? And has दो limits है. Just two limits, remember. Paid up capital not exceeding how much? 4 crore. Turnover. Turnover can I take today's or as per previous year? Previous year. And it's taken from what? PL. PL of the preceding financial year does not exceed 40 crore. Instead of writing the definition like this, can I write here only 4 crore? And can I write here only 40 crores? Am I right or not? Yes. Then in that case, I don't have to add this. Correct? Can I directly write here 4 and 40 crores? Someone in this class, was it someone from this class who had messaged me, ma'am, in the book, this is the limit given, huh? क्लास में पढ़ाती हूँ तब ध्यान किधर रहता है? हाँ, हाँ. Now, however, this clause shall not apply to a what? Holding and subsidiary or a Section 8 company or a company governed by special. If I put it in simple terms, what they are trying to say is, if these companies fulfill the requirements also, they will never get the status of a small. That means they will never enjoy the benefits of a small company. समझ आ रहा है सबको? Yes. So I won't ask you to write. It's basically very chiller copying that. But ये बता दो आंसर क्या होगा? What is the answer? Can it avail the status of a small company? ABC Private Limited. Chalo, it's a private company registered under the Companies Act with a paid up capital of how much? 35 lakh. What is the maximum limit? 4 crore. So is it within the limit? Yes. Turnover of 2.5 crores. What is the maximum limit? 40 crore. Is it within the limit? Yes. Will it get the status of a small company? Yes. See, they have also given, also discuss the meaning of a small company. They have also given what? Discuss the meaning of small company. इसका मतलब क्या? You have to write the entire definition. So here you cannot write only what? The limit. You cannot say this is the relevant part of the question. No, you have to write even this. Is it clear to everyone? Because they've asked you to explain the meaning of small company. You have to write the entire definition. I hope it is clear to everyone. Can we go forward, guys? Yes. Yes, बोलिए ना. हाँ हाँ, many questions are there in the substance. कुछ कुछ इधर उधर इंटर का भी हो सकता है, but mostly are there in the substance. ठीक है? Okay. Can I just yes. So moving on to the next one. What is holding, subsidiary and associate? पहला तो we know holding and subsidiary is what? Interrelated. If I am your holding, you are my subsidiary. Correct? If I am your holding, you are my subsidiary. They are interrelated. What is holding? A company said to be the holding of another if such other is a subsidiary. So it does not tell us really. It just says that we are interrelated, but does not tell us how you become subsidiary. So let's see the definition of subsidiary. It says a company is in relation to the company. Holding company means a company in which the holding company control. So who is controlling the composition of the board of directors? Who is controlling the composition of the board of directors? Is it the holding company or is it the subsidiary company? It is the holding company. What is control the composition of the board of directors? What is controls the composition of the board of directors? The right to appoint or remove the majority of the directors. What is controls the composition of the board of directors? The right to appoint or remove the majority of the directors. Exercises or controls more than one half of the total voting power. Share capital में लिख के आ जाना वहां पे. The word, this is the key word. Total voting power. Either on its own or together with one or more of its subsidiaries. So let's say I directly hold 51%. Are you my subsidiary? Yes. I hold 20%, but my subsidiary holds 40%. Are you my subsidiary? Yes. Because through my subsidiary, I'm holding how much? 40%. I hold nothing, but my subsidiary holds 60%. Subsidiary or holding? Yeah. Am I the holding? Yes. समझ में आया सब तीनों cases? Yes. Now, what is associate company? Associate company means a company in which the other company has a what is significant influence? What is significant influence? Control of at least kya? 20% of the total voting power or business decisions. Not being a subsidiary. What it means is 20 to 50 associate, more than 50 subsidiary. Clear to all of you? Yes. What is a government company? Please, not less than 51%. देखो please, यहाँ पे क्या था? More than one half. इधर क्या था? More than one half. Whereas here it is what? Not less than 51% of the paid up share capital is held by whom? Central government, state government, or both of them. Central government, state government, or both of them. Now tell me, and includes a company which is a subsidiary of a government company. That means if you are a subsidiary of a government company, you are automatically a government company. What is foreign company? Incorporated outside India but has a place of business in India. What do I mean by body corporate? What do I mean by body corporate? Body corporate means a company incorporated in or outside India. Is every foreign company a body corporate? Is every foreign company a body corporate? Yes, because it's a company incorporated outside India. Is every body corporate a foreign company? Why not? Okay. Because body corporate means incorporated outside India. But foreign company is incorporated outside India and having a place of business in India. But when I say body corporate, you may or may not have a place of business in India. Is it clear to everyone? Yes. What is foreign company incorporated outside India, having a place of business in India? एक लास्ट क्वेश्चन दे रही हूँ फॉर द डे यू विल राइट आई मीन और नहीं लिखवाने वाली हूँ ये लास्ट आज के लिए क्वेश्चन मिल जाएगा हाँ ये वाला थैंक यू okay I think I have given you enough time moving on the state government of X a state in the country is holding 48 lakh shares of Y limited the paid up share capital of Y limited is 9.5 crores 95 lakh shares of 10 each Y limited directly holds 2,50,600 shares of Private Limited which is having share capital of 5 crores in the form of 5 lakh Z Private Limited claims the status of a subsidiary company of sorry Z Private Limited claimed the status of subsidiary company of Y Limited as well as government company. Advise whether Z Limited is a subsidiary and a government company.
Yes.
Is it a subsidiary?
Yes.
Yes. Is it a government company?
No.
Are you sure?
Yes.
Government company नहीं है?
No.
अच्छा, what all provisions will you write here? Huh? What all provisions will you write here? Can I say this is actually a 7 marks ka question? Yes or no?
Yes.
Can I say this is a 7 marks ka question? Yes. This question is actually and iska answer. You really have to like not miss out on whatever is like I mean on all the what do you say all the provisions here. So basically here what all the provisions are there? Can you please tell me? Holding subsidiary government होल्डिंग सब्सिडियरी गवर्नमेंट तीनों का प्रोविजन लिखना है एज पर कंपनीज एक्ट 2013 और यू कैन राइट एज पर सेक्शन 2 क्लॉज 45 है ना गवर्नमेंट कंपनी का यस यस अ गवर्नमेंट कंपनी means a company in which not less than कितना 51% not less than 51% of the paid up share capital is held by central government one or more state government partly by central government and partly by state government and includes a company क्या which is a क्या होगा which is a subsidiary of a government company ये हुआ मेरा एक provision please don't write first holding company then government company then subsidiary company it's not wrong or anything but एक presentation होना चाहिए answer का if you are writing government first write government then holding subsidiary if you are writing holding first write subsidiary then government समझ में आया yes don't miss this line because this is the line which gives us the answer right so the next part as per section 2 clause 46 a company is said to be the क्या holding of another if such other is its subsidiary this is holding company का definition next Is it preferable to go to the next line and write the provision or same line, next line? अभी imagine मेरा आंसर इधर खत्म हो गया. I wrote answer 2, it ends here. I wrote answer 2A, it ends here. ठीक है? अभी answer 2B, should I start? Yo, don't waste page. Answer 2B. Should I start from here only? No. Please go to the next page. Generally start every fresh answer with a fresh page. But yes, abhi just 2 lines you have written here. Then is it okay if I start? Yes. But otherwise, always start with the next line. Don't forget to write your answer numbers. Either likha, lekin, write it in the column, whatever. But also write answer to question 2 ऐसे करके. So that even if this portion is missing, this portion will not be missed by the examiner. So that he can know. Even let's say you tie the paper, he couldn't see that side में क्या लिखा. At least if you have written like this, he knows what you have written. So be careful about all these. These all small things makes a huge difference. Can you underline the keywords? Can you underline the keywords in the provision, in the case study, connecting the case study? Yes. Can you use red color pen, blue color pen, pink color pen? Huh? No. Only use your black color pen or the pencil. Okay? As per section 2, clause 87, a company is said to be the holding, sorry, is said to be the subsidiary of another if the holding one controls the composition of the board of directors. Second, exercises or control. Since I remember the whole definition, I will write as it is given. Exercises or controls more than one half of the total voting power either on its own or together with one or more of its subsidiary. This is my provision. This is my provision. So 6 marks the question and so the provision should also be worth it, no? Correct? Can I go forward? Yes. I want to discuss this once case आपके साथ में हो गया ये definition ही लिखा है. I've just written the definition. Okay. So coming back here, here what the question is saying is, so where is the nahi company Y Limited. What is the share capital of Y Limited? What is the share capital of Y Limited? 95 lakh shares. And this state government is holding how much? 48 lakhs. Is it 51% se zyada? I mean, is it 51% or more? No. I think it is 50 point something. Yes or no? Yes. So my question is, Y Limited, is it a government company? Is it a government company? No. Now here they have given another case. What is the other case? There is one other company. What? Z Private Limited. Z Private Limited has a share. कितना shares है उसका? 5 lakh. Of which 2,50,600 is held by whom? Why? Can I say Z Private Limited is the subsidiary of Y Limited? Yes. Why? Because it is more than 50%. But government के लिए minimum कितना चाहिए? 51. Please, there is a difference of 0.9%. Be careful. ठीक है? So So Z Private Limited claimed the status of a subsidiary company. Can it claim a status of a subsidiary company? Yes. In this case, if, okay, I repeat again, in this case, if Y Limited was a government company, can I say that Z Private Limited would also be a government company? Yes. But is Y Limited a government company? No. So, can Z Private Limited claim the status of a government company? No. Clear to everyone? Hello? Yes? तो ये ना मुझे अब मुझे वो क्वेश्चन ढूंढना पड़ेगा. I wanted to discuss this question. कल कर अभी कहाँ? I'm not leaving you now. This was a question in the ये हमने क्लास में डिस्कस किया है. Let's see how many of you actually give the right answer. That's what I want to see. लिखना नहीं है, सिर्फ आंसर देना है. ठीक है? Already done this. This one. You guys, we had done the same question in the class. What is the definition of government company? Where government, whether central or state, is holding 51%, right? Same example I have given you in the book also. बड़े प्यार से 3 situations लिखा था. वो situations which went out of your head immediately after you had written it. Am I going to count this government of India? Yes. Am I going to count this LIC? No. Am I going to count Tamil Nadu, Rajasthan? Yes. ABC Limited? No. Because it is not government. Government company is not government. Are you understanding? I've given an example in the class. Nikalo government company ka example. That X Limited wala case. 3 situations I had given. Take out that example. So moving on to the next one. What is a Section 8 company? What is the objective? To promote sports, science, arts, religion, charity, commerce, technology, environment. Do these companies distribute dividend? No. What do they do with the profits that they earn? They reinvest the profits into the business. Now tell me, can you just become a Section 8 company or you have to apply to the government? Apply to the government. Apply to the government to become a Section 8 company. Government will allot you a license. The moment the license is allotted, you are a Section 8 company. Do you need to use the word limited or private limited after your name? No. Can a partnership firm also become your member? Yes. Can a partnership firm also become your member? Yes. Can I alter my MOA AOA? Yes, but in this case only with the approval of the central government. In this case only with the approval of the central government. Now tell me, if the company is doing something which is fraudulent, तब क्या होगा? Or it's breaching its objects, then what will happen? Then what will happen? Central government will revoke the license. Tell me, if the central government revokes the license, क्या होगा? If the central government revokes the license, क्या होगा? It may either be ordered to convert into a private or a public company. Acha, once it converts into a private or a public company, can I say it should use the word private limited or limited after its name? Yes. And they should inform the registrar so that he can make the changes. Second, it can amalgamate with another Section 8 company but with similar objects, or winding up of the company. In case of winding up, the surplus is given to another Section 8 company or it is transferred to IBF, Insolvency and Bankruptcy Fund, under the Insolvency and Bankruptcy Code, right? But these are two very grave steps, so it can be done only in the public interest. However, no order will be passed before giving the company an opportunity of being heard. Clear, all of you? Huh? What is a dormant company? कितना टाइम हो रहा है? What is a dormant company? Which is formed for a future project or to hold any assets, including an intellectual property right. Now tell me, a dormant or an inactive company does not have what? Significant accounting transactions. Does not have any significant accounting transactions. What is significant accounting transactions? Other than this four, everything is significant. What? Payment of fees to the registrar. Payment to fulfill the requirements of this act or any other act. Then, sorry, allotment of shares to fulfill the requirements of this act. And what is the fourth one? Maintenance of office and reports. What is an inactive company? Which is not carrying any business operations. Then what? Which has not made any significant accounting transactions in the past 2 financial years. Or a company which has not. So basically, no, after my annual general meeting, within 30 days, I have to file financial statement. Within 60 days, I have to file annual returns, right? If for 2 consecutive years, I have not filed it, then I am a inactive company, right? So can the government registrar give you a notice that you are not doing any business? We are going to declare you in dormant company or inactive company. Yes. Or you can yourself go and apply to the registrar कि भाई मुझे तो क्या बोल दो? Give me the status of a dormant company. Clear to everyone? Yes. इसका आंसर बताओ तो. XYZ Limited was incorporated to hold the patent for a new product. The company is expecting to start its commercial production within the next 2 years. In the meanwhile, for timely installation, they want to start it in the next 2 years. Okay. For timely installation, the company has placed the purchase order for plant and machinery with a down payment. Isn't it a significant accounting transaction? Correct or not? Yes. But ma'am, you said to hold an asset. To hold an asset means when the purpose of incorporating the company is to hold an asset. Here they have started it for they have incorporated it to hold the patent. The motive of starting the company was to hold the patent. But was the motive of the company to hold the plant and machinery? No. I mean, was it incorporated with this motive? Had it been this plant and machinery and this patent to hold it, then it would be dormant company. But after incorporation, they purchased this machine. So what is it a significant accounting transaction? Yes. So can the company get the status of a dormant company? No. Is it clear to all of you?
Incorporated to hold a plant and machinery.
I'm sorry?
Can it be incorporated to hold a plant and machinery?
Yes. But that should be the motive of incorporation then. Like it was incorporated to hold the patent. So for this patent, it is not dormant, it is a dormant company. But after incorporation, they got plant and machinery. So the motive is what? To do business. You have made a significant accounting. But had the machinery been purchased and at the time of purchase we incorporated the company to hold the machine, then it would have been what? Then it would have been a dormant company. Okay? Clear with you? Chale next topic pe. Yesterday we are done till dormant company. So can we continue today? Yes. So continuing today, incorporation of the company as given under section 7, read with company's rules. Now what does section 7 actually say? First of all, section 3 says that we can incorporate a company and this company may either be may have one person in case of OPC, minimum 2 persons in case of private and minimum 7 persons in case of public. And this company may be what? Limited by shares or limited by guarantee or an unlimited liability company. Now section 7 gives us the procedure for incorporation. What section 7 says is, we will file an application in what form number? Spice Plus. We'll file an application in which form number? Spice Plus, right? So when I say Spice Plus, we have 4 applications in this form. Then along with this Spice Plus, we have to file these documents. What? MOA and AOA. Second, a declaration has to be filed. Now, who will file this declaration? CA, CS or an advocate who has been engaged with the formation of the what? Company and CMA, and also any one of the director or manager. What? That we have fulfilled all the requirements of the acts. That means whatever the Act says relating to incorporation, we have fulfilled all of it. Correct? Then we have to give a declaration. This declaration will be given by whom? This declaration is given by whom? Every director and subscriber. This declaration is given by whom? Every director and subscriber. What? Three declarations are given here. First, that I have not been found guilty of any what? Offense in the incorporation of any company. Second, I am not guilty of fraud or breach of duty in the management of any company. And third, all information given is true to my knowledge. Then we have to give an address for correspondence where the ROC, if we have an office, we will give the office address. But if we don't have an office, we will have to give an address for correspondence where they will communicate with us. Then details of subscribers. What type of details are given here? Name, surname, family name, address, occupation, photo ID. And if the subscriber is a body corporate, we provide the SIN number. Then details of what? Directors. What are the details of directors that are given? Name, surname, family name, address, occupation, photo ID. And can a body corporate be a director? No. So the director is always an individual. But here what we do, we provide a DIN. Then can my director be a director of any other company? Yes. Shareholder of any other substantial holdings? Yes. Can he be a partner of any firm? Yes. So those details have to be given. And the consent of the director has to be given that he's agreeing to act as a director. Here basically there are 3 Ds. D1, 1D, 2D, 3D. Abhi 1D, 2D, 3D kya hai? First D, 1D is documents, MOA, AOA. Second is 2 Ds are the declarations. Then 3 Ds are details of what? Address. Then details of subscribers and directors and details of interest of holding of directors. So these are the informations that we provide. We will file it with whom? ROC. What will the ROC do? He will issue a, kya issue karega wo? He will issue a what? Certificate of incorporation and he will allot a SIN. This certificate of incorporation is an evidence. See, in LLP, the certificate of incorporation is the conclusive evidence. But here, is it the conclusive evidence? No, it is just an evidence. Evidence of what? It is an evidence of incorporation. It is the evidence of what? Incorporation. Okay? Now, if the company is incorporated after giving false or incorrect information, I can find out that the information given is false or correct either before the incorporation or kya? After the incorporation. If before the incorporation I come to know that the company has given false information, then every person who kya? Signed and who is aware shall be liable under section 447. 447 is one section where it is both fine and imprisonment. Then if after incorporation I come to know, then the promoters, the persons, every person who have signed the document is liable under, see what is the difference? Here they are saying only if you are aware. Here doesn't matter you are aware or not, you will be liable under section 447. Are you getting my point? Yes. Then tribunal can pass any of the orders against the company. First, pass an order for the regulation of the what? Management. Can it say remove the directors, appoint new directors? We will appoint the directors. Directors will act as per our orders. Anything. Anything, right? Second, direct that the liability of the member shall be what? Unlimited. Can it remove the name of the company? Yes. Strike off the name of the company. Then also pass an order for what? Winding up. And this is obviously an open-ended point. Apart from this, if they feel any other order should be passed, can they also pass that orders? Yes. Now, the moment a company is incorporated, a thin wheel called the corporate wheel comes between the company and members. That means what? The member is not liable for the company is not liable for the member. However, in certain cases, this wheel is lifted. Where say this wheel, can we say the wheel is lifted here also? Wheel is lifted means what? The member has unlimited liability. Correct? Here, when the order for members liability unlimited is passed, can we say here also the wheel is lifted? Correct or not? Yes. But in this, what we are basically going to study is what? All the judicial cases where the wheel is lifted. Is it clear to all of you? Yes. The first case where the wheel is lifted is protection of revenue. When the company has been formed to avoid the payment of revenue. Right? Where the company has been formed to protect the payment of revenue. Do you remember the name of the case? Sir, Sir Dinshaw Manikji Pettit. And you know what? There is one Indian law also for this. If you don't remember this case name, you can remember this also. What? Jugilal versus Income Tax Commissioner. अगर इनके cases याद रहे तो it will be good actually. So where the motive of forming the company was to avoid the payment of taxes, the wheel can be lifted. Where the company is a sham or a fraud. The name of the case was what? Guilford Motor Company versus Horn, right? And there was one more case, Jones versus Lipman. So in Guilford Motor Company versus Horn, the employer has asked his employee that after you quit our job, you cannot deal with my clients. But after quitting the job, he started a company, and through this company, he started dealing with the clients. So can we say the wheel can be lifted for the new company? Yes. And in Jones versus Lipman, the contract was made just to avoid performing. A company was formed just to avoid performance of a contract. The wheel was lifted and the court ordered to perform the contract. Where the company is formed to avoid welfare legislations. What was the name of the case? Workmen of Associate क्या? Rubber Industries Limited, Bhavnagar versus the Associate Rubber Industries Limited, Bhavnagar. So this was a case between employer and employee. When you have formed a company so that you don't have to pay in this case, what happened? They formed another company, subsidiary company, to pay less bonus. So it is formed to avoid welfare measures. So the wheel was lifted. And the last one, to determine the true character of the company. What was the name of the case? Daimler Company Limited versus क्या? Continental Tire. Is tire or rubber and tire, or tire and rubber? Tire and Rubber Company Limited. Correct? In this, here the company was not formed for any unlawful purpose, but the wheel was lifted just to determine the true status of the company, that whether it is an enemy company. Okay? Any case you want me to explain in details? नहीं? इसका एक question थोड़ा सा देखते हैं, because we have actually not done any question on. We have never written question on this topic, right? So how you will make a reference to the case law if you remember? Let me just discuss one case on this with you. Let me see if there is. There should be one case. This one. Just seeing if there is anything. This one. Okay. So we had discussed these two documents, memorandum and association. What is memorandum? Memorandum means the memorandum of association of the company as originally framed and altered from time to time. There are how many clauses? 6 clauses. What is the first one? Name. Then office clause, right? Just remember no clause. Object clause. Then Liability, capital clause, liability clause, and association clause. So tell me, when I say name clause mentions the name of the company, registered office clause tells us the location of the company, object clause tells us what is the purpose of forming the contract and any object which is ancillary to it. Capital clause tells us the capital of the company divided into the number of shares. Liability clause tells us what shall be the liability of the member, limited, unlimited, whatever. Achha, if the company has no share capital, can I say this clause will not be there then? Correct? Association clause is basically the members, they give a declaration that we are forming this company. One more thing, if you are an OPC, you will also have a nomination clause. This is only in the case of OPC. Articles of association means what? Articles originally framed and altered from time to time. Now this is important here. Entrenchment clause. Important matlab isko samjho. What do I mean by entrenchment clause? Entrenchment means to provide something more what? More secure. To make something more secure. So when I actually talk about entrenchment clause, when the law says actually articles can be altered by passing a special resolution. What is special resolution? What is special resolution? 75% votes in favor. What is special resolution? 75% votes in favor. So a company can actually, you can pass a resolution, you can alter your, you can alter your articles by passing a special resolution. Lekin, it may happen that the Companies Act gives a right to the members. If you want, you can make a provision that one particular clause of the article will be altered by more strict provisions. That means what? This is my articles of the company. These are the clauses of my company, right? All the clauses, if I want to alter, how will I alter it? Special resolution. How will I alter it? But this one clause I have said that to alter it, I need 90% consent. That means what? The rest of the clauses will be altered by 75%, but this will be altered only by 9. This is known as what? Entrenchment clause. How can I add this entrenchment clause? Can I add it at the time of formation of the company? Yes. Let's say I did not add it at the time of formation. Can I add it later as an amendment? Yes. For this amendment, I need the approval of, in case of a public company. How can I amend my articles? How can I amend my articles? Special resolution. So public company, what resolution? Special. But if it is a private company wants to add an entrenchment clause, it needs what? Consent of all. Clear? And we have to give a notice to whom? Registrar. Did you understand it? This special resolution and consent of all is what? To add the entrenchment clause. Right? Can I move forward? Yes. Now we have the object clause of the article, of the memorandum. When you make any contract which is within the object clause, it's fine. But if you make any contract which is against the object clause, such a contract is what? Such a contract is what? Void. Such a contract is what? Void. Are you getting what I'm trying to tell you? Yes. It is known as what? Ultra. Ultra means what? Beyond. Wires means what? Powers. It is beyond the powers of the company and hence it is void. The name of the case was Ashbury Railway Company versus Ritchie. This is one case you need to remember. So in this case, so I'll just give you, I won't go, you don't, case, I won't discuss this case, rather I'll give you a very simple example. You started a business of coaching. That was your MOA. Your MOA only says, I will what? I will give classes for professional courses. That's it. You rented a building. Later you refuse to pay the rent. Can the owner sue you for the rent? Can the owner sue you for the rent? You have taken a loan. You have taken a loan, but you are not allowed to take the loan. You took the loan, money is remaining. Actually, it is an ultra vires loan. Can the outsider sue you? No. Ma'am, how will the outsider know what I'm allowed to do or not? Comes doctrine of constructive notice. When I file a document with the ROC, it's a public document. And it is deemed that every person dealing with the company knows about it. Under section 399, it becomes a public document. So company was not allowed to take a loan, but it took the loan. Now the money is not utilized by the company. Can the lender recover that money from the company? Yes. Yes. And the last point, company has taken an ultra wires loan, but it is used for some lawful debts. Then the lender steps into the shoes of the creditor for the lawful part. So iska we will just discuss a question which was there in the September exam, I think it was there. So I just want you to give me the answer to this. We will not write this, but JV borrowed a secured loan of 5 crore from Star Bank Limited. To meet its working capital, however, the borrowing powers of the company was restricted to 1 crore. Okay, before I actually decide, Atma will come and give you the answer or what? Huh? Huh? Kash aisa ho sakta na? I would be like, in multiple. The borrowing power of the company under its MOA was restricted to how much? 1 crore. The bank released the loan amount in 2 installments of 1 crore and 4 crore. अच्छा एक बात बोलो, can I say this 1 crore can be recovered, correct or not? Everyone, वो AC में आपका कोई काम नहीं है, वो ऑफ हो जाएगा, आप नहीं देखोगे तो भी ऑफ हो जाएगा. आप So, can I say the loan was taken in 2 installment? Can I say this 1 crore? This is payable by the company, correct or not? Yes, because it is what? Intra wires. Whereas this 4 crores was actually ultra wires. On the due date for payment, the company refused to accept the liability of 5 crores on the grounds that the borrowing was ultra wires. The company's books of accounts show that the company has utilized the loan amount of how much? 3 crores for repayment of lawful debts. The utilization of the remaining 2 crores cannot be traced. Right? The utilization of remaining 2 crores cannot be traced. Correct? So, referring to the provisions, write down how much can the company recover. How much can the company recover? See, 1 crore though is intra wires. Right? That though they can recover. Correct? This 3 crores is for what? Lawful debts. Can they recover this also? Yes. How much can they recover? 4 crores. समझ में आया कैसे 4 crore? You would say, but ma'am, only 3 crores was traceable to lawful debts. So out of 4 crore, 3 crore was traceable. And 1 crore was intra wires. So how much can they recover? 4 crore. Is it clear to everyone? Yes? Chale aage. Now doctrine of constructive notice also done. Do you have any doubts in this? Clear all of you? Yes? Now indoor management. What they say is, as an outsider, I should know whether the company has the power to do something or not. But how the power was given, how the power, if they have to pass some resolution, whether that resolution was passed or not, how am I supposed to know that? So if there is any defect in the indoor management, can I hold the outsider liable? No. I repeat again, let's say It is given that Yeshas Academy can do this act. As an outsider, I only have to check whether Yeshas Academy can do this act. How the power to do the act was given is not my concern. So whether they have followed whatever was given to do the act or not, that only they know. How do I know? So I am not responsible for the internal management. I repeat again, I am not responsible for the internal management. So when we talk about doctrine of indoor management, can I say indoor management protects the protects the outsiders against the company. So if there is any defect in the internal management, I am not responsible. And this case was laid down in the case of what? Another case name that you need to remember, Royal British Bank versus Turquoise, or simply put, the Turquoise rule. What happened in this case was the bank was allowed to issue bonds, but to issue a limit tak. Beyond the limit, they had to pass special. They had to get the consent of the shareholders. They issued the bonds, but did not take the consent of the shareholders. This Turquoise, he wanted to encash the bond. They say we are not liable to pay. Are they liable to pay that money or not liable to pay the money? I repeat again, the bank was allowed to give the issue bonds. But beyond the limit, if they wanted to give the bonds beyond limit, they have to take the consent of the what? Shareholders. They issued it, but no consent was taken. They issued bonds, but no consent was taken. Now, Turquoise took the bond. Actually, it was not Turquoise. He was a liquidator for the person who took the bond. So Turquoise goes to the bank to get the money on the bond. Bank says, we never took the consent, not liable to pay. Are they liable to pay or not liable to pay? They are liable to pay. Because you are internal, I am not responsible. So you did not take the consent, that was your fault. As an outsider, do I have to check whether they can issue the bonds or not? Yes. But how they got the right to issue the bonds is not my concern. Is it clear to all of you? Yes. However, law में क्या होता है? Locha. Because of this, many people started misusing, so they came up with these lochas. Tell me, you know, resolution was never passed. Can you say, I don't know? Not my liability. No. When you know there is some irregularity, can you claim any relief? No. When you are negligent, if you remember, the house, the security guard, you gave the money to the security guard to book the flat because it was written officers. Okay. Remember, you wanted to purchase the house, you gave the advance money to the security guard to book the flat. The security guard, you gave the advance money to the security guard to book the flat. Can we, and then you say your MOA said I could give it to your officer. Can you compare the officer to the security guard? No, no. Then the next one, forgery. Do you remember Hasina Wano? Yes. And the last one, you don't know about MOA. So if you don't know about MOA, can you claim any relief? No. It is your duty to know. What is share? A share is a share in the share capital of the company and includes stock. What are the different types of shares that we have? Equity and preference, right? What is equity? Which actually life itna easy hota. What? So how pleasant life would be? Which is not equity. Ayo, which is not preference. What is preference shares? Which is not equity. Which gets preferential right. When? When does it get preferential rights? In the repayment. Repayment when? During winding up or in the payment of dividend. That means first we will pay dividend to preference and then to equity. And in repayment, if a company goes into winding up, we'll first pay the creditors, then we'll pay the preference shareholders, and then we will pay the equity shareholders. Do I really need to explain these things? Naina? So with this, we are done with Companies Act. Sale of Goods Act 1930. What was the date of enforcement of Sale of Goods Act? 1st of July. Now, when we talk about Sale of Goods Act, Can I say Sale of Goods Act deals with a contract of sale? Am I right or not? Yes. Contract of sale deals with a Sale of Goods Act deals with a contract of sale. What do I mean by contract of sale? Ownership of the goods is what? Transferred. What do I mean by contract of sale? Ownership of the goods are transferred. Now, is it ownership is transferred immediately or is it ownership is transferred on a future date? It could be both. Ownership can be transferred immediately or it can be transferred on a future date. When it is immediately, it is what? Sale. Future date. Why future date? Because some conditions have to be fulfilled. It is what? Agreement to sell. Transfers or agrees to transfer the property in the goods. When I say property in the goods, what do you mean by property in the goods? Ownership. What do we mean by property in the goods? Ownership. To whom is it transferred? To the buyer. And what does the transfer take place for? For a price. So if I look at this definition, do I get the essentials of a valid contract of sale? Yes. Seller. Who is a seller? Who sells or agrees to sell. Who is a buyer? Who buys or agrees to buy. Then next, whose ownership will be transferred? Goods. So when I say goods, what do we mean by goods? What do I mean by goods? Goods means any what? Movable goods. Goods means what? Any movable goods. And when I say movable goods, right, it does not include what? Money or actionable claims. Does not include money or actionable claim. Is service also included in goods? No. Now, anything which is a part of the land, is it considered as goods? Yes, provided we detach them from the land at the time of sale. Provided we detach them from the land at the time of sale. Now tell me, what are the different types of goods that we have? Existing, future, contingent. What is existing? When the contract is made, I have these goods. When the contract is made, I have these goods. What do I mean by future goods? I don't have these goods. I don't have these goods. But after the contract is made, if I am a producer, I'll produce them. If I'm a manufacturer, I'll manufacture them. If I am going to get it from someone, I'll get it and sell it. So I don't have the goods. After the contract is made, I'm going to acquire them. What is contingent goods? I don't have them. I don't even know whether I'll get them or not. If I get them, I will sell. If I don't get them, I will not sell. I want to sell you this pen. What type of goods are these? Existing. I will sell you the pen which I buy from the shop. Future. If the seller is willing to sell me the pen, I'll sell it to you. Contingent. Clear to all of you? Now, existing can, please always remember, specific, ascertain, unascertain is for what? Existing. Existing can further be classified into specific, ascertain, unascertain. I go to the shop and I say, I want this pen. What type of goods are these? Specific. I've identified them. When I point out, identify. When I give a description, I want a surface metal body red color pen. What type of goods are these? Unascertain. So basically, what is specific goods? In case of specific goods, I'm identifying them. In case of unascertain goods, I am what? Describing them. Now, as per my description, when the shopkeeper takes out the goods, what has the shopkeeper done? He has ascertained. So it is always unascertain goods which are what? Ascertained. Now, what is the next essential? Price. Price means what? Price means what? The monetary consideration. Price means what? The monetary consideration. Correct? Now, when we talk about price here, I'm not talking about what is price that we all know. I told you monetary consideration means what? The legal tender of the country at that time. At that given point of time, whatever monetary currency we are using in the country. So if I use 2000 ka bhi currency note, is it considered as money? No. Now when I talk about money, how do I fix the price? Can it be fixed by the agreement? Yes. Yes. Parties mutually agree on the price. Can it be fixed by mutual dealings? It may happen that we don't fix the price, but we deal with each other on a regular basis. And because we deal with each other on a regular basis, we have terms using which we can fix the price of the goods. For example, I always sell you the goods at 10% below the market price. At what price will I sell you the goods if I don't fix the price? 10% below the market price. Can the price also be fixed by a third party? Yes. Now, if the third party refuses to fix the price, bolo kya hoga? The contract becomes void. Right? If any party prevents the third party from fixing, then what? If any party prevents the third party from fixing, then what? They are liable to give damages. To whom? If the seller is preventing, then he will give to the buyer. If the buyer is preventing, he will give to the seller. Correct? If the price is not fixed in any of the following manner, are you sure? Now there was this one question. Really sorry, you have to keep waiting for me to. Thank you so much for being so kind. Huh. Can you see this question? I'm sorry, you have to actually. छोटो सा question के लिए we taking so long, huh? What is the answer? A contracted to sell his Swift car to B. Both missed to discuss the price of the Swift car. Later, M refused to sell the Swift car on the grounds that the price was not fixed. Can he refuse to sell or is he bound to sell? Are you sure? When the price is not fixed, what price should you pay? You should pay a reasonable price. So, in that case, you must pay a reasonable price. Is it clear to everyone? Yes. When I talk about contract of sale, obviously every contract means what? Performance. When I say contract of sale, there is a performance of the seller and there is a performance of the buyer. Can you tell me what is the seller's performance? Can you tell me what is the seller's performance? Delivery. And what is the buyer's performance? Payment. And always remember, delivery, time of delivery is of essence. Time is of essence, whereas time of payment is what? Not of essence. This is given by law, I'm not saying it. Now moving on, what is delivery? What is delivery? Voluntary transfer of the possession of the goods. It's not statutory, it's not mandatory, it's voluntary. That is the word used. So if you write not just delivery also. So if you are getting a question on delivery, you should always start with delivery is the what? Voluntary. That word should be there. Voluntary transfer of the possession of the goods. There are three types of delivery. What is the first one? Actual. What is actual? Physical possession of the goods are transferred. The goods are physically handed from the seller to the buyer. What is symbolic? What is symbolic? Sorry. What is symbolic delivery? Means of I don't give you the goods, but I give you certain means using which you can take the delivery of the goods. That is, for example, what? Keys or document of title. Now, what is the next one? Constructive. I'm not giving you the goods. The goods are where they are. Just by acknowledging the goods are delivered. This is what? Constructive. This is delivery without any physical delivery. Is it clear to all of you? Yes? One topic is not here, so but I want to discuss that. Destruction of subject matter. Guys, I'm having like what happens if the goods are destroyed before the agreement is made? And what happens if the goods are destroyed after the agreement is made? बताओ क्या होगा? What happens if the goods are destroyed before the agreement is made or after the agreement is made? Before agreement is made, the goods are destroyed. क्या होगा? Is void ab initio. Correct or not? Can I say this is bilateral mistake? Yes, yes, existence of goods. After the agreement, the goods are destroyed. After the agreement, the goods are destroyed. Here, the goods may be specific or unasserted. If the goods are specific, it's void. Void ab initio or void contract. Because it's becoming void afterwards. Supervening impossibility. Unascertain goods, the contract is valid. Because I've not identified the goods, you can provide me any goods of the same description. Contract is what? Valid. With this, we are done with this unit. Differences I'm not doing. I hope this is clear to all of you. Any doubts you have in this? No? किसी का कोई doubts है? नहीं? तो I want you इसका answer लिखो चलो. Write this answer. So Ram Vilas Yadav is a farmer. Anna Chips Company approached him and entered into a contract to supply 100 quintals of potatoes, which is to be grown in the fields belonging to Ram Vilas Yadav at 1,000 per quintal. Anna Chips Company made which is to be grown. That means what? Future goods. But delivery, Anna Chips made the payment of the price, but delivery was to be made after 6 months. Before the time of delivery, the whole crop of potatoes was destroyed due to flood. Anna Chips Company demanded payment of price which is already made by it. Ram Vilas Yadav denied returning the price. Okay, my question is he supposed to return the price or not required to return the price? How many of you say he must return the price? Must return. How many of you say need not return? Is the ownership transferred? Is the ownership transferred to Anna Chips Company? No, future goods. Unless the goods are what? The ownership is not transferred. Correct? So, as per the provisions of sale of. Okay, can I write SOGA instead of Sale of Goods Act? No. Right? Sale of Goods Act पूरा. ठीक है? 1930. An agreement to sell is a contract of sale whereby the ownership is transferred on a क्या? Future date after the fulfillment of certain conditions. So, in an agreement to sell, the ownership is transferred after the condition is fulfilled or the time क्या lapses, right? So, is this my complete provision, by the way? Tell me, is this my complete provision? No, because I have to write about future goods. Future goods are defined as goods which are क्या? Not in the possession of the seller but will be procured or produced or manufactured by him after the contract is kya made, right? Is it clear to everyone? Yes. In case of future goods, the ownership is transferred only when the goods are ready. Right? Just add that one line. In case of what? Future goods, the ownership is transferred only when the goods are ready or the conditions are fulfilled. Anyway, where this was written. Can we move forward? So what will be the conclusion? Therefore, Anna Chips Company can kya? Recover the money from Ram Vilas Yadav. Clear? Okay. So this was I know we have written this question, but this was a September 24 question and it has multiple provisions also. I want you to write this answer. Okay, let's go to the question. Sony, a friend of Priya, wanted to buy her two-wheeler. Priya agreed to sell her two-wheeler to Sony and it was decided that the price of her two-wheeler will be fixed by Priya's father, who is an auto dealer. Priya immediately handed over the keys to Sony. However, Priya's father refused to fix the price as he did not want Priya to sell her vehicle. Priya expressed her inability to sell. Can Priya take back the vehicle? When the price is to be fixed by a third party and the third party refuses to fix the price, the contract is what? Void. But if the goods have been delivered, the contract is valid and we have to pay a reasonable price. So can Priya demand the vehicle back? No. Will your answer be different if Priya had not handed over the vehicle to? Yes, then she is not liable to sell. So here you will write two things. In a contract of sale, price may be fixed in any of the following ways. Okay? All the three. First by agreement, then by mutual dealings, and the last one is what? By third party. The next line, when in a contract, price is to be fixed by a third party and such third party refuses to fix the price of the goods, the contract is void. However, if the parties have if the goods have been delivered and the third party refuses to fix the price, the contract is valid and the buyer must pay a reasonable price. Next line, in case, as per the act also states, or symbolic delivery means where the goods are not physically delivered to the buyer, but the buyer is given the means of obtaining the possession of the goods. For example, the keys or the document of title. This is my provision. Clear to everyone? Yes. How will you write the conclusion? Therefore, Priya cannot take back the vehicle from Sony because when the goods are delivered and the third party refuses to fix the price, the contract is valid. Next line, if Priya had not handed over the vehicle to Sony, the contract is void because the third party has refused to fix the price of the goods. Are you clear with it? Yes. अब चले हम लोग इसमें? Yes. Next. Okay. Conditions and warranties. What are conditions? Conditions are stipulations which are essential for the main purpose of the contract and a breach of which. So they are what? Excuse me. They are what? Essential to the main purpose, right? That means they are the basis of the contract, the foundation of the contract. They are the essential to the main contract. And if there is a breach of condition, what will happen? Can you cancel the contract? Yes. Can you claim the damages? Yes. Is it clear to all of you? Yes. Now, there are conditions and warranties may be express or implied. Express is what we agree. Now, what we agree, obviously, we are not going to discuss. What is implied? Implied is by law. Implied is what? By law. That is, law says when the seller sells the goods to the buyer, these conditions and warranties have to be fulfilled. And if it is not fulfilled, can the buyer cancel the contract and claim the price or damages as the case may be? Yes. The first one is what? Title. What is title? Ownership. When the seller is selling the goods, do you ask him, do you have a right to sell, or you assume that he has a right to sell? You assume. Or if he agrees to sell on a future date, you assume that on that future date he will have the rights to sell. If the seller has no rights to sell, will the buyer get the ownership of the goods? No. Can the true owner claim the goods back from the buyer? Yes. What will the buyer claim from the seller? What will the buyer claim from the seller? The price of the goods. Why only damages? Price I'll claim, right? But instead of claiming the price, if he claims only the damages, he should have claimed the price. Instead of claiming price, he claims damages. Then what will happen? He has treated a breach of condition as what? As breach of warranty. Which warranty is it? Undisturbed or quiet possession. Correct? What is sale by sample? What is sale by sample? I show you the sample of the goods. If you like, you can purchase. When the sale is made by sample, what are the conditions that have to be fulfilled? The bulk must correspond to the sample. The buyer must be given an opportunity to examine the goods, and the goods must not have any latent defect which makes them unmerchantable. What is sale by description? What is description? I describe the goods to you. What is sale by description? The bulk of the goods must correspond to the description. Ajay, when we say description, packing, place of growing, all this will be a description or not? Yes. Can it also be sale by sample and description? Yes. When the sale is made by sample as well as description, the bulk must correspond to the bulk must be described as it is known in the market, and the sample, and the bulk must correspond to the sample and description. So the sample must be described as it is known in the market, and the bulk of the goods must correspond to both sample and description. Then the next one is specific purpose of the buyer. When the buyer gives the seller the reason of his purchase, tells the seller the reason of his purchase, does he himself select the goods or he relies on the seller? Achha, in the exam, are we supposed to write he, slash, she all the time? No. You will only write what? He. Because general clauses act, you remember I told you that lady drives. No, you don't remember that. So this, you only have to write he. Okay? Now, does the buyer select the goods or he relies upon the seller's skill to select the goods? Relies upon the seller's skill, and seller deals in those goods. Then it is implied that the seller will only give the goods which suit the buyer's purpose. Otherwise, can the buyer return the goods back? Yes. Usage of trade. How can I forget the umbrella? Do I have to tell you, I want an umbrella which protects me from the rain? It's implied. If it does not suit the purpose, can I return the goods back? Yes. Merchantability. What is merchantability? Goods should be in a saleable or usable state. If the packing is defective, does it make the goods unmerchantable? Yes. But if you have personal ailment, does it make the goods unmerchantable? No. The last one, wholesomeness, it's an extension of merchantability, right? It is an extension of merchantability. That is, goods are in a consumable state. What is wholesomeness? The goods are in a consumable state. Is it clear to all of you? Hello, is it clear to everyone? Yes? Okay, the next one is implied warranties. What is the first one? Undisturbed possession. There was a breach of condition. You should have claimed the price. Instead of claiming the price, what you did? You claimed only the damages. X stole goods from Y, sold it to Z. Can Y claim the goods back from Z? Can Y claim the goods back from Z? Yes. What should Z do? He should claim the price. This is what? Condition as to title. Instead of claiming the price, he claimed the damages. He has treated a breach of condition as a breach of warranty. Freedom from encumbrances. Encumbrance means charge of a third party. When I sell goods to you on which a third party has a charge, and owing to this charge, I suffer loss. Can I claim the damages? Can I claim the damages? Yes. Dangerous nature. When the goods are of a dangerous nature, it should actually be mentioned on the packing. If it is not mentioned and the buyer suffers the damages, can the buyer claim the damages from the seller? Yes. And quality and fitness by usage of trade. This umbrella, I should have returned it back. But instead of returning, I claim the damages. I have treated a breach of condition as a breach of warranty. Is it clear to all of you? The next one, caveat emptor. What is caveat emptor? Let the buyer beware. So it is the buyer's duty to make the right selection of the goods. If he makes a wrong selection of the goods, can he hold the seller liable? No. लेकिन लॉ में क्या होता है? लोचा. So माखर में ना नेक्स्ट टाइम हम मिलेंगे तब आपसे मैं आपसे पैसे पेमेंट करवाऊंगी. But can I say all the implied conditions are lochas too? Okay. Caveat emptor says you cannot return the goods back. But in all the implied conditions, can I return the goods back? Yes. So all implied conditions are lochas to caveat emptor. Is it clear to everyone? Yes. समझ में आया सबको? So can we go forward? Yes. Transfer of property. When I say property, what do I mean by property? That means I'm talking about ownership. Now there are three stages in which transfer of property takes place. There are three stages in which transfer of property takes place. Property in the goods, possession of the goods, and passing of risk. Property in the goods, possession of the goods, and passing of risk. अभी property in the goods क्या होता है? Ownership. Possession means what? Physical. Now please, there are three stages in transfer of property, and just because I've written these three stages like this doesn't mean that this is the sequence. In fact, there is no order or sequence. In fact, any one can happen after the other or before the other. Property in the goods means what? Ownership of the goods. Possession of the goods means what? Physical goods. Passing of risk. Risk passes with ownership. Whether you have the goods, I have the goods, doesn't matter. Till I am the owner, I have the risk. Once I transfer the ownership to you, you are the person who will bear the risk. But whoever, as a bailee, are you supposed to take care of the goods or not? Yes. And if you don't take care of the goods, who will bear the loss? The bailee. I mean, if any party is at fault, the defaulting party shall bear the risk. When does ownership transfer? In the contract, they may specify when the ownership will transfer. And if they specify when the ownership will transfer, the ownership will transfer as per the specification. The ownership will transfer as per the specification. However, if nothing is given, then depending on the type of goods, ownership will be transferred. If nothing is given, then depending on the types of goods, ownership will be transferred. Right? If the goods are specific goods in a deliverable state, what is deliverable state? What is deliverable state? Buyer is bound to take the delivery. If the specific goods are in a deliverable state, when will the ownership transfer? Immediately. If they are not in a deliverable state, when will the ownership transfer? After they are brought to a deliverable state and the buyer is informed. If the seller has to conduct tests over the goods, now tell me, why would the seller conduct tests over the goods? To maybe find out the price, quantity, quality, identity, whatever. When will the ownership transfer? After the test. But if the buyer has to conduct the test, do we wait? No. The ownership is transferred immediately. But ma'am, he has a right to conduct the test. Yes. So he can say, I am ready to buy the goods, but I will test them. If he doesn't say, ownership is transferred immediately. Is it clear to everyone? Yes. In case of unascertained goods, when is the ownership transferred? After they are ascertained and appropriated. Ascertained means what? As per the description of the goods are taken out. Ascertained means what? As per the description of the goods are taken out. Who does this? Can I enter the seller's premises and do it, or is it only done by the seller? Only done by the seller. What is appropriation? Once the goods are taken out, we confirm with each other about the goods so that finally the goods can be delivered to the buyer. So selection of the goods with the consent of both for the performance of the contract. Is it clear? So I go to the shop, I say I want a Microsoft Surface metal body red color pen. What type of goods are these? No, unassertive description. So what will the seller do? He will immediately go to his total stock of pens and out of that take out the pen that I described. This is what? Ascertain. Now what he will do is he will come and say, ma'am, this is the pen you want. Yeah, this is the pen I want. This is what? Appropriate. समझ में आया सबको? Yes. If the contract is silent about who is appropriating, if the seller is delivering the goods, the seller has appropriated. If the buyer is taking the delivery, the buyer has appropriated. Sale on approval. I give you the goods. If you like, you can purchase. Otherwise, you can return the goods back. When does the ownership transfer? When the buyer gives his approval. Right? Or when the buyer does not give his approval, but he retains the goods. Retains the goods to what time? After the specified time, or if nothing is specified, reasonable time. Or he does any act which only an owner can do. If it is sale on approval on cash basis, देखो एक लाइन है ऐसे लगता है चिल्लर सा लाइन है क्या है इससे एक क्वेश्चन आ जाएगा. That is how they ask question in law. एक line से. Sale on approval on cash basis. When is the ownership transferred? Only when the cash is paid. समझ में आया? Yes. Yes. No one can give what he has not got. I pick your notebook, go and sell it off. Is it a valid sale? No. No. No one can give what he has not got. Nemo that quod non habet. लेकिन लॉ में क्या होता है? लोचा. एक और दो है इसका लिख लेना. लेकिन लॉ में क्या होता है? लोचा. So there are 8 cases where a non-owner can sell the goods. First, if it is sale by a merchant. Who is a mercantile agent, guys? Who is a mercantile? He's a middleman. Okay. Who is a mercantile agent? He's a middleman. What are his rights? He can buy the goods. He can sell the goods. He can consign the goods for sale, or he can even pledge the goods. If let us say mercantile agent is acting in the ordinary course, that means it's his business to be a mercantile agent. He gets the possession of the goods with the consent of the owner. With the owner's consent, he gets the goods and he goes and sells this off to a bona fide purchaser. Is the sale valid? He goes and sells it off to a bona fide purchaser. Is the sale valid? Yes. Yes. Instead of sale, if it was he pledges, is the pledge valid? Yes. Sale by one of the joint owners. What is joint owners? When a property is owned by more than one person. When the joint owner sells the goods, when one of the joint owner has the possession of the goods, that means, let's say three people own a property, one of them has it. How does this one guy have it? With the consent of the others. The others told him, you keep it. And he goes and sells it off to a bona fide purchaser. Is the sale valid? Yes. The sale is what? Valid. Sale by a person in possession under a voidable contract. I sold you the goods, but the contract between you and me is voidable. Before the contract is cancelled, you go and sell it to someone else. Will the new buyer get a good title to the goods? Yes. Sale by a person in possession under a voidable contract. When a person has the possession of the goods under a voidable contract and before the contract is cancelled, sells it to a bona fide purchaser. The sale is valid. The next one, sale by estoppel. The person who is selling the goods is not the owner. But the owner is looking at him and not stopping him also. Is the sale valid? Yes. Yes. Sale by a person in possession after sale. I sold you the goods, but I still have the goods. And I go and resell them to another person. I sold the goods to you, but I still have the possession and I resell them to another person. Is the sale valid? Yes. Yes. You gave me the goods. I don't have the ownership. I will get it on a future date and I go and sell it to someone else. Is the sale valid? Yes. Sale by a person in possession before sale. Can an unpaid seller sell the goods? Yes. Sale under other acts. So till point number 7, it was under the Sale of Goods Act. Now under the Indian Contract Act, can the pawnee sell the goods? Yes. Is the sale valid? Yes. Can the finder of the goods sell the goods? Yes. Is the sale valid? Yes. And if a person becomes insolvent, can the assignees or liquidators sell the goods? Yes. Is the sale valid? Yes. Now rules of delivery. What will be treated as delivery? Can we agree upon anything? Like if I say you leave the goods here, this is delivery. Can this be considered as delivery? Yes. Delivery is anything that the parties agree to. Right? If I have made a delivery of the part of the goods, the rest will follow. Can we say it is deemed that the whole of the goods have been delivered? Yes or no? Yes. If I have given you the goods and I am going to send the rest of the goods, it is deemed that the whole of the goods have been delivered. Is it the seller's duty to deliver or is it the buyer's duty to apply for the delivery? It is the buyer's duty to apply for the delivery of the goods. Correct? Now, if there is no contract about where the goods have to be delivered, I made the contract here, goods were on first floor. Here I should deliver or first floor? First floor. The goods shall be delivered, see what's given, at the place they were. That means what? I only have to keep the goods ready wherever they are. You will come and take the delivery. Can I say delivery must be made within a reasonable time? Yes. If the third party is holding the goods, delivery will take place only when the third party acknowledges that he is holding the goods on behalf of the buyer. That means what? Constructive delivery. I gave you the goods to deliver it to the buyer. Now you go and tell him, I am holding the goods on your behalf. The moment you say I'm holding the goods on your behalf, can I say for me delivery is already done? For example, Amazon. Okay, Amazon is delivering you the goods. Who is responsible for the delivery? Amazon. But the moment Blue Dart calls you and says your delivery is with us, your goods are with us. Now if you don't get the goods, you will sue Amazon or you will sue Blue Dart. Blue Dart is now responsible, right? Because Amazon ki taraf se delivery is done. The expenses of putting the goods in a deliverable state shall be borne by whom? Seller. But getting the goods to, but the charges of delivery who shall pay? Buyer. For example, आपने goods order किया on Amazon. They will pack the goods. Do they charge you for that? No. But delivery who will pay? You will pay. Ma'am, हमारा तो free delivery है. Because advance में you paid for the whole year by taking the subscription. Correct or not? Now, if the seller delivers less than the contracted price or more, let us say I asked for 600 kgs, he delivered 400. Can I reject 400? Yes. Can I accept 400? Yes. He sent 800. Can I reject 800? Full 800 can I reject, or should I keep 6 and reject 2? Nah, I can reject the whole 800. Why should I sit and do this? Why should I swim in your 800? Correct or not? है ना? Now tell me, can I reject the whole 800? Yes. Can I accept 600 and reject 200? Yes. Can I accept the whole 800? Yes. And if I accept the whole 800, I should pay for what? 800 at the contract rate. Okay? The next one, if the goods mixed with different description, can I reject and accept? Yes. But inferior and superior quality goods, is it different description, or should I just reject the goods? That is not considered. See, different description matlab kya? I asked for black color pens. Along with the black colors, you sent me blue color also. So this is what? Different description. But I asked you to send me blue color ka classmate ka pen. Along with that, you send that use and throw wala pen. So is it different description, or is it inferior and superior quality? Inferior and superior quality. Okay? Now, is buyer bound to accept installment delivery? No. If it is agreed, only then, otherwise not. Then delivery of the goods to the carrier is deemed to be a delivery of the goods to the buyer. Deterioration of the goods in transit. Even if the seller agrees, who shall bear the loss? Buyer. This loss shall be borne by whom? Buyer. If the buyer has never seen the goods before, so when the delivery of the goods are made to him, is he bound to just accept it, or can he examine them before he accepts it? You can examine them. Is it clear to all of you? Yes. With this unit is done. Write the answer to this question. It's a little tricky how to write. Mr. Samuel agreed to purchase 100 bales of cotton from Mr. Varun out of his large stock and sent his men to take delivery of the goods. They could pack only 60 bales. Later on, there was an accidental fire and the entire stock was destroyed, including 60 bales that were already packed. Referring to the provisions of the sale, explain as to who will bear the loss and to what extent. Can I say for the 60 bales, okay, the ownership has already passed to Samuel, right? So who will bear the loss? Samuel. But for the remaining 40, who will bear the loss? Varun. अब इधर ना what all am I supposed to write? Please listen carefully. There are two things here. Whenever you अभी जब आप practice करोगे writing answers, ठीक है? Before you start writing the answer, for every answer, I would suggest exam में मत करना. You're not supposed to scribble on the paper. But when you keep doing this, no, you will get into the habit of doing it. So whenever you start writing the answer, no, उसके पहले just write what provisions are applicable here. First, they are talking about what? Risk. Second, they are talking about what? So that means, can I say my answer should have provisions relating to these two? Yes or no? So whenever you keep writing this, no, like this, if you keep writing next to the question, this is what the provision relates to, you will see you are automatically able to write a better answer. Just do this for 15 days. Mark my word, on the 16th day, you will be able to write your answer like this. So how am I supposed to write? So as per the provisions of the Sale of Goods Act, unless otherwise agreed, the risk remains with the seller. But once the ownership is transferred to the kisko? Buyer. Once the ownership is transferred to the buyer, risk passes on to the buyer. So, even if the buyer does not get the physical goods, he bears the loss as soon as he gets the ownership. As soon as he gets the kya? Ownership. In case of unascertained goods, ownership is transferred when the goods are kya? Ascertained and appropriated. Ascertaining the goods takes place when goods identifying the description are what? Set apart. Right? Appropriation is, वैसे generally question रहेगा for how many marks? 4. But the provisions are so many. Sometimes it happens. Just 4 marks, but the provision is huge. Appropriation is selection of the goods with the consent of what? Both the parties for the performance of the contract. Appropriation is done by the seller with the kya? Consent of buyer or by the buyer with the consent of seller. अब ये ना अगर 4 marks का है तो एक आध line which is a little repetition of the thing you can cancel it. But rest को आपको you have to write. ठीक है? So this is my provision. Therefore, the loss shall be borne by Mr. Samuel for the 60 bales. As the goods have been ascertained and appropriated, the ownership has been transferred to him. For the rest of the 40 bales, since the goods were not ascertained and appropriated, Varun is the owner and he shall bear the loss. Is it clear to all of you? Hello. Can I move forward? Yes? Or you want to take a break now and continue after that? Huh? Break chahiye? Moving on to the next unit, that is the last unit of Sale of Goods Act. And this actually talks about what? Unpaid seller, right? So tell me, who exactly is an unpaid seller? Can I say who has not received, kya? Not received the whole price of the goods. So that means even a partly paid seller is an unpaid seller. Yes. So unless you have received the whole price, you're an unpaid seller. That means even if I have received the part of the money, can I still call myself as an unpaid seller? Yes. Unless I receive the whole price, I am an unpaid seller. Clear to everyone? Yes. Now, can I say, Acha, why has he not received the whole price of the goods? The buyer did not pay. What are the circumstances under which the buyer might not have paid? Sorry? There was no credit period. So when there is no credit period means you should pay immediately. You did not pay. Or let us say there was a credit period which has expired, but the buyer did not pay. Or payment was made by a negotiable instrument which has been dishonored. Or the buyer has become insolvent. In all these 4 cases, what happens? The seller becomes an unpaid seller. Now, can I say this seller will have rights? Yes. He has rights both against the goods and against the buyer. Please remember, rights against the goods are available when the goods have not reached the buyer. When is it available? When the goods have not reached the buyer. The concept is once the goods reach the buyer, the rights over the goods come to an end. And you know what? Once the goods reach the buyer, even if I get the goods again, I have no rights over the goods, right? Once the goods reach the buyer, the rights against the goods come to an end. Now, even if I get the goods back also, I have no rights over the goods at all. Now, what is the first right? Right of lien. What is the first right? Right of lien. Lien means what? Retain the possession. Lien means what? Retain the possession. I have sold the goods, but the goods are still with me, right? I have sold the goods, but the goods are still with me. And I have become unpaid. Why have I become unpaid? Any of the four reasons. Why have I become unpaid? Any of the four reasons. What are the four reasons? No credit period expired, buyer has become insolvent, or negotiable instrument dishonor. Instead of giving the goods to the buyer, can I retain them with me? Yes, this is lien. Instead of giving the goods to the buyer, I can just retain them with me. This is what? Lien. When does lien come to an end? When does lien come to an end? Now, when I say come to an end, what people think is I've exercised and comes to an end. No. Comes to an end means it cannot be exercised anymore. Please understand, when I say comes to an end, what people think is it's exercised and comes to an end. No. When I say comes to an end, what I'm trying to say is it cannot be exercised anymore. When? Why am I exercising lien? Because you have not paid. If you pay, can I exercise lien? Why am I exercising lien? Because you have not paid. If you pay, can I exercise lien? No. So, the first, when the buyer tenders the payment. Tenders means pays or offers to pay. Also, tell me one thing. When I have sent the goods, for lien, the goods have to be with me, right? If I have sent the goods to the carrier for delivery, if I have sent the goods to the carrier for delivery, now what? Can I exercise lien? Lien matlab kya? I have the goods and so I am keeping them with me. If I have sent the goods to the carrier, can I exercise lien? No, because the goods are not there with me anymore. So the second is what? When the goods are sent to the carrier, right? When the goods are sent to the carrier, or the buyer or his agent lawfully acquire the goods, they show court orders, get the goods, whatever, or by estoppel or waiver, right? He says to the buyer, whenever you ask the goods, I'll give it to you, I'll not stop. He says to the buyer, whenever you ask the goods, I'll give it to you, I'll not stop. By saying that, what has he done? He has made him believe that he will not exercise rights of what? Rights of lien. You should have done the 3 times. I'm going to record that. Just Sheldon thing there. Now tell me, I have parted with the goods, okay? I have given the goods to the carrier. But before the goods could be delivered to the buyer, I have become unpaid. Why have I become unpaid? Because the buyer has become insolvent. So this could be exercised in all the 4 cases. This can be exercised in what? All the 4 cases. This can be exercised only in the case of insolvency. Right? In the case of insolvency. So now tell me, can I stop the goods from being delivered to the buyer? Can I call the carrier and tell him, please keep the goods wherever they are, don't deliver it to the buyer? Yes. Can I tell him, please keep the goods wherever they are, don't deliver it to the buyer? Yes. This is known as what? This is known as what? Stoppage in transit. This is known as what? Stoppage in transit. When does stoppage in transit come to an end? When does stoppage in transit come to an end? When the goods reach the buyer. When the goods reach the buyer, stoppage comes to an end. Right to resell. Can the seller even resell the goods? Yes. Can the seller even resell the goods? Yes. But tell me, who does the goods belong to? But tell me, who does the goods belong to? Buyer. Because all these rights are available when the ownership is with whom? Buyer. But the goods have not yet reached the buyer. So tell me, who is the owner of the goods? Buyer. So if you're selling his goods, don't you think you should give him a notice that, look, I'm going to resell your goods? Yes. So when you give a notice and you resell, and on that resell there is a loss, whose fault is it? Buyer, because you did not pay. Who will bear this loss? Buyer. But if there is a profit, who will keep the profit? Seller. On the other hand, you don't give any notice. Whose fault? Seller's fault. So if there is a loss, who will bear? Seller. If there is a profit, he must give it to the buyer, because when he does not tell him I'm going to sell, he is just acting as an agent for the what? He is just acting as an agent for the buyer. Clear, all of you? If the goods are perishable, do I have to give any notice? If the goods are perishable, do I have to give any notice? No. जब तक notice देंगे, my goods will only reach somewhere else. Correct or not? Yes. Now, what are the rights against the buyer? Can we say first right to sue for the price of the goods? Correct or not? Yes. Second, sue for interest. Interest can be only if the agreement says, or in any case. Interest can be in only if the agreement says, or in any case. Any case, yes. It's an inherent right, irrespective of whether the agreement says or not. Then, can I sue for damages for non-acceptance of goods? Yes. If the seller delivers the goods to the buyer, proper time, proper place, buyer, as the buyer wanted, but still the buyer does not accept the goods, can I, in that case, even claim damages for non-acceptance? Yes. And the last one is right to sue for what? Breach of contract. If it is an actual breach, I can sue for both price and damages. If it is an anticipatory breach, only damages. Now, itna der se we are saying, acha, ek minute. Let's say I have sold the goods to you, but the goods are still with me. You resell the goods. Can you do that? Yes. In the meantime, I become unpaid. Can I exercise a lien over the goods? S sold his goods to B, but the goods are still with whom? S. B sold the goods to P, but the goods are still with whom? S. B becomes insolvent and S becomes the what? Unpaid seller. Goods are with him. Can he exercise a lien over the goods? Yes. Any subsale or pledge does not affect the rights of an unpaid seller. Doesn't matter, seller, buyer resells the goods or pledges the goods. I have the goods, I will exercise lien. But let us say B asks S, I am selling the goods, and he says, yeah, go ahead, please sell. Then can he stop the goods? No. Or if the buyer has the document of title which he transfers to the new buyer, then can he stop the goods? No. Is it clear to all of you? Hello, 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 yes. Rights. Now, what are the rights of the buyer? That is, if the seller breaches, what are the rights of the buyer? First of all, the buyer is ready to take the delivery of the goods, but the seller is not giving the goods. Can he sue for damages for non-delivery of goods? Yes, yes. If the seller wrongfully refuses or neglects to deliver the goods, the buyer can sue for damages for non-delivery. If the goods have no substitute, Will you sue for damages or will you sue to perform the contract? This is what? Specific performance. Specific performance is only if the goods have what? No substitute, or damages are not an adequate relief. Damages are not an adequate relief. Correct? Sue for damages. If there is a breach of warranty, or if there is a breach of condition which is treated as a breach of warranty, what can I sue for? What can I sue for? I can sue for damages. If there is a breach of condition, what can I sue for? Price. I have paid the advance money, but you don't deliver the goods to me. What can I sue for? I have given you the advance money, but you don't give me the goods. What can I sue for? Refund of advance money. That is price. Clear to everyone? Yes. The last topic of Sale of Goods Act, auction sale. It is an invitation to offer. The sale is complete on the fall of the hammer. If the goods are put up in lots, lots means two or more goods put up together in a single lot. Every lot is a separate contract. Can the bidder retract his bid before the fall of the hammer? Can the seller or his agent bid at the auction? Yes, if they reserve the rights to bid. If they bid without reserving the rights, what will happen? If they bid without reserving the rights, what will happen? The sale is voidable. Why? Because this is considered as fraud. The sale is what? Voidable. Then tell me, if the seller appoints more than one bidder, that is pretended bidding, why would he do that? Just to raise the price of the goods. What will, can we say this is also fraud? Yes. The sale is what? Voidable. We are done with Sale of Goods Act. Now, so I want you to tell me which provisions would you write for this. It's given AB sold 500. What's the difference between lien and stoppage? Okay, lien is retain the possession, whereas stoppage is what? Regain. I've parted with the goods, I want the goods again. Next. Lien can be exercised in all the four cases, whereas stoppage only in insolvency. In lien, the goods have to be with the buyer, whereas in stoppage, the goods are in transit. And can I say the end of lien is the stoppage, the starting of stoppage in transit? Yes. AB sold 500 bags of wheat to CD. Each bag contains 50 kilograms of wheat. AB sent 450 bags by road transport, and CD himself took remaining 50 bags. This CD himself took remaining 50 bags. Can you exercise a stoppage over these goods? No. Before CD receives the delivery of the 450 bags sent by the he becomes bankrupt. AB's being still unpaid stops the bag in transit. Official receiver on CD's insolvency claims the bag. Decide with reference to the provisions of the Sale of Goods Act. What will be the answer? Can he exercise? Yes, as per section whatever 1930, as per the provisions of Sale of Goods Act 1930, when the seller has parted with the goods, but before the goods reaches the buyer, becomes what? Unpaid. Why? Due to the insolvency of the buyer. He can stop the goods from being delivered. The right can be exercised by either stopping the goods wherever they are, stopping the goods wherever they are, or by bringing them back to the क्या seller, right? Stoppage can be exercised if the following conditions are fulfilled. वैसे it's just a summation of ऊपर का. Depending on the marks, अगर let's say 5 marks का है तो extra लिख देना. Let's say 2-3 marks का है, this much is enough. ठीक है? Stoppage can be exercised if the following conditions are fulfilled. If the this is also gone. If the following conditions are what? Fulfilled. What are those conditions? First, the goods are in transit. Second, seller has become kya? Insolvent. Oh, I'm so sorry. Buyer has become insolvent. The seller is an what? Unpaid seller. The goods have not yet reached the buyer. So can I say therefore the what is his name? AB can exercise a right of stoppage in transit on the 450 kgs of goods. However, 50 kgs, since the goods were already taken by CD, he cannot exercise any rights. Okay, clear to everyone? Yes. So we are done with Sale of Goods Act. Let's move to the Negotiable Instruments Act. Okay. Okay. So Negotiable Instruments Act 1881. What does 1881 suggest? You all know what does that suggest, right? Is the year of what? Incorporation. Sorry, the year of the act coming into force. What is negotiable instrument? Negotiable instrument means, देखो means बोला है. That means if any other document also has the same feature, would it still be considered as a negotiable instrument? No. अच्छा, for those who have a doubt in this chapter या नहीं follow कर पा रहे हो या because this marathons are like the the fast marathons. Because of the time constraint, we are not doing the slow marathons. So इस chapter का भी there is a revision video which has been put up, which is a little detailed and which will like kind of 2 videos, I think 2 hours, 2.5 hours, and the entire negotiable instruments is done. In fact, if you sit with your book and watch that video and do it, pura chapter is done. You're just left to learn it after that bus. So negotiable instruments means what? So first of all, they've used the word means. That means if any other document. So I'll do one thing. I'll share the links today in the group again. Okay, not So I come back again. Huh? So means use kiya. That means if any other document also has the same feature, it will not be considered as a negotiable instrument. So means a promissory note, a bill of exchange, or a check payable to or to the order of or to the bearer of the instrument. So what are the characteristics of the instrument? It should be in writing. It should be signed. Freely transferable. एक minute. The word freely here doesn't mean without money. Freely means without any restrictions. The holder's title is free from defects. Holder's title, if he is a holder in due course, the holder's title is free from all defects. What do I mean by holder in due course? What do I mean by holder in due course? A person is said to be a holder in due course if 3 conditions are fulfilled. He gets the instrument before maturity. He gets the instrument in good faith. And he gets the instrument for consideration. If these 3 conditions are fulfilled, you are a holder in due course. Then the sum payable, the time, the amount, the place, the parties, everything should be what? Certain. and the instrument should be delivered. Please understand, delivery is not only at the time of endorsement or negotiation, that is negotiation by delivery. Delivery should be done even at the time of drawing the instrument. Please, I remember, I repeat again, delivery is not only at the time of kya, endorsement. Delivery must be also at the time of drawing the instrument. And please remember, delivery must be of the whole instrument. Must be of the whole instrument and not a part of it. So in ICI book, there was a very sweet sa question on this. Okay? I mean, it was not, I mean, sweet sa question is a wrong word to say. Quite an interesting one. Like when you see these questions, you're like, why? Why you did this? Hmm. Can you see question number 10? Yes? I'm sorry guys, I cannot scroll it up. It's zyada. You just read and tell me the answer. The question is not who will get it. It is like why. Kattap वो क्या था कट्टप्पा ने something like मतलब why. Even I could never understand कि भाई किस लिए मतलब किस लिए किया ये. M owes money to N. Therefore, he makes a promissory note for the amount in favor of N. For the safety of transmission, he cuts. Seriously? Safety of transmission. You make a document which is not right now. Hai in half and post one half, and he then changes out. Okay. He posts one half to N. My first question, is it a valid delivery? No. So if it is not a valid delivery, can N demand the rest of the piece? No. So who can actually demand? M. Later he changes his mind and calls upon N to return the half of the note which he had sent. N बोलता है कि तुम भेज दो. So who has a right to claim? M or N? M. Why? Because this note is itself not valid. Okay? So I hope this is clear to all of you. Payable to the bearer means what? To whoever is holding the instrument. To or to the order of means to a specified person or as per the order of the specified person. Okay, what is a promissory note? A promissory note is an instrument in writing. But if you remember, when we were doing the class, we saw the currency notes. And a currency note is not a promissory note. Containing an unconditional undertaking. Unconditional undertaking means what? Promise. Signed by the maker to pay a certain sum of money only to or to the order of a certain person or to the bearer. इसी से ही we get all the essential characteristics also of promissory note. Must be signed, must be in writing, must be signed by the maker, parties must be certain, amount must be certain, it must be money only. Bank note, it must be a promise to pay. Bank note or currency note is not a promissory note. However, as per RBI Act, only banks can issue, government can issue promissory note payable to what? Bearer. That is, no one can issue promissory note payable to bearer. Two party or three party? Two. Who are the two parties? Maker and pay. What is the bill of exchange? A bill of exchange is an instrument in writing containing an unconditional order. This is what? Order. This is what? Order. That was what? Promise. This is what? Order. Containing an unconditional order signed by the what? Maker. Signed by the maker, directing a certain person to pay a certain sum of money only to or to the order of or to the bearer of the instrument. Clear all of you? Yes. This is always made by the debtor. This is made by the creditor, which is accepted by the debtor. Correct? A check is a what? Check is a bill of exchange. वैसे ना ये वाला जो ये है chart, read this. It literally covers almost everything. मतलब after you've read the chapter, read this. It covers everything. So I repeat again, what is a check? A check is a bill of exchange drawn on a specified banker and not expressed to be payable otherwise than on demand, and includes a truncated check or a check in an electronic form. Because it's a bill of exchange, can we say this is also three-party? Yes. Who? Drawer, drawee. Drawee is always a banker and pay. Obviously, check and bill of exchange both are, check is also a bill of exchange, so both are similar. But what are the two differences? What are the two characteristics which are not there in a bill of exchange? Abhi, when I say now like this, people start writing the differences. No, I am only asking you to tell me the two separate features of check. First, it is always drawn on a kya? Specified banker. Always drawn on a specified banker. Second, it is always payable on demand. Clear? Hello? Clear? Yes? So these are the characteristics. We already done it there, so not going into this again. So what are the types of instruments that we have? So what are the types of instruments that we have? सबसे पहला bearer. Bearer means what? No name is given. Bearer means what? No name. That is the name of the payee is what? Blank. Okay? Where the last endorsement is in blank. That means I have originally drawn it as a bearer instrument, or I have made a blank endorsement on it. So it is either originally drawn as a bearer instrument, or the endorsement on it is a blank endorsement. In these two cases, it becomes bearer. Blank endorsement, kya hota hai? Do you know? We already studied it, by the way. Okay, isko now we'll come back later. Let's go first to the endorsement part. Okay? What is negotiation? What is the purpose of negotiation? To make the transferee the holder of the instrument. What is the purpose of negotiation? To make the transferee the holder of the instrument, right? It can be done by delivery or by endorsement. Delivery means I just hand over the instrument to you. No name, nothing. If the instrument is payable to bearer, no name is written. Can I just give it to you and you become the owner, right? No name is written. It's just written pay rupees 10,000 on this day. It's what? Bearer. I hand it over to you. Can I say you become the owner? Yes. You hand it over to them. Can I say they become the owner? Yes. So if the instrument is a bearer instrument, do I need to write someone's name, or I can just hand over and make them the owner? Just hand over and make them the owner. We call it as what? Negotiation by delivery. What is negotiation by endorsement? Let us say it is written pay C rupees 10,000 on this date. Unless C signs it, can this instrument be transferred? No. Unless C signs, can this instrument be transferred? No. So when C signs on this instrument, we call it as what? Endorsement. When C signs the instrument, we call it as what? Endorsement. So what is endorsement? To write something on the instrument. That means C can write his name, and over this he can write pay, D or order. What he can do is he can write pay, D or order and put his signature. This is what? Endorsement. Just endorsing the instrument is enough, or it should be completed by delivery. It should be completed by delivery. Unless the instrument is delivered, the instrument is not, the endorsement is not valid. Is it clear? इस पे questions आ सकता है. On this delivery part, you can actually get questions. Now, there are two ways he can actually endorse. One is he can just write his name. He can just give his signature, but not write anyone's name. This is known as what? Blank endorsement. What is blank endorsement? Sign of endorser is there? Yes. Name of endorsee is there? No. Achha, let's say C gives his signature and hands over the document to D. Now D wants to give it to E. Can D just hand it over to E, or should he sign it? He can just hand it over to E. That means, can I say the instrument has become a bearer instrument? The instrument has become what? Bearer instrument. Is it clear to everyone? What is full endorsement? C gives his signature, and over his signature he writes pay, D or order. So now if D wants to endorse it to E, can he just give it to E, or should he sign it? He has to sign it. Why? Because D's name is there. He has to sign it. So this is known as what? Order instrument. This is known as what? Order instrument. Is it clear to everyone? Yes? What is full endorsement? Sign of endorsee is there? Yes or no? Yes. Name of endorser is there? Yes. Yes. Now, coming back to our bearer instrument. You can either make it as a bearer instrument, or the last endorsement is in black. When the endorsement is in black, it becomes again what? A bearer instrument. Are you clear with this? Yes? What is an order instrument? See, here is given such instrument can be negotiated by mere delivery. That means what? They are saying negotiation by delivery. Okay? What is order instrument? Can I say the name of the person is given? Yes? What is order instrument? It is payable to a specified person, or it is payable to the order of the specified person. Right? Pay C or order. So it's either payable to C, or it's payable as per C's order. Now this instrument, if I endorse it, how can I do it? Can I just hand it over, or endorsement is mandatory? Endorsement is mandatory. So such instrument can be negotiated by endorsement and delivery. Okay? What is inland instrument? It has to be drawn in India. It has to be drawn in India, and either it is made payable in India, or it is drawn on a kya? Person resident in India. Clear to all of you? Yes. What is a foreign instrument? Which is not an inland instrument. That means it's drawn outside India. Or it is drawn in India, but it is drawn payable outside India, drawn on a person resident outside India. What is inchoate instrument? It's a blank instrument. Where the signature is there? Yes. Signature of the drawer is there or not? Yes. Blank check hota hai na? You fill the amount. This is inchoate. Abhi you don't even sign the check and you give. So kya fayda hai? I cannot even encash it. So sign is there or not? Yes. But other information is what? Missing. Missing in whole or part? Missing in part or whole? Anything. It could be missing in part or missing in whole. अच्छा बताओ. Compare it with a blank check. You are given a blank check. Okay? Someone gave you blank check. Is it valid? You just take this check like this and present it. Is it valid? No. But if you fill the amount, is it valid? Yes. He gave it to you. He gave a blank check to you and he told you fill it up for 20,000. You filled it up. The maximum value of the instrument was, let's say, 50,000. He tells you fill it up for 20,000. You fill it up for 50,000. How much can you recover? How much can you recover? I gave you a blank check and I told you please fill it up for 20,000. The maximum value of the वैसे check में value नहीं होता वैसे, but let's say the maximum value of the instrument is 50,000. What is the maximum value of the instrument? That is, this is the maximum value for which the instrument can be drawn. It's 50,000. I gave it to you for how much? 20,000. You fill it up for 50,000. How much can you recover? 50 or 20? 20. Because I gave you authority only for how much? 20. So see, the holder of such instrument cannot recover any amount in excess of the amount intended to be paid by the signer. How much I intended to pay you? 20. You filled it up for 50. Can you recover 50? No. Now you gave it to a holder. You had taken a loan from someone for 50,000. You gave this check to him and told him fill it up for 50,000. How much can he recover? 50. The holder in due course can recover any amount covered by the stamp. Is it clear to everyone? Yes? समझ में आया सबको? Yes? So this is again, this part is important when it comes to a case study. The case study के लिए this part could be a little important. Just seeing if there is any question, we'll just discuss it. I don't think there is. Okay, now tell me, what is an ambiguous instrument? Ambiguous means what? Not clear. Ambiguous means what? Not clear. So when an instrument looks like both promissory note and bill of exchange, it is what? Ambiguous. Is it a valid instrument? The holder can decide how he wants to treat the instrument. And whatever the holder decides, that is how we will treat the instrument. Clear to all of you? Yes? Acha, abhi na wapas coming back to this delivery part. Let us say A endorsed the check to B. He endorsed it to B, wrote his name, but did not deliver. Okay. In the meantime, A is what? Swaha. A is what? Swaha. His son saw the check and he delivered it. Is it valid? Is it valid? No? How many of you say yes? Chalo, raise your hands. Let's see. How many of you say no? Raise your hands. Why? Exactly. So always remember, any person can deliver the instrument on behalf of endorser only when authorized. So even if it is legal heirs or anyone for that matter, unless the authority is given, you cannot endorse it. Is it clear to every? I mean, you cannot deliver it, and it's not a valid delivery. समझ में आया यहाँ तक? Yes. हाँ. I'll just give you. Wait a minute. Huh? Dishonor of check. Now, this is one topic again that generally I've seen every time they will ask question from this. Most of the times I've seen them asking questions from this. So section 138 basically gives the punishment, but it's actually section 138 to 142. 138 actually just gives you the punishment. Now what they are saying is, if you have issued a check and this check is dishonored due to lack of funds in your account, see, if you just let it go, people will have no faith on the whole banking system. Issue kiya, it bounces, koi kuch nahi. So to stop that, to create that faith, we have this whole section 138 which says that if after the issue of the check bounces due to dishonor, due to insufficiency of funds or no funds, it is a punishable offense. What is the punishment? Up to 2 years or twice the amount of the check or both, right? The liability shall, but before you can actually claim on this liability, there are a few things here. First, it should be for a discharge of a liability. It should be for a discharge of a liability. That means what? I have made the payment because I owe you money. I am supposed to pay you the money. Matlab, I give it as a donation. I give it as a gift. Can you actually sue me if it bounces? No. Now, it should be presented within the validity period. Actually, it is said that a check cannot circulate in the market for more than 3 months. If the check circulates in the market for more than 3 months, it becomes a stale check, right? Then, the moment the banker informs the holder that the check has been dishonored, within 30 days of getting this notice, he gives a notice to the drawer that, look, your check has been dishonored. You give a notice, what? Your check has been dishonored. Once you do that, once this happens, the drawer is given 15 days. In 15 days, if he pays fine, if he does not pay, then you will file a case against him. Clear to all of you? Yes? So this, as I told you, very favorite question. Either say her term, you will find a question. ये वाला बताओ. Sorry, it's maintainable. Priyansh purchased some goods from Sumit. He issued a check to Sumit for the sale price of on 14 June. Sumit presented the check to his bank and the bank informed on 19 June that the check was returned unpaid due to insufficiency of funds in the account. Sumit sued against, okay. Sabse pehla, we cannot just say that the suit is maintainable. When he received the notice on 19th June that the check has been dishonored, within 30 days he should send a notice to Priyansh that his check has been dishonored. So I think 19 June se 30 days count karo. You don't count 19. What is it? 20, 21, 22, 23. How much does it come to? 30 days कब तक होगा? Chalo, theek hai, whatever. And once this notice is given within 15 days, Priyansh must pay. If he fails to pay, then he can file a case and then the suit will be maintainable. Is it clear to everyone? Yes. So it will be 18 July 2023. By then, if he gives the notice and within the next 15 days, if the person doesn't pay, then he can file a case. Okay? So please don't forget, because to file the case, that 15 days and 30 days is mandatory. अब इधर में let us say if after the issue of the check I stop payment, if after the issue of the check I stop payment, is that also punishable under section 138? Now stop payment is something which is allowed by law. So if it is allowed by law, how can you punish me? But if you allow me, I will issue check, then go to the bank and say please don't pay. And I will save myself from bouncing off check. Correct or not? So to prevent this, the lawmakers said, look at the reason for stop payment. Is it due to insufficiency of funds? That means you have issued the check, but you don't have money in your account and so you stop payment. Isn't it indirectly 138 only? Correct? If I allow you to do this, every time you will issue a check, go to your bank and say don't pay on this check. Correct or not? So you are trying to avoid section 138. So then they said, look at the reason. If it is insufficiency of funds or is it other reasons? If it is other reasons, no problem. But if the check has been stopped due to insufficiency of funds, you will again be liable under section 138. इस पे भी क्वेश्चन काफी बार they have asked. Is it clear to everyone? Yes. पक्का समझ में आया सबको? Yes. Now, wanted to write this, ठीक है? Bholenath drew a check in favor of Surinder after having issued Bholenath drew a check in favor of Surinder. After having issued the check, Bholenath requested Surinder not to present the check for payment and gave a what? Stop payment. Request to the bank in respect of the check issued to Surinder. Decide. What will you write in this answer? You will first write about section 138 ka provision. That if after the issue of the check is dishonored, then the drawer shall be punishable with twice the amount of the check or up to 2 years or both. Imprisonment up to 2 years or both. In case of stop payment, if the reason for the stop payment is insufficiency of funds, such stop payment shall attract the liability under section 138. ठीक है? लिखा नहीं है मैंने, चलेगा? और should I just write it down? चलेगा? पक्का? ठीक है. पक्का no? Okay. Presentment. Now, I want you to understand a little bit about presentment. Why and when do you present? 3 times you need to present. अच्छा एक बात बताओ. Let's say today is the maturity of the check. Okay. Okay. So basically, presentment can happen. Achha, let's say maturity is today. I have given you a promissory note or I have given you a bill of exchange. Today is the maturity date. So that means you are supposed to give me the money today. Yes. My question is, do you come and give me the money? Or do I have to come and ask you for the money? You have to pay me on a negotiable instrument. Today is the maturity, right? So on maturity, will you automatically yourself come and pay me the money, or I have to go to you to ask for the money? I have to go to the court to ask you for the money, or what? What? क्या होगा बोलो? You will come and ma'am your money, or I will have to say please पैसे दे दो इस पे. Please पैसे दे दो. That means, can I say first case, presentment has to be made for what? Payment. Clear to all of you? Yes. Ab, can I endorse a bill of exchange without acceptance? Can I endorse a negotiable instrument can be payable what? After date or after sight, right? A negotiable instrument can be payable what? After date or after sight. After date का मतलब क्या? It is the maturity starts from the day the instrument was drawn. After sight मतलब मुझे देखना है उस इंस्ट्रूमेंट को. बिल ऑफ एक्सचेंज के केस में एक्सेप्ट आई हैव टू एक्सेप्ट इट एंड व्हेन आई एक्सेप्ट उस दिन से उसका मैच्योरिटी स्टार्ट होगा. ठीक है. आफ्टर डेट आफ्टर साइट क्या है अभी सुनना सबको ध्यान से. ठीक है. कैन आई एंडोर्स अ बिल ऑफ एक्सचेंज विदाउट एक्सेप्टिंग? एक्सेप्टेंस पता है ना बिल ऑफ एक्सचेंज का. द ड्रॉवर ड्रॉज इट गिव्स इट टू द ड्रॉई, ड्रॉई एक्सेप्ट्स इट. करेक्ट. कैन आई without acceptance on the bill of exchange can I endorse it? Yes. In fact, today is the maturity date. Today only I will go to the drawee. He will accept it now and give the payment now. But if the instrument is payable after sight, do I need to get it accepted or not? Yes. Because maturity will start from the day of acceptance. Who did not understand this, what I just explained? Are you sure, all of you? Yes. See, please understand, instrument may be payable after date, after sight. After date matlab from the day it is made. After sight for bill of exchange means from the date it is accepted. Abhi, if the bill of exchange is payable after date, acceptance is not needed. Without it, I can endorse. But if it is payable after sight, maturity will start only from acceptance. So there I have to get it accepted or not. Yes. So for acceptance, I need to make the presentment or not. Yes. So the second presentment is for a bill of exchange for acceptance. Clear to everyone? Yes. Can a promissory note be payable after sight? Yes. But the point is, promissory note में acceptance नहीं होता है. The thing is that promissory note में acceptance नहीं होता है. So what is after sight? I draw a promissory note on you. I give it to you. Now you give it to me. I see it and return it back. So when I see it, that is after sight. So the third type of presentment is for sight in case of what? Promissory note. Is it clear to everyone? तो देखो यहाँ पे you will see all of this. Presentment for क्या? Acceptance. Presentment of promissory note for क्या? Sight. Presentment of promissory note for sight. And can you see the third one? प्रेजेंटमेंट फॉर पेमेंट. समझ में आया सबको? यस. यस. नाउ प्रेजेंटमेंट, अब ये चिल्लर चिल्लर है, वेरी इजी कॉमन सेंस. प्रेजेंटमेंट शैल बी, इट मस्ट बी प्रेजेंटेड विद इन अ रीजनेबल टाइम. ठीक है. इन बिजनेस आवर्स एंड ऑन बिजनेस डेज. ठीक है. Always remember, acceptance is given for, how much time is given for acceptance? 48 hours. And you know what? If within 48 hours I don't accept, it is dishonor by non-acceptance. But you give me now, ma'am, accept it now. I'm like, give me, no, ma'am, accept it now. Am I liable to accept it now? 48 hours तो मिलना चाहिए, right? Excluding public holidays. एक्सक्लूडिंग पब्लिक हॉलीडेज. इसका एक बहुत इंटरेस्टिंग सा क्वेश्चन था. हर चीज में कैन यू अंडरस्टैंड, फॉर एवरीथिंग देयर इज अ क्वेश्चन. फॉर तो इसीलिए मैं आपको हमेशा बोलती हूँ ना कि एवरी लाइन इज इम्पोर्टेंट. अरे बाबा वो क्वेश्चन कहाँ गया? आई जस्ट सॉ दैट क्वेश्चन. ना हाँ, नो आई वोंट बी एबल टू फाइंड इट लाइक विद सर्च. वही तो प्रॉब्लम है. हाँ, इसमें था वो क्वेश्चन. आई रिमेम्बर इट. मॉडल टेस्ट पेपर 2 में था. But I remember this question was there. This one. Is he justified in doing so? Is it dishonored due to non-acceptance? How much time is given? 48 hours. Tell me, is it dishonored due to non-acceptance? How many of you say yes? Yes? How many of you say no? Why? Acha. Utkarsh purchased some goods from Saksham on 14th August. Saksham draws a bill of exchange on Utkarsh and sent it to him for acceptance on the same day. At what time? 3 p.m. Same day. Matlab kya? 14th August 23 at 3 p.m. Utkarsh requested Saksham to allow him some time for acceptance. Saksham allowed him 48 hours. Generally 48 hours are given for acceptance. Okay? Utkarsh could not accept till 16th August and he says dishonor by non-acceptance. Bro, 15th August is a public holiday. Right? Yeah, पता ही नहीं था it's national holiday है. So can we actually count that? No. Can we actually count that? No. तो क्या आएगा? Date is last date should be what? 17th August 3 p.m. Clear or not? समझ में आया? देखो, you people are giving right answers. मतलब conceptual clarity है. Most of the answers were right. अभी only one problem is left in our life. And that is only going to kill you. It is either a do or die situation now. If you are scared of writing, you don't know how to write, you don't know where to start, how to start, but as per the provisions, uske aage you don't know. Keep your book open. For the first 2-3 answers, keep your book open. 4 answers, see and write. Then dhire dhire from the 5th answer, stop looking into the book. 4 answers, 5 answers, write it from the book. You'll get that hang, the confidence. Uske baad mein start writing it without looking into the book. ठीक है? हाँ? तो वो तो प्रोविजन भी अगर इंडियन कॉन्ट्रैक्ट एक्ट है वो उस पर लिखेगी तो उसके पहले व्हाटएवर चैप्टर शी हैड डन ना उसका प्रोविजन आ जाएगा. बट हाँ, इफ शी हैज डन इंडियन कॉन्ट्रैक्ट देन गोस टू सेल ऑफ गुड्स नहीं होगा, इंडियन कॉन्ट्रैक्ट एक्ट होगा. फिर पार्टनरशिप में जाएगी तो उसमें लिखेगी सेल ऑफ गुड्स एक्ट. हाँ, शी इज वन sales of good acts. Okay, now acha, if default is made in presentment, will anyone be held liable? No. You are supposed to present but you make a default in presentment. Hello, wait. You are supposed to present but you make a default in the presentment. Am I liable? No. You are supposed to present it to me, you defaulted in presentment. Am I liable? No. If drawee is not found after due search, the bill of exchange is dishonored. If I'm presenting him for acceptance and he is not found after search, it is dishonor by non-acceptance. यहाँ पे acceptance के लिए है वही, but same thing for payment also, that we will do in payment. Clear? Promissory note is presented for sight. Acha, if any place is given, particular place is given, where should you present it? At that place only. Abhi suppose karo, oh, this is our office, but you know there is one cafe, coffee shop opened up right in this lane. You say no, present it there only. So where should I present it? There only. Now, did you understand why promissory note has to be presented for sight? Yes. Now, promissory note payable at a certain period after sight must be presented within a reasonable time during the business hours on a business day. Clear to everyone? Yes. If there is a default, no party shall be liable. Okay? If there is a default, no party shall be liable. Now, presentment for payment to whom? Maker, if it's a promissory note. drawee, that is acceptor in case of a bill of exchange, and drawee, which is a banker in case of check. When should you present? Obviously during the business hours. It should be presented for payment at maturity. At maturity का मतलब क्या? On the day of maturity, not before, not after. Got my point? If it is payable in installments, acha, you remember you get 3 days ka grace, correct or not? Yes. So every installment, let's say I will pay you every month on the 15th. So every month on the 18th, you should present it. If it is payable in the, ये ना, I'm telling you honestly, book से पढ़ने से ज़्यादा इससे पढ़ लेना is easier. Because book में क्या same thing is written but line. अब इतने lines देख के तो ना मैं ईशान अवस्थी बन जाता हूँ. Right? Words start flying. Toing, toing, toing happens, right? So read it from here. Must be presented on the 3rd day after the date fixed for each installment. Instrument is payable at a specified place. Must be presented for payment at that place. Where no exclusive place is specified, then in that case where? Place of business or place of residence. When there is no place of business, no place of residence, bhai tu jahan mil jaye. Wherever I find you, on the road, ma'am, I find him. Stop him, bhai, to accept kar, payment kar. Okay? Instrument payable on demand. When it is payable on demand, it should be presented within a reasonable time. If default in presentment, will any party be liable? No. No. If promissory note is payable on demand and is not payable at a specified place, no presentment is necessary. Is pay case tha. If it is payable on demand, first is what? It is payable on demand. Second is that it is not payable at any specified place. Then no presentment is necessary. Right? Then no presentment is necessary. Is it clear to everyone? Yes. Let us say the person, he was taking it for presentment. While taking it for presentment, something hit him. God knows what. Straight into hospital bed, coma. 2 months later. मैं कहाँ हूँ? मैं कौन हूँ? After 2 days, अयो मैं यहाँ हूँ. I know who I am. Can I be excused for that 2 months ka period? Yes. Clear to everyone? Yes. So I know you will be like killing me. She's killing it, ma'am is killing it. She's killing us also. But now, because I told you, इसके ऊपर question. Let me just search. अगर वो मुझे question मिल जाता, I'll just discuss that question. This to be already done. Okay. This. But once at least read from the notes everything, because answer to pura likhna hoga. This is for recap. It's helpful for recap. So the A purchased the watch from B. He issued a promissory note which was payable on demand, but no specific place was given. On maturity, B did not present the promissory note. As the promissory note was not duly presented, whether A would be discharged from the liability. Is A discharged from the liability? Is A discharged from the liability? No. Why? Because when the promissory note is payable on demand and no specified place is given, no presentment is necessary. That means payment must be made without presentment. Payment must be made without presentment. That means I don't have to present, you have to pay it. When is presentment not necessary? When they prevent the presentment. That means I am trying to present, but you are taking every steps not to get the instrument presented. So my fault or your fault? Your fault, right? It is payable at a business place. And afternoon 2 o'clock, I come to your business place, locked. So what should I do? Am I liable now for not presenting? No, but it is closed. It is payable at a specified place. You tell me, ma'am, come to Starbucks. 5 hours I sit there having coffee, sipping coffee, but you still don't come. Huh? AK? Seriously. Anyway, listen carefully. But still, okay. हाँ वो भी हाँ एग्जैक्टली मैं इसलिए अपनी बॉटल लेके जाऊंगी So tell me, if it is not payable at a specified place and I tried to look for him, but I could not find him, am I liable for non-presentment? No. Or he is he said that I will pay whether you present or not. Whether you make the presentment or not, I am liable to pay, I will pay. He makes a part payment, now he is liable for the rest of the payment without presentment. In all of these cases, presentment is not necessary. Rules as to compensation, this again they ask a couple of times, they have, asked question on this. Let us say 30,000 ka instrument you issued. This instrument was dishonored. Ab just think logically. If I file a case against you, can I claim this 30,000? Yes. Because you know, dishonored, I went to the court, I had to spend some money, I got it notaried. Can I claim those expenses? Yes. Apart from that, don't you think I should get interest also? Yes. So, rules for compensation. And when is the interest payable? From the day the money was payable to the date the money is actually paid. So I issued the instrument here. It was supposed to be paid here, but finally you paid it here. So this period 18%. So what are the rules of compensation? First of all, the amount due. Second, the expenses incurred. Third, interest. And if it is in foreign currency, we will take the current rate of exchange. Okay? With this, we are done with negotiable instruments.